A very good morning to all. I, Dipali Man, I feel extremely privileged to welcome you all at Day 2 of UNCITRAL South Asia Conference, New Delhi. Yesterday, we had an enriching inaugural session where we were enlightened by the views of eminent speakers on the role of UNCITRAL in harmonizing international trade law and making India a hub for international arbitration. We had some eminent speakers, including Honorable CGI, D.Y. Chandrachud, Mr. Falias Nariman, Senior Advocate, Supreme Court of India, Ms. Anna Jobin Brett, Secretary of UNCITRAL, and many others. Today, we begin our Day 2 of the conference. We have a panel discussion on various themes, including digital economy, MSME, access to credit, ISDS reforms, regional perspective on UNCITRAL. Our first session for the day involves a panel discussion on digital economy. I now call upon stage Mr. Siddharth Malik to moderate our first session. I would also like to call upon stage Mr. Luca Castellani, Mr. Abhishek Singh, Dr. Chaichana Mitrpant, Ms. Shaila Yasmin, Ms. Laura Ho, Mr. Siddharth Malik is IFS 2010 batch, currently serving as the Director, Economic Diplomacy Division, Ministry of External Affairs, India. He has served in our various diplomatic missions, including New York and Beijing. He has also represented India at various sessions of UNCITRAL at both New York and Vienna. Over to you, sir.
Thank you, Dipali. Good morning, all. First of all, I would like to welcome all of you. Despite the bad weather, you have made it on time. I welcome all of you to the first session on digital economy as part of the 2023 UNCITRAL South Asia Conference. What I'll do is first, I'll just quickly introduce the panelists. First, we have Mr. Luca Castellani. He's a legal officer at UNCITRAL. He has overseen preparation of several model text laws of digital economy and has assisted several countries in enactment of UNCITRAL text related to e-commerce and paperless trade facilitations. On my right is Mr. Abhishek Singh. He is the Joint Secretary in Economic Diplomacy Division and also the host of the conference. Sir, prior to this assignment, he was our ambassador to Venezuela. He has served in various capacities in Berlin, New York, Beijing. On my left is Ms. Shaila Yasmin. She is Joint Secretary dealing with Free Trade Agreement in the Ministry of Commerce in Bangladesh. She is an Administrative Cadre Officer of Bangladesh and has served as Deputy Director in Bangladesh Energy Regulatory Commission and at the Department of Disaster Management. On my right is Dr. Chaichana Mitrpant. He is the Executive Director of the Electronic Transaction Development Agency, Ministry of Digital Economy of Thailand. He has devoted almost 2 decades towards raising Thailand's cybersecurity awareness and has also played an important role in drafting the National Cybersecurity Framework of Thailand. On his right is Ms. Laura Ho. She's Director of National Roadmap and Cross-Border Rules of Digital Trade at Malaysia Digital Economy Corporation. She also has over 2 decades of experience in policy, regulatory, and legal matters related to digital economy, cross-border trade facilitation, and digital trade. So what I plan to do today is that I will, as you're aware, this is a 60-minute session, followed by 15 minutes of Q&A. I will allow the speakers, each speaker, 2 interventions of 5 minutes each. This will be followed by a 15-minute Q&A. So friends, as you're aware that digital economy is part of our daily life. From buying groceries when you scan a QR code, to cross-border transactions, digital economy is part of our daily life. And we have very new areas also coming, for example, digital currency, which will help countries trade. This has led to efficiency in digital economy, but at the same time, it has led to issues of regulation of digital economy. So today, because we have the experts from South Asia and also an expert from UNCITRAL, we will have a discussion of the regulatory framework and how the regulatory framework has helped the economies in digitization of trade and leading to efficiency. So first, I will give the floor to Mr. Luca Castellani. He's a legal officer at UNCITRAL. So Mr. Luca, as you see, we have many students amongst us. And many of them probably are not aware of what UNCITRAL is. And one of the important focus of today's session is also to explain to them what UNCITRAL does. So if you could please help guide our students and other audience members on what UNCITRAL has done in general, and how UNCITRAL has helped in drafting model laws related to digital economy, and what probably areas you're working on in the future as well. The floor is yours.
Thank you. Thank you very much, and good morning, everyone. I'm very honored to be the first speaker of the first panel, and I would like, of course, to thank the co-organizers for this impeccable event. It's a real pleasure to be here. As was mentioned yesterday, we were here 7 years ago with a major conference, and it's a real pleasure to follow up on that. As you mentioned, United Nations Commission on International Trade Law, or UNCITRAL, is a body of the United Nations General Assembly, a commission, which was established in 1966, so now a bit more than 50 years old. And it is the core legal body in the United Nations. We say for international trade law, but let me allow to use language that is universal and that is understood by all. It is actually the core legal body for commercial law, because that's what it is. Many texts of UNCITRAL are not applied only internationally, but also domestically. That is particularly true for our area of digital trade. It does not deal with what now is called trade law in the WTO sense. It does not deal with regulation. It deals with enabling environment. That is to say, rights and obligations of the parties to a contract. That is to say, in the case of digital trade, removing obstacles to the use of electronic communications. That is to say, for instance, in the case of insolvency, coordinating insolvency proceedings across borders so that there will be more value for the creditors, but also more possibility that the business may continue, and that, for instance, employment will be safeguarded. It works as an intergovernmental organization. It has universal memberships. 70 states are actually members, and the others are observers, but because of the method of work, which is consensus-based, there is little difference in practice. All states may come. There are also intergovernmental organizations contributing significantly, and also some major non-governmental organizations, because we want to hear from the private sector. I really cannot go beyond these, or otherwise, you know, a lecture on UNCITRAL itself would take time, but maybe this will help also to frame the future panels, the future discussions, mindful that many of those discussions are about ongoing work, ongoing meetings at the intergovernmental level. So these are meetings where India and other countries come with official delegation to represent the views and the interests of the country. In the field of digital trade, we have done something a little bit different, because in many cases, and especially at the beginning, the mandate of UNCITRAL was about harmonizing existing laws. But in this field of digital trade, it was more about modernizing, that is to say, finding solutions to new problems. And this explains why there is a high level of uniformity in the legislation around the world. I have to stress, when the work was started in the 1990s, this was called electronic commerce. But now, especially the young generation, when talking about electronic commerce, will think about consumer protection and the like. UNCITRAL is absolutely not about that. It is about, especially business to business, electronic transactions. Typically, you would find our provisions in an Electronic Transactions Act, or also electronic signatures and the like it is the case of India. The most important UNCITRAL test in this field is the Model Law on Electronic Commerce from 1996, the most adopted. It has been updated in different parts, but it has been adopted in 90 states, so quite significant. India has adopted that model law and also the model law on electronic signatures. And these two texts are quite popular in South Asia. As this is a conference where many panels deal with arbitration, I have to mention that another text of UNCITRAL in this field, the United Nations Convention on the Use of Electronic Communications in International Contracts, was drafted also with a view to enabling the use of electronic communications also in at least most aspects of arbitral proceedings. And for that reason, you will find an explicit reference to the Convention on the Recognition and Enforcement of Foreign Arbitral Awards in that convention. And more recently, we have two model laws, the model law on electronic transfer records and the model law on the use and cross-border recognition of identity management and trust services. These were adopted respectively in 2017 and in 2022. And this way really set the foundation for digital trade as we understand it now. So we move from digitizing individual documents to having a holistic perspective on data flows. And for that reason now, Working Group 4 is working on matters that are closely related to the use of data. On the one hand, transactions in data, and on the other hand, contract automation, which includes artificial intelligence and smart contracts. And I would like to conclude, sorry if I was a bit longer, but your question was very broad, by inviting, of course, all states in South Asia to participate actively in our working group. Because I think that the discussions going on there, the next session is starts on 16 October in Vienna, were particularly important, especially for India, of course, because India has very many private sector big players in the field of the digital economy. Thank you.
Thank you, Mr. Luca. Thank you, Mr. Luca. I think in 5 minutes you have very clearly explained what UNCITRAL does. I think this will give a good introduction to our students who are here to understand what UNCITRAL as a body does. Now I will give the floor to Mr. Abhishek Singh, Joint Secretary, Economic Diplomacy Division, Ministry of External Affairs. Sir, India recently organized a very successful G20 summit. And one of the outcomes of that was inclusion of building of digital public infrastructure. Moreover, India has also been at the forefront of passing legislation to regulate digital economy. We just saw the parliament passing the data protection bill. And the work is also ongoing like in digital currency. So I would urge you to explain our audience, to explain the recent regulatory and policy measures that Government of India has taken in the regard of digital economy. Sir, floor is yours.
Honorable judges of the higher judiciary, Excellency ambassadors, Madam Anna Hoben-Brett, Secretary UNCITRAL, Ms. Meg Kenner, Secretary General of ICSID, fellow esteemed panelists, Mr. Moderator, and my colleague, Mr. Siddharth Malik, students coming from various law universities, a very warm greetings to all of you. But before I start my intervention, Mr. Moderator, I have to indulge you for a moment, because while you were explaining to me my role as to what I have to speak on, I got a message from one of the vendors, and he intimated that in the next 2 minutes he's going to reach at my place, and I have to, it's a payment on delivery. So I will have to open my phone, and I have to use my fingerprint because it's like a purse, and then I have to go to the payment app, that is Paytm, and then I have to click on the person who I have to deliver, because he will not give the stuff till the time I make the payment. And then my thing is linked to my bank account, and then I have to put the amount that I have to give him for the stuff that he has to deliver. And then I have to put the code, and the payment is done. So I can, rest at ease and concentrate on my speech. But in a way, it also, shows that digital economy is not only an esoteric concept that one can discuss in such, conferences like the one we are having today, but it's a practical thing. It's in fact a journey that transcends borders, reshapes industries, empowers individuals, and redefines the fabric of the society that we live in, work, and interact. Information and knowledge are the lifeblood that fuels the digital economy. The enormous volume of data generated daily is staggering and can be harnessed for economic advantages. For businesses, this means understanding market trends, consumer behavior, and operational efficiencies. Unlocking an economy's full potential hinges on digital and financial inclusion. You had referred to the financial inclusion part, Mr. Moderator. And this is very important to further pivots on trust and active participation of the citizens, the cornerstone of India's digital revolution. The digital public infrastructure, in essence, serves as the heartbeat of the digital economy, ensuring trust, security, and accessibility for all the participants. Henceforth, introducing the India Stack, where I will talk more about the India Stack in my second intervention. We have elements of identity rail, payment rail, and the data sharing rail convergence. Friends, excellencies, within the boundless digital space, the DPI, as it is popularly known, or digital public infrastructure, also faces an array of challenges, from cybersecurity threats and data privacy concerns to the specter of terrorism attacks, targeted advertising, and the rise of capitalist surveillance. Due to the borderless nature of digital environment, there is risk that breaches may disrupt the functioning of the whole ecosystem. Therefore, it is important for all the countries to share their approaches and good practices to build a safe, secure, and resilient digital economy. I think today's session and the various sessions that we are going to have in the next day and a half will add to this, what I call as a safe, secure, and resilient digital economy. While each nation crafts its own set of regulatory framework, there is a pressing need for a standardized global approach championed by UNCITRAL, a framework that harmonizes the individual's privacy rights and government's needs for requirement of data for legitimate purposes, and business interests of corporates would provide the solution to this complex landscape. Coming to the G20 presidency, which Mr. Moderator, you had mentioned, that India very successfully, we had the G20 summit recently. It was concluded, the G20 summit. And during our G20, India underlined the importance of digital economy and the need to strive to fully harness the opportunities offered by digital public infrastructure. Towards this, Mr. Moderator, under India's presidency, we have welcomed the G20 framework for systems of DPI, a voluntary framework for the development, deployment, and governance of DPI, affirming the importance of ensuring appropriate levels of privacy and data protection in accordance with the applicable legal frameworks. In the G20 New Delhi Declaration, we welcomed the non-binding G20 high-level principles to support businesses in building safety, security, resilience, and trust in the digital economy. India is also committed to halve the digital gender gap by 2030, Mr. Moderator, and promote gender-responsive policies to create an enabling, inclusive, and non-discriminatory digital economy for women-led and owned businesses, including MSMEs. Within the context of DPI, Mr. Moderator, we recognize the importance of promoting open source software, open application programming interfaces, APIs, to enable different DPI systems to communicate as a long-term goal. India reaffirms the importance of enabling cross-border data flow and data free flow with trust, which is well evident from the latest legislation, the Digital Personal Data Protection Act 2023. The courts in India, Mr. Moderator, are also pushing for digitalization, led by the Honorable Chief Justice of India, who was very generous with his time yesterday and guided us how we are doing that. The Honorable Chief Justice of India is leading the e-courts projects and has set the target of going paperless. The pandemic has taught us lessons and some takeaways that include virtual hearings, which is now widely used. We have the presence of several honorable judges of the higher judiciary, and I'm sure with your presence, sir, we are also encouraged, and it's a testimony of the importance that you give to sessions like this, sir. It is here that a forum like UNCITRAL can frame guidelines, madam, for virtual hearings. The role of UNCITRAL in framing such policies, guidelines, model laws assumes importance on account of major jurisdiction, adopting the said laws and incorporating these into their respective domestic legislations. In the specific context of India, in the digital domain, India's legislation on electronic signature and E-Commerce IT Act is influenced by the UNCITRAL model law on electronic signatures 2001 and UNCITRAL model law on electronic commerce. So I would conclude, Mr. Moderator, on this note, and I will dwell more on the initiatives undertaken in India pertaining to the digital economy in my second intervention. Thank you very much.
Thank you, sir. Thank you for enlightening the audience on the steps taken by India in the field of digital economy. I would now request Dr. Chaichana Mitrpant. Dr. Chaitanya, Thailand has adopted UNCITRAL model laws in 2001. I would like you to highlight Thailand's journey in adopting such regulations. Also, if you could explain to our audience how Thailand has aligned its policies to international best practices, especially in emerging areas like e-commerce and digital ID. The floor is yours.
Good morning, and thank you, UNCITRAL, senior officers, executives, RCAP teams, and also the local host for hosting this timely event. E-commerce has been very popular since year 2000. It's more than 20 years now, but Thailand faced difficulty since before 2000. If you remember, we started to use email in the late 1980s and using the internet in the 1990s. I still remember using Netscape. Do you still remember Netscape? Browsing the web. It's the first, I think it's the first web browser, which was popularized in the year maybe approximately 1991, 1992. We then sent information, share information among ourselves cross borders. And Thailand is one of the parties sharing information through the internet. And at that time, when the trade was already international, and the trade information was shared and sent through electronic means. But before 2001, electronic document, electronic signature was not recognized under Thai legal systems. So these information, these data messages were not admissible in Thai court of laws. So there were cases put up to the consideration of the judges, and the digital evidences were dismissed. Well, in some cases, it was for the benefits of the Thai traders, but of course, that would not attract foreign investors or foreign traders to conduct digital trade with Thai citizens, Thai businesses. And that time when we recognized that it was the time when Thai has to look into international practices and framework, into adopting legal principles related to electronic documents, electronic signatures. So we had been following the work of the Working Group 4 of UNCITRAL quite closely. And in the year 2001, we passed the Electronic Transactions Act in Thailand, which the principle was in line with the UN model laws on e-commerce and on electronic signature. It was since year 2001, when Thai people did not have wide access to the internet. But we recognized the importance of the harmonization of the law at that time. We had difficulties promoting the adoption of the law in Thailand because, Thai businesses, Thai government officials, they were not familiar of using email as an evidence in court, in their work, in their businesses. So we had to make our first amendment to the law, to our law, for the change of media. So electronic document can be converted to paper document when it was originated in electronic form. And likewise, paper media document can be converted according to the law into the electronic document. Then the organizations, the people in Thailand became more aware of the equivalence of electronic document and paper-based documents. And then we look at the UN Convention on the use of electronic communication in international contract. And we recognize that we also needed to adopt that principle as well. So we decided to amend our act again to accommodate the nature of automated contracts. And later on, we recognize that it is important when we promote the use of electronic transactions that we need to assure the security and trustworthiness of electronic transactions. And the issues around the e-commerce and digital trade at that time in Thailand was related to digital identity. So in year 2019, we started to look at the issue of digital identity in Thailand in order to make sure that we have secure electronic transactions ecosystem, and also to support the eKYC, Know Your Customers requirements for the anti-money laundering related law. And at that time, the UN doesn't have the model law on the digital identity yet. So we provide the legal recognition of digital identity in our law. Now, we are in the process of, again, adopting the model law on electronic transferable record in order to recognize a particular instrument in the trade, namely the transferable record. And also adopting some of the part of the digital identity management and trust services into our existing law in order to make sure that our law is in line with international principles and practice and framework. Because we believe that this is a gateway for international trade. When foreigners look into our legal system, and they can be comfortable because this is the environment they're operating in otherwise in different countries. We think this is a very important gateway to digital economy, to digital trade to the country. That's the legal framework. Once the trader come into the country, then they might have different restriction or constraint or regulation. That's another level of constraint on international trade, which is totally different from UN model laws, which has the nature of facilitating, harmonizing, less on regulation. So Thailand, now we have, we believe that we have an equal level playing field for digital trade, and we're trying to adopt different regulations on top to make sure that we have a secure environment for digital trade. For example, privacy protection, data sharing, competition law, consumer protections. Those are additional levels of regulation that we need to put on our legal system in order to make sure that the trade is fair and transparent, the local businesses are protected, the consumers are protected. So we would like to really encourage different countries to start adopting the principle of the model laws on digital trade, international trade, so that we can allow more seamless digital trade globally. Thank you.
Thank you, Dr. Chaichana, for sharing best practices of Thailand in adopting UNCITRAL model laws. Next, I will give the floor to Ms. Shaila Yasmin. Ms. Shaila, I think Bangladesh has done exceedingly well in adopting cross-border paperless trade. So I would request you if you could kindly explain our audience how has Bangladesh overcome legal and technical barriers in adopting cross-border trade, as a paperless cross-border trade, and how this digital system brought in efficiency in your system, and has it helped in increasing trade with neighboring countries? The floor is yours.
Honorable Judges, Excellencies, Secretary General, members, moderators, respected panelists, and dear audience, Assalamu alaikum and very good morning. I'm honored to speak on behalf of Government of Bangladesh on the issue of relating cross-border paperless trade. I appreciate initiative on UNCITRAL and Ministry of External Affairs, India, for arranging such a nice session and give me the opportunity to address the session. Being supported by robust economic planning, Bangladesh Vision 2021, the economy has achieved remarkable progress in many socio-economic indicators over the last decades, especially in per capita growth, poverty rate, life expectancy, primary education, and mortality rate. Recently adopted Perspective Plan of Bangladesh 2021 and 24 sets a goal to upgrade the economy to middle income country by 2031 and developed country by 2042. Now come to the main point. Bangladesh increasingly integrated with the global economy through international trade. Compared to most of the competitors, high trade cost is persistent barrier for Bangladesh to engage international trade more efficiently. A large portion of this high trade cost mainly resulted from the significant inefficiencies in the country's border operation. According to WTO, Bangladesh have implemented 44% of its trade facilitations commitment. Implementing paperless trade and cross-border paperless trade measures could reduce countries' cost significantly. A recent studies done by UNSCAP shows that when digital trade facilitation measures are implemented, the average trade cost could be reduced 13% if the measures can properly adopted. Now, our government tried to reform some institutionals, legal and trade facilitation, increased trade facilitations for the well-being or for proper implementation of cross-border paperless trade. The rectifications, as Bangladesh has rectified framework agreement on facilitation cross-border paperless trade in Asia and the Pacific in 2021, and it came into force 2020 and came into force 2021. Bangladesh has active transit agreement with India, Nepal, and recently signed a protocol with Bhutan in March 2023. Bangladesh has no mutual agreement for cross-border electronic trade and data exchange with the trade partners, but Bangladesh government shown keen interest in this regard. For that purpose, the export and import related laws and regulation has been amended in the case of establishing single national window that is operating under operation, and it will come into force by 2030. But we are expecting it will come into force 2027. And in the case of trade, trade by sea, land, and air transportation, however, majority of the maritime transportation, more than 90% by Chattogram port. Neighboring countries are India, Nepal, Bhutan, Myanmar, with the international trade, transportation is done mainly by sea, few by land customs stations. And we are, for the betterment of the trade, Bangladesh Customs Authority has developed a module for capturing transit in SI code. Few documents are needed for incorporate with the SI code, export-import manufacturers, some land port shipping agencies submitted to IGM and EGM, and then the customs officials entered the data into SI code. And billing of lading, letter of credits, import, exports. But still, we are now totally digitalized. Still, hard copies also documented, needed to submit it for final assessment. We are trying to overcome, not to give any papers, but still for the supported and for function smoothly, as well as the paper documents is needed, is still needed. And I have already told national single window, and Chittagong Post is still operating in the SI, with the SI code systems, and this is totally system. This is done totally digitalized system within the country, but not across the country or over the other countries like India, and I have mentioned earlier, no states or region has been signed for the digital paperless trade. But it is needed for same countries, harmonizations of data, some legal reforms, and institutionals. As you know, Bangladesh Ministry of Commerce is lead in this field for any regulations, and our customs and National Board of Revenues is working all the mechanism, total mechanism, and others related department and institutions are related with the digital cross-border paperless trade, and we are working hard to do that. But it is not in our end, it is depends on the others partners or countries. So I am stop here, and we'll discuss the next portion for that reason. Thank you very much.
Thank you, Ms. Shaila, for sharing the journey of digital transition of Bangladesh. Now I'll give the floor to Ms. Laura Ho, I know we are just exceeding time and you're the last speaker, so I will request you to please stick to time. I know Malaysia has been actively engaging in free trade agreements and standalone agreements as well. I would like to highlight the journey of Malaysia in adopting domestic legislation regarding digital economy. Floor is yours.
Thank you. Thank you, Mr. Chair. And good morning to all of you. My name is Laura. I'm from Malaysia. So I'd like to start by expressing my gratitude to UNCITRAL for having me here, for giving me the invitation to have the opportunity to be here today. And of course, gratitude also to the gracious host, the MEA and UNCCI, for your gracious hospitality. So some background about our organization. I'm from the Malaysia Digital Economy Corporation. The company was set up in 1996 as a one-stop agency to drive the digital transformation, to drive the country towards the digital economy. Today, we are very much still right at the center, front and center of the digital economy and driving the digital transformation agenda for the country. We're an agency under the Ministry of Communications and Digital. So our core mission, of course, is to make Malaysia the preferred destination for digital investments. And of course, to also drive an inclusive approach to ensure that everyone can benefit from the opportunities of digital economy. So we do this via different initiatives. We call it the catalytic initiatives. Digital trade is one of the area, and also, for example, digital agriculture and digital nomad. And one of the key functions that we do is also to work with government and private sector to shape and influence the development of policy and regulatory framework for the digital economy. So a bit about the ICT developments and status in Malaysia. So as at the end of 2021, ICT contributed 23% to Malaysia's GDP. E-commerce itself contributed 13%, having grown from 6% in 2016. Our population is 33 million people. 99% have mobile phones, and 99% penetration for social media. So as Malaysia progresses towards the digital economy, the digital ecosystem needs a framework that both, number one, enables and facilitates, and two, that build trust and confidence for both businesses and consumers to engage in the digital economy. The first major piece of legislation for Malaysia is the Communications and Multimedia Act 1998. It establishes a licensing and regulatory framework in support of our national policy objectives for the communications and multimedia industry through the convergence of the telecommunications and broadcasting industry. Of huge significance also is the Electronic Commerce Act. It gives legal recognition on the use of electronic messages in commercial transactions, which is based on the UNCITRAL Model Law on Electronic Commerce 1996. We also have the Digital Signature Act, which provides for the use of a signature using the PKI technology and the licensing regime for the certification authority. I would like at this juncture to state that the E-Commerce Act of Malaysia specifies that e-signature includes digital signature under the Digital Signature Act. We also have the Financial Services Act, enacted in 2013, to regulate the use of the electronic money as a payment instrument. So except for the Digital Signature Act, which is technology specific, our legislation, as I mentioned above, is based on key three principles in the UNCITRAL Model Law on Electronic Commerce 1996. These three principles are widely regarded as the founding elements of modern electronic commerce law. These three principles are non-discrimination, technology neutrality, and functional equivalence. So there are also various laws in the Malaysia's legal framework to build trust and confidence. We've heard about Consumer Protection Act, similarly in the case for Malaysia as well, Personal Data Protection Act, and the Computer Crimes Act. Now, digital trade has evolved, e-commerce and digital trade has evolved so much over the last few years, especially during the period of the pandemic. So Malaysia has gone through a period of acceleration on the uptick of e-commerce and has eventually currently reached a stage of stabilization in terms of the growth trajectory. We have seen that growth is beginning to stabilize, and what we are focusing now is about driving cross-border interoperability, which is premised on the seamless end-to-end movement of data. Common data sets, common standards, and of course, a coherent and compatible legal framework across the borders. So this is where Malaysia also has been very active to engage, to use free trade agreements in order to drive the growth of cross-border trade. So since 2010, the FTAs that we signed also include the e-commerce chapters. We are currently also working with many countries, 89 countries in all, to engage in negotiation under the WTO Joint Statement Initiative on e-commerce. So based on what we've heard, I think the target for completion of this negotiation is targeted to be the end of this year. So earlier this month, there's also been an announcement by ASEAN that the 10 ASEAN member states will be engaging in negotiation of digital economy framework agreement. So this new generation of agreement covered not only the conventional provisions in existing FTAs, but also newer and emerging issues such as AI, cryptography, fintech, blockchain, and a number of new issues. So definitely, FTA and the more recent digital-only agreement, we feel that is a useful piece of mechanism to complement the work of UNCITRAL in order to forge a common approach, a common globalized approach, in order to address and forge international cooperation in order to drive digital trade agenda forward for the entire world. So thank you, and that concludes my remarks for the first part. Thank you.
Thank you, Ms. Laura, for sharing your views on the digital transition journey of Malaysia. As we are running a little short of time, in the second intervention, I would request speakers to please stick to 2 to 3 minutes, and this time I will intervene if you're exceeding. Last time I didn't. So I will start with Mr. Luca. Mr. Luca, if you could tell us about the impact of digitization of trade, especially on developing economies, with a focus on South Asia, please.
Thank you very much. The event we had earlier this week in the Republic of Korea was about the transition from documents to data. So we have of course commercial documents, but these documents contain information. That information in the digital economy has to be seen as a whole and not fragmented as if it be on paper. In order to accompany that transition, as I mentioned before, UNCITRAL has prepared and is working on adequate legal texts. When we come to South Asia, we see that in general, all South Asian countries have adopted the UNCITRAL text from the late 90s, early 2000, with the exception of Nepal as an outlier. And India in particular started with a very technology-specific approach to electronic signatures, but eventually opened it up and has a now technology-neutral two-tier approach. But the issue with South Asia, and again, there are nuances, Sri Lanka and the Maldives, where we were active directly providing technical assistance, may have adopted more texts compared to the other countries, is to really embrace these, what we call digital trade 2.0 legislation. We have read not only the G20 declaration on the digitalization of commercial documents, but also last week there was a pilot transaction between Singapore and India, purely paperless, with electronic bills of lading, electronic letters of credit, So India private sector is ready to transition to this exclusively digital world, but there is the need for the enabling legal environment, starting with the adoption of the UNCITRAL model on electronic transfer records. And I'm very grateful to Laura because she completed what I was saying, and she also pointed at what is going on in Southeast Asia with more awareness and more advanced stage of sub-regional integration. So to conclude, 2 sentences. The first one is, again, please come to Working Group 4 because that's the entry point to take stock of what is going on. And the second is, please take a look at this newer UNCITRAL text on digital trade. Thank you very much.
Thank you. Thank you for sticking to your time. I'll give the floor to Abhishek Singh, sir. Sir, if you could highlight the role of digital economy in not only the traditional sectors, such as agriculture, education, but new emerging sectors, such as fintech, which have helped India emerge as the 5th largest economy. Sir, the floor is yours.
Thank you. Thank you, Mr. Moderator. I'll try and stick to your timelines. Honorable judges, excellencies, panelists, the success of an effective digital economy lies in its key components, primarily a robust digital infrastructure, a skilled workforce, and cybersecurity measures to protect systems and data. And it rests on the 3 pillars of digital infrastructure, digital payment system, and data sharing. Talking about India, Mr. Moderator, India Stack is an example of how a unified, multi-layered set of digital platforms provided by the public sector give businesses, startups, and developers significantly improved access to financial services. At the same time, it also promotes financial inclusion, efficient conduct of specific fiscal policies, increased efficiency, financial stability, and easier access to data generated with consumer consent. It primarily converges the 3 rails which I had spoken about regarding the India Stack, which is the identity rail, wherein, the example of that is the Aadhaar, which allows the Aadhaar card, which allows the authentication of identity without the need for a physical presence, as well as a eKYC, e-sign, and DigiLocker. I'll talk a little bit about that. So you must have heard, especially for the dignitaries who have come from abroad, this is the Aadhaar card, and this was issued to me in 2012, I believe, and still it's, very much, valid. And you can see there is a code, scanner code, and if I have to open a bank account or need a gas connection or, get a new mobile connection, I think this is required, and it has a lot of information which they would require for issuing those services to me. Mr. Moderator, India offers an example of how various policy reforms related to digital finance, including transformation of traditional banking system with the Central Bank of India playing a pivotal role, can solve actually many problems and many challenges of inclusive financial development that once seemed out of reach. If jurisdictions were to adopt a UPI-like payment solution, it would not be so much of a technical challenge to set up instant cross-border payment schemes. The challenge would be to build international consensus over policy architecture for cross-border payments in which intervention from UNCITRAL is solicited. Excellencies, India's approach is essentially built on 4 pillars. Number 1, providing digital financial infrastructure as a public good. Number 2, encouraging private innovation by providing open access to this infrastructure. Number 3, creating a level playing field through the regulatory framework. And last but not the least, empowering individuals through a data sharing framework that requires their consent. In 2010, Aadhaar was the first digital public good designed for the specific purpose of authenticating individual biometric identity for all Indians. India created several innovative digital platforms built as a public good ever since. I've talked about the India stack, and I've also mentioned in a passing way about the KYC rail, about the e-sign, which allows individuals with Aadhaar to sign documents digitally on their phones. DigiLocker, which is an online repository of digital documents. But let me also briefly mention about how digital economy has led to advancement of health tech, edutech, and fintech, Mr. Moderator, that you were mentioning about. In the health tech sector, digitalization of COVID-19 vaccination drive, India launched the indigenously developed CoWIN platform as a digital tool to combat COVID-19. CoWIN platform monitored name-based vaccination and administration of more than 1.92 billion vaccination doses in India. With interest received from more than 50 countries, Mr. Moderator, appreciating the efficacy of CoWIN app, India offered CoWIN platform as a digital good to the world to combat COVID-19. India's telemedicine platform, eSanjeevani, has benefited more than 390 million beneficiaries in India through video consultations during the COVID-19 pandemic, making it the biggest such platform in the world. Similarly, and important for this conference, I want to mention this, Mr. Moderator, that we are trying to extend this expertise to 54 countries across Africa via e-Arogya Bharti, promising results that have been observed throughout telemedicine. Finally, I'll just briefly touch upon e-education, education tech, where we have this e-Vidya Bharti launched in 2019 by India for the next 5 years, offers certification and diplomas, etc. Fintech, Mr. Moderator, which you were mentioning, this fintech revolution has the full support from our government, as India is amongst the fastest growing fintech markets in the world. The Indian fintech industry, Mr. Moderator, this ecosystem sees a wide range of sub-segments, including payments, lending, wealth technology, personal wealth, etc. In conclusion, Mr. Moderator, I would mention that under the visionary leadership of Honorable Prime Minister Shri Narendra Modi, we have also unveiled, and which is popular across not only India, across the globe, the Make in India and the Digital India initiative. The Make in India program aims to promote manufacturing in India, while Digital India program aims to promote the adoption of digital technologies. The two programs, Excellencies and fellow panelists, these two programs complement each other, with Make in India promoting the production of digital services, while Digital India promotes the adoption of digital services. So on this note, I would like to thank everyone for their time, and once again, thank Mr. Moderator for your indulgence in permitting me a little extra time. Thank you.
Okay, thank you, sir. Thank you. I would request the remaining 3 speakers to please stick to the time. I will give the floor to Dr. Chaichana. Dr. Chaichana, if you could highlight how the digital transition journey has helped practically people on the ground, especially in the field of creating an efficient digital system, e-tax filing, and electronic transactions. The floor is yours, but please stick to the time limit, please. 3 minutes is yours.
Thank you. I'll do my best. What we are talking about is not only on paper, it's now in action, as has been mentioned before. Now we have, for B2B, we have e-tax invoice document. In the past few years, more than 3 billion documents being exchanged on the e-tax invoice. Now government of Thailand are offering e-services. SEC, or Security Exchange Commission, alone has offered more than 100 services online. DBD, Department of Business Registration, has been offering registration services online. So all these are in action. And also there are court cases where, when the person in Thailand get advanced money without money in the account, get advance money from the ATM machine, and the person denied of signing a contract. But the court case already pinpoint that. Put in the card, put in a PIN number, identify yourself, getting the advance money. That's total process is already a contract formation using the concept of electronic contract in Thailand. So now everything is in action, but we have to expand further. For example, in terms of digital ID, in India you have ATA, in Thailand we have TID. Now we start to grow the population of digital ID. My dream is we have a global adoption of, for example, model law on the use and cross-border recognition of identity management system, so that TID from my side can be used to recognize myself here in India for cross-border transactions. I hope that next time, maybe myself, when entering India, my TID will be recognized by the government of India. Maybe my children, but I hope in my generation. That's what my hope. Thank you.
Thank you, Dr. Chaichana, and thank you for sticking to the time limit. I give the floor to Ms. Shaila. You, in your earlier intervention, you talked about cross-border paperless trade. If in this intervention, if you could highlight the steps taken by Bangladesh in other fields like fintech, edtech, the floor is yours.
Thank you, moderator, and respected judges and panelists and dear participants. Assalamu alaikum again. As we are in short of time, so Bangladesh is on the way to implementation of cross-border paperless trade, but we have some issues to we have some for the implementations of cross-border paperless trade, as that's our finalization and enactment of the Data Protection Act that are enabling legal environment for cross-border paperless trade, and totally developed required ICT infrastructure and technological capacities in various agencies directly related to export and import procedures, so that the organizations can accept procedure, certified and submit the required data documents electronically. This will also enable this agency to be linked for the cross-border paperless trade. Establishing the interface between the SI code world and e-port management system for electronic transmission, data, documents, and decisions for paperless trade. And also developing an appropriate mechanism in the SI code world for verifying authenticity data and documents submitted electronically to avoid additional submission of all original papers document. Bangladesh established a full operation of Bangladesh National Single Window for creating enable environment for cross-border paperless trade. With that, Bangladesh government has made the necessary provisions in the Customs Act 1959 to facilitate cross-border paperless trade for data and documentations. However, appropriate agreements and cooperation arrangement for the electronic exchange and data and documents with its trade partners and neighboring countries must be agreed upon and put in the place for effective operationalization for cross-border exchange for the trade data and documents. So in conclusion, I can say that harmonization the data between the trade partners and harmonization of legal instruments in on platform is very much necessary for the cross-border paperless trade. Thank you very much.
Thank you. Thank you. Now I will give the floor to Ms. Laura, the last speaker for the second intervention. We have seen Malaysia's e-commerce has contributed significantly to the GDP. I think it was 6% in 2017, and it's around 13% now. So could you tell us the strategies that Malaysia adopted in increasing the contribution of e-commerce to your GDP? The floor is yours.
Thank you. So the initial touch point on digital economy, and for that matter, digitalization for many, is e-commerce. And Malaysia recognizes the importance of e-commerce in driving the growth of the digital economy. And we have been implementing this particular roadmap called the National E-commerce Strategic Roadmap, the NESR, since 2017. So this particular roadmap seeks to address a number of challenges. So if I may summarize. First, Malaysia is a country with a population of 33 million people. Malaysia has areas which are urban, rural, and also very remote. So we had to work on solving the issue on adoption. How do we get our SMEs and merchants to be trained? And in fact, many of the merchants that we're trying to address are in fact MSMEs. How do we get them to be trained? How do we get them onboarded onto e-marketplaces? So the challenge on accessibility and scalability is really very real. So that's the first challenge. So the second challenge is about the cross-cutting nature of the digital economy. We're looking at policies, we're looking at disciplines, we're looking at interventions that needs to be undertaken across a number of ministries and agencies. And third is about ecosystem development. So when we are looking at e-commerce, we are not only addressing the transactional part of it. It's not just about the buying or the selling. It is also about digital literacy. It's about the talent development. It is also about solving the logistics problem, about inculcating a culture of innovation. And of course, now we know that digital economy is about seamless end-to-end flow of data. How do we enable and facilitate cross-border flow of data? And of course, leveraging on the new and emerging technology. And of course, last but not least, the importance of a legal and regulatory framework that not only works domestically, but also it makes sense in terms of the overall cross-border rulemaking, in terms of our cooperation with our partners. So we have implemented this particular roadmap called the NESR, as I mentioned, since 2017. So this particular roadmap seeks to mobilize a diverse group of stakeholders in the private sector, across the public and also the private sector, towards a common vision. So this particular roadmap is governed and monitored through a task force chaired by senior officers of the government, and it goes through various reporting structure and eventually reporting to a council that's chaired by the Prime Minister. So we are now in the second phase of the roadmap. The first phase was 2017 to 2020. Of course, with the evolvement of the digital economy, the roadmap has gone through a refresh, and we're now in version 2, which is NESR 2.0, that will take us through from 2021 to 2025. So this roadmap is premised on three key principles in order to solve the challenges that I mentioned earlier. First is about intensifying e-commerce adoption and growth, including to take advantage of the cross-border export opportunities. Second, enhance ecosystem. And third, strengthening the policy and regulatory environment. So this roadmap is implemented through 16 programs across 15 ministries and agencies, and of course with very close collaboration with the private sector. So we have found such a roadmap to be extremely useful and effective in order to align all the very diverse stakeholders towards a common goal. So I would like to also take this opportunity to share with you that one of the key initiatives under the NESR is the National E-Invoicing Initiative. So Malaysia is a newcomer to this particular initiative. And this e-invoicing is premised on the concept of interoperability, a standardized approach on standards, and of course, it's also about seamless movement of data in order to achieve efficiency, accuracy, and reliability of transactions. Of course, the global technological landscape and business models have undertaken huge evolution, especially over the last couple of years. So the NESR, even though it's meant to take us until 2025, we are now conducting a review. Because global conversations have moved from e-commerce to digital trade. a lot of technology are now being employed in order to ensure security, effectiveness, and efficiency of transactions. So as we are doing a review, I'm very pleased to be able to work with UNCITRAL and of course to engage with the global communities and of course experts around the region, especially South Asia, to take into account regional developments, best practices, and in particular the work of UNCITRAL to be incorporated into the next version of our roadmap. And we want to develop this particular roadmap called the National Digital Trade Roadmap for the country. So with that, thank you so much again.
Thank you. Thank you, Ms. Laura. So we have very less time left for Q&As. If there is anyone who wants to ask any question, if you can have the mic, please. We have only 3-4 minutes, so probably 1 or 2 questions. There we have, somebody has raised a hand. If you give the mic to her, please. Please introduce yourself and please be brief when you ask your question, please. Please, can you ask?
My name is Sahil Kumar, and I am from Calcutta. Currently, I'm studying law from University of Calcutta. So my question is to Mr. Luca, sir, that security challenge in digital economy are indeed a significant concern. So in a global nature, digital economy operates globally, making it difficult to enforce laws uniformly across difficult jurisdictions. So legal challenges dealing with cybercrimes that transcend borders. So this is my question.
So if I understand correctly, this is what kind of challenges we have for cross-border recognition of electronic transactions and other similar matters. We do have, the challenge historically is related to electronic signatures, because countries have adopted very specific technology approaches, but also national approaches. And we don't, in many countries, a signature is a matter of mandatory law. So it is not possible for the parties to a transaction to agree on the validity of the signature. It has to be validated by a statute. Now we are transitioning from that to, we see now electronic signatures not only as the equivalent of a handwritten signature, but as a trust services that gives a guarantee of origin and of integrity of the signed data message. That's why the model law on the use and cross-border recognition of identity management and trust services is so important. We don't have yet this global system for cross-border recognition of trust services. I don't know to which extent it will be in the joint statement initiative, but countries have to start agreeing on that.
Thank you. We'll have one last question. Please go ahead.
Namaskar, sir. My name is Divya, a last year student of Campus Law Center, Faculty of Law, University of Delhi. Sir, my question to you, sir, Siddharth, sir, to you only.
Okay.
Sir, my question to you is that we, the most populous country in this world,
Right.
and largest internet user too, and so far we have not the digital data protection bill. We have in a bill stage, but it has not been made the act yet. So my question to you is that whatever the knowledge I have gained from such a bill which has been tabled in the recent session of the parliament, it has not covered the hacking against any kind of provision I didn't found regarding the hacking. We have the incidents of the Pegasus virus and the PETA virus ransomware. So what kind of the government is going to do in this regards if certain kinds of hacking happens to our citizens? How we are going to deal with, what kind of provisions are there? So if you can elaborate this in a much better way, that's I expect. Thank you.
Thank you so much for your question. I am actually the moderator. I'm not the panelist, so I'm not the right person to answer that. I'm also not the right person to answer this question. I'm not a lawyer by profession. I think Government of India has already taken this, passed this data protection bill. And we will be working on because you see this field is very evolving. It's dynamic. New kinds of crime are coming up. And if you see, we've also recently in the parliament, a new bill was also introduced with respect to amending the Indian Penal Code as well. So I'm sure if this is not covered there, our parliament would be discussing this in the new penal code, and you are a lawyer, and that you have all the right to give your views to the parliament because it is open to the public. Would request you, if you raise such an important point, to give this to the parliament in writing. Probably they could take this up, and they will definitely consider this.
If you get the opportunity to meet the Mr. Prime Minister, then please, if you on my behalf, on the behalf of the citizen, please convey this message to him also.
Sure. I am only a director in the Ministry of External Affairs, but I will try to do that. Thank you. Thank you so much. Thank you, all the panelists. I think we have been able to finish the first session in desired time period. I will thank you, all the panelists, and I would now request Dipali to please take the floor.
I would request you all to stand together for a group picture. Thank you all for your expertise. Your wide-range views have helped us acquaint with how UNCITRAL can help in regulation and enhancement of digital economy, not just domestically, but across borders. We'll begin our next session now. I now call upon stage Dr. James J. Nedumpara to moderate today's session on MSME and access to credit. I would also like to call upon stage Mr. Jai Sungli, Ms. Mercy Ipau, Ms. Hemlata Mahalingam, and Mr. Jingchan Lai. We also have amongst us Mr. P. Kumaran. He's the Additional Secretary, Economic Relations and DPA, Ministry of External Affairs, Government of India. Mr. Kumaran is an IFS 1992 batch and has served in various diplomatic missions and posts all across the globe, including Cairo, Belgium, Pakistan, Washington, and Sri Lanka. He has also represented India as an ambassador to Qatar and Singapore. I would like to invite you, sir, on stage to enlighten us with your words on MSME and access to credit.
Members of the legal fraternity, members of the diplomatic corps, distinguished delegates, ladies and gentlemen, good morning and namaskar. It's a pleasure for me to speak to you at this session on MSMEs and access to credit. The session aims to focus on the challenges of the micro, small, and medium enterprises and the measures to address these challenges. I'm happy that the panelists for this session represent a wide range of organizations and experiences in this area, and I look forward to listening to their views. Friends, the Indian MSME sector comprises nearly 63 million enterprises, which contribute 30% to India's GDP, 45% to manufacturing, 40% to our exports, and provides employment to over 113 million people. India's fintech revolution has served as a valuable instrument to not only empower individuals, but has also facilitated the growth of MSMEs significantly. The government and policymakers in India are acutely aware of the need to support MSMEs given their potential to generate better social impact. We have therefore taken a range of measures to enhance MSMEs access to credit, recognizing their importance in driving economic growth and employment. Some notable measures include the Pradhan Mantri Mudra Yojana. This is a flagship program aimed at providing financial support to MSMEs in the form of loans through Micro Units Development and Refinance Agency, Mudra Banks. This initiative offers 3 categories of loans, catering to different stages of MSME development. It has significantly expanded access to credit for small businesses and entrepreneurs. The Credit Guarantee Fund Trust for Micro and Small Enterprises offers credit guarantees for lending institutions, encouraging them to extend collateral-free loans to MSMEs. This scheme reduces the risks for lenders and boosts MSMEs' access to credit, especially those without substantial collateral. The Interest Subvention Scheme for MSMEs provides interest rate concessions to small businesses on timely repayment of their loans. This initiative lowers the cost of borrowing and incentivizes MSMEs to maintain good credit discipline. The Small Industries Development Bank of India, SIDBI, manages a fund of funds scheme which provides financial support to various MSMEs, focused venture capital and private equity funds. This scheme helps MSMEs raise equity capital, enhancing their financial stability and growth prospects. Stand Up India is another initiative aimed at promoting entrepreneurship among women and underprivileged communities by facilitating bank loans between rupees 10 lakhs and rupees 1 crore for setting up greenfield enterprises. It encourages financial institutions to extend credit to such categories. The government has encouraged the development of digital lending platforms that use technology to streamline the loan application and approval processes for MSMEs. They help in reducing the time and effort required to access credit conveniently. Trade Receivables Discounting System, TREDS, is another online platform that facilitates the financing of trade receivables of MSMEs. It allows MSMEs to auction their trade receivables and receive funds early, thereby improving their cash flow. The RBI has also revised priority sector lending guidelines to include higher lending targets for MSMEs. This encourages banks to allocate a greater portion of their loan portfolios to MSMEs. The Export Credit Guarantee Corporation, ECGC, operates a number of schemes that offer export credit insurance and working capital financing support to MSMEs engaged in export activities. The government has also from time to time taken extraordinary steps such as the Emergency Credit Line Guarantee Scheme, ECLGS, to alleviate pressure on the MSME sector, especially during the dark days of COVID. Friends, India has the world's 3rd largest startup ecosystem. We have therefore implemented several measures, especially to support startups in terms of access to finance and to create a conducive environment for innovation, entrepreneurship, and the growth of new businesses. Some key steps include Startup India, which is an initiative launched by the government to promote and support startups. It offers a number of benefits, including tax exemptions, funding opportunities, and simplified regulatory procedures. As part of this, the government has established a startup seed fund scheme to provide financial assistance to startups right at the ideation stage. The government has also established a fund of funds for startups with a corpus of 10,000 crore rupees to provide equity funding to startups. This fund invests in various alternative investment funds, which in turn fund startups. Startups also enjoy a 3-year tax holiday on profits under the Startup India initiative. Additionally, there are exemptions on capital gains tax for investments in startups. The government encourages startups to participate in public procurement by reserving a certain percentage of contracts for them. This opens up opportunities for startups to work with government departments and agencies. These measures together create a favorable ecosystem for startups in India and for MSMEs. Based on our successes in this area and with a view to sharing our experiences with other countries, we made it a point during India's presidency of G20 to underline the importance of startups and MSMEs. We see them as natural engines of growth and key to socio-economic transformation by driving innovation and creating employment. We therefore established the Startup 20 Engagement Group for enhancing startups and MSMEs' access to information to promote their integration into international trade. We are happy to work with UNCITRAL and other international partners to help achieve this objective. Thank you very much.
So thank you, Mr. Kumaran, for laying out the various activities initiated by the Government of India and how the MSMEs have got a better ecosystem to work in the country. I understand that Mr. Kumaran will have to go for another engagement, but I would like to thank him for giving a bird's eye view about the various policies taken by India. Thank you.
We'll now begin our panel discussion, which will be moderated by Professor James. Mr. James is head and professor at the Center of International Trade and Investment Law at the Indian Institute of Foreign Trade, which is established by Ministry of Commerce and Industry. He has also played a key role as an advisor to the Government of India on various aspects related to international and trade law. Sir, please.
So thank you, Dibali, and welcome to all of you. I understand that this is a very distinguished audience. We have got judges from Supreme Court and High Courts of India. We have got representatives from international organizations like UNCITRAL and ICSID for that matter. We have got a number of reputed lawyers, senior and junior. And we have got a vibrant community of very young and enthusiastic students here. So welcome to all of you. So my role is to actually have to moderate a session on MSMEs. So when you think about MSMEs, it is a very diffuse kind of a group. And the additional secretary mentioned that in India we have nearly 60 million MSMEs. So in raw terms, it is actually 6 crores. There is a huge number for that matter. But when it comes to MSMEs, most of the times they do not have access to finance. That is a major problem, in fact. And when we also think about the various issues they face, they have got barriers to entry. They have got a high amount of transaction cost in the country. So in many ways, I think it is very difficult to function as an MSME. So if you really look at the recent G20 document, there is an acceptance that the MSME is basically the backbone and the engine of the economy. So in paragraph 18 of the G20 document, which is basically the declaration of the leaders, there is a statement that the MSMEs can actually perform socio-economic transformation for that matter. So that is a huge, I think that is recognizing the huge ability of the MSME to make a transformative role in the society. And we also know that when it comes to MSMEs, the access to finance is only one of the many, many problems. First of all, I think even to form an MSME is actually a challenge. So in this particular panel, we have got a very diverse mix of people. So we have got representatives from the Indian government. Ms. Mercy Appo is actually a joint secretary in the Ministry of MSME. And in addition to that, we have got a representation from UNCITRAL. We have Mr. Jaisung Lee from UNCITRAL. He is actually a senior legal officer. And we have also Ms. Hemalida Mahalingam, who is an advisor to the Regional Industry and Director of Financial Institutions Group, South Asia. And in addition to that, we have got Mr. Jing Chang Lai. He is a Principal Operations Officer, Financial Institutions Group, Asia Pacific, International Finance Corporation, World Bank Group. So the advantage is that, since we have got a very diverse group of people, we can not only understand the various kind of policy frameworks which countries may have in place. There are two different things. One, having number of sufficient programs on paper. So, we may have a number of programs to facilitate MSMEs. But the real important thing is, are these programs are actually functioning on the ground? So, are they really working in action? And because of the presence of the diverse group, my understanding is that they will be able to provide the areas where the MSMEs face real and tangible challenges, and how we can provide real solutions so that we can integrate the MSMEs to our mainstream economy and to actually echo the feelings of the leaders of G20, how the MSMEs can be used as a leverage for economic transformation. So without further ado, let me invite Mr. Jae-Sung Lee. He is a senior legal officer with UNCITRAL, to talk about the various initiatives taken by UNCITRAL, at least in terms of having the model securitization law with respect to the MSMEs. The floor is yours. Thank you.
Thank you, Moderator. As introduced, my name is Jae-Sung Lee. I'm a Senior Legal Officer at the UNCITRAL Secretariat, and it's a pleasure to be here in New Delhi with the entire UNCITRAL team of 5. So as Additional Secretary Kumaran has mentioned, he had already mentioned a number of government initiatives by India to support the MSMEs, and I think it reflects some of the best practices that you can see all over the world. But not all states have implemented such policies. And therefore, as Anna has mentioned in her opening remarks, UNCITRAL has been working to provide for an enabling legal framework to support MSMEs. This is because, as Additional Secretary mentioned, MSMEs represent the vast majority of businesses in all regions. They account for around 55% of the GDPs in developed economies and 35% in developing economies. And worldwide, they make up about 90% of the businesses and 60 to 70% of employment. MSMEs offer employment and are therefore crucial in increasing the income for the poorest of the 40% of the world's populations. And this is why a number of governments, including India, have prioritized MSMEs' roles, and therefore that leads to work by UNCITRAL. UNCITRAL, more specifically, its Working Group 1, has prepared 4 different texts, or adopted 4 texts, with regard to MSMEs that you can see on the screen. The first being on the business registry to formalize such enterprises. The second on the simplified form of businesses to make it easier for them to establish such enterprises. Third, on their insolvency, particularly taking into account the unique characteristics of MSEs. Here I'm referring to micro and small enterprises, such as their intermingled business and personal debts, to respond to the specific needs and circumstances to their financial distress. And most recently this summer, UNCITRAL adopted the Guide on Access to Credit for MSMEs just this July. The objective of all our work was to address the legal obstacles that MSMEs face throughout their life cycle, particularly in developing economies. But what you see on this slide is the relevance of other UNCITRAL texts with regard to the entire life cycle of an MSME. UNCITRAL texts on e-commerce, public procurement, and cross-border trade also are relevant. UNCITRAL texts on dispute resolutions, particularly the most recent text, which is on expedited arbitration, is also relevant for MSMEs. So let's have a little bit of a closer look at the Guide on Access to Credit for MSMEs. But before we do that, one might ask, what is an MSME? There is no global standard definition of MSMEs, and this is one of the questions that the working group had to address. Different countries and regions use different criteria according to the economic, legal, political, and social context. Number of employees, annual sales, value of assets are some of the criteria mostly common used. But there are other variations: years of experience, initial investment, and so on. Now, mindful of these differences, UNCITRAL texts on MSMEs do not define MSMEs. Rather, they take a flexible approach and allow states to apply their own definitions, of course. But What we hope to do is to actually identify the common characteristics of the MSMEs. For example, their lack of access to credit, difficulties in accessing markets, and, for example, limited access to courts. So the guide itself is a very, it's not a long document, but it actually contains, the first part contains the sources of credit and capital that are available to MSMEs general, which range from friends and families for support, commercial credit, lending from banks, credit cards, crowdfunding, leasing, receivables financing, warehouse receipt financing, letters of credit, collective credit, and microcredit, as well as public support. So these are kind of the sources that actually are available to the MSMEs. But what the guide does is actually looks into the recommendations or what the states need to do in order to ensure that the MSMEs have sufficient access to credit. And that is why I wanted to go through a little of the recommendations first. So the first two recommendations that you see on the screen relate to equal access to credit to ensure that MSMEs are not limited or disadvantaged in accessing the credit market. This is in recognition also in that poverty of women is directly related to unequal access to economic opportunities, and that women-owned MSMEs often face higher or barriers than owned by men. The guide thus encourages states to adopt necessary measures to ensure equal access to women entrepreneurs. The guide also recommends that states adopt laws to promote the formation of businesses, both through a simplified registry and simplified organizations forms. And as I've already touched upon, these are texts that have already been adopted by UNCITRAL in this area, and reference is made to those texts. The guide then recommends that states establish a secure transactions regime with regard to immovable assets, for the few MSMEs that actually have such immovable assets, and recognizing that the reliance on personal guarantees, states are also urged to require that the terms and conditions of such guarantees are clear and understandable to the MSMEs. In order for the financials to lend, they need to have information about the MSMEs and their credit worthiness. And that is why, so that is mainly whether they can really pay the loan. And therefore, establishing a system providing such information to the lenders is suggested in the guide, often referred to as a credit reporting or a credit score system. This could allow borrowers with a high credit score to obtain credit at a lower cost. And as mentioned, MSMEs, the needs of the MSMEs in financial distress is also reflected in the UNCITRAL text on insolvency. Now, recommendation 10 and 11 and 12 relate to the terms and conditions of the loan agreement that they engage in, and it is suggested that there is a clear and they are formulated in a clear, understandable manner so that MSMEs, when they actually engage in such transactions, know what they're engaging in. Lastly, the guide recommends or highlights the importance of capacity building, not only for the legal and financial literacy of the MSMEs, but the capacity of the financiers and the regulators on the understanding of what the needs of the MSMEs are. Now, while these recommendations may be quite obvious to you, not all states have implemented these policies or such a framework, and this makes the guide useful. Now, if you have been following the slides quite carefully, you would have noticed that I skipped one of the recommendations, which is recommendation 5. Recommendation 5 deals with secure transactions using movable property, and the recommendation states in paragraph B that it should allow MSMEs to utilize movable assets as collateral. In order to do so, the secure transactions regime should facilitate easy creation of security rights. It should allow for the creation of security rights in future assets. It should be easy to perfect by registration in a registry, and it should enable creditors to determine the priority of their rights and to enforce such rights in the case of default. Now, this is easier said than done, as anyone who has worked in the secure transactions reform knows that a number of rules have to be prepared for such a regime to operate. And this is why you see in the first subparagraph of the recommendations, you don't see it now, but you'll see it, that there is a reference made to the UNCITRAL model law on secure transactions, which was adopted in 2016. Now, a successful secure transactions regime has the characteristics that you see on the screen. It has to be a comprehensive regime for all types of movable assets. It has to have a functional approach so that any kind of a transactions that secures a payment is considered a security right. There should be some certainty and predictability about the transactions, especially the rights and obligations of the parties. You have to balance the interest of the parties. If you protect the MSMEs too much, the financiers will not be willing to lend. And therefore, you have to balance not only the interests of the MSMEs, but also the financiers, and you have to respect party autonomy. By doing so, you reduce the risk of creditors, thereby increasing the ability of credit to MSMEs at a more affordable rate and for longer periods. So to achieve this, UNCITRAL has adopted a number of texts in the field of secure transactions, with the model law on secure transactions being at the heart of that. The model law is a simple and concise text, but this is mostly for financial experts and not for journalists, I would say, providing a comprehensive, so it covers all types of movable assets, and a functional approach to address the multiplicity of regimes which have been created, and therefore gaps and inconsistency arise. For example, if you have a law on receivables, which is different from a law on inventory, what's going to happen is that the lenders would need to look at two different laws, and then if you have a multiplicity of these regimes, you have to look at all those regimes in order to create a security right over all the assets. Now, if I go into all of the details of the model law, we'll probably not have time for any coffee break, so I just wanted to mention that the model law makes it possible for MSMEs to use any type of movable assets without passing over the possession of those assets to the lender. And at the same time, there's a safety device to let the entire world know that the secured creditor has a security right in the assets, and to ensure that the secured creditor can enforce it in an easy and a simple manner. Now, this has been a very peep preview of the secure transactions law, and I would urge you to look up our text on secure transactions. Now, one of the other things I wanted to mention is that the model law also covers outright transfer of receivables, although this is not for security purposes, but this is because the same rules should govern such transactions. In this context, UNIDRA also has prepared a model law on receivables financing, which is called the model law on factoring, and therefore that is a relevant text as well. I wouldn't go into these details, and there's a practice guide to the model law on secure transactions for those who are engaging in such secure transactions, because what we have seen is that MSMEs and financiers and regulators who are new to this kind of a model law has faced difficulties in implementing the provisions. So that is why the UNCITRAL also prepared a practice guide. So UNCITRAL and other organizations active in the field of secure transactions has launched a joint network to support states in their in need of carrying out legislative reforms with regard to secure transactions. And as part of that initiative, I think Jin Chang and I will be in Dili, East Timor, next week to support and provide technical assistance in their legislative reform. We are going to be engaging in capacity building for lawyers, practitioners, and bankers, and government officials, and we also did that in Nepal in March. So we are cooperating with a number of institutions to support the implementation of the model law. So I just wanted to conclude that what is important is creating an inclusive economic environment for MSMEs to ensure that they can have access to credit easily and at affordable cost. We have to address the finance gap, and similar to the digital gap that we have touched upon in session 1. Access to financial services is essential for MSMEs, and that is throughout the entire life cycle. It enables entrepreneurs to start up, innovate, improve, and grow. And that is why it is quite important to support such growth through a legal framework that UNCITRAL has been able to provide. And we're hoping that the UNCITRAL text on MSMEs and on secure transactions to support their growth. Thank you for your attention.
So thank you, Mr. Jay Sung Lee. This is actually a very, very interesting presentation because he spoke about the need of legal structures and institutions. So when we think about access to finance, obviously we know that there is, the lenders and banks, they will actually see a perceived kind of a risk when lending to MSMEs because of various factors, or because of information asymmetry, because of the possibility of a default happening. So how to actually balance that point? I think this is something very, very, very much interesting. And what he mentioned is actually a list of very, very complex documents. How you can actually create a security interest, how you can achieve priority interest in that, how there can be dispute resolution. So I think in 7 minutes, it is impossible to have a complete understanding of this complex model laws and guidelines for that matter. Maybe we can have a discussion a bit later as well. So let me now invite Ms. Mercy Apo, Joint Secretary in the Ministry of MSME.
Very good morning, namaskar. My name is Mercy and I'm Joint Secretary in Ministry of MSME. I thank the UNCITRAL and MEA for organizing this very important conference where we have distinguished participants and also expert panelists to help us all understand and come to an understanding where we can help the MSMEs grow. Government of India recognizes the importance of MSMEs. So we have a separate ministry, particularly dedicating to MSMEs. And I'm going to echo what Additional Secretary Mr. P. Kumaran has already mentioned. I will be echoing on most of the points. And I also would like to share what MSME Ministry is particularly doing for the MSMEs to access the credit. For the benefits of our international participants, I want to also mention here that in India, we have 3 types of segments if we talk about MSMEs. We have a micro segment, which is more than 95% of the MSME bracket. And in many countries, this micro segment is not there. So in order to bring out this distinguished segment, we have reclassified our MSMEs and in 2020, July. And if any enterprise, the investment in technology is up to 1 crore, rupees 1 crore, and the turnover is not more than 5 crore, you are considered a micro unit. And for the small enterprise, investment in equipments and machineries is not more than 10 crore, and the turnover is not more than rupees 50 crore. If you are a medium segment, investment in machinery will be not more than 50 crore, and your turnover is not more than rupees 250 crore. The unique thing about India's definition of MSME is that we do not put in the number of employment that any enterprise is registered. So that could be one of the unique, the unique feature of our MSMEs. Now, the importance of MSME, its contribution in exports, GDP, and also manufacturing output, services and trade, all these, the keynote speaker has already spoken. So I will not go into that, but MSMEs play a very important role for our Indian economy. And so government is also giving a lot of importance, a lot of focus. And we at the ministry level are also taking up a lot of initiatives at policy level. And we are also trying to help our MSMEs. One of the initiatives that we have taken is the Udyam registration. Now, we are also having camping across the country because we know that although there are many MSMEs, and we say that we are more than 6.3 crore, but we know that there could be a lot more because many of the MSMEs are not under the formal sector. They are not registered as yet. And because of our cultural context, If an enterprise is owned by a woman or started by a woman, usually it is registered in either father's name, husband's name, or brother's name. So we are also trying out, reaching out to them and getting them registered so that we also handhold, give them the special support that they require for women and the marginalized community as well. So Udyam registration is one of the initiatives that we have taken. And in the MSME ministry, one of our vision is for the Amrit, India Amrit Kal, when India reach 2047, we would like to see women entrepreneurs coming up at 50%. And right now, the employment is number 2, next to agriculture. But we would like MSMEs also to be in number 1. So these are some of the visions that we have given ourselves, and we are working towards that. For the Ministry of MSME, we work broadly under 5 verticals. One is, of course, the most important thing is credit facilitation, which we are discussing just now. And we have different programs and schemes and initiatives to help the MSMEs, because this is one of the biggest gaps that India faces, like many of the countries. And our flagship program is Prime Minister Employment Generation Fund, PMEGP. And for this year, we have 2,700 crore earmarked for this program. And under these, we have higher subsidy for women. We have higher subsidy for people coming from the scheduled tribe and the scheduled caste. And we have also revised very recently the amount that they can avail under PMEGP scheme. For example, in services sector, you can now avail up to rupees 20 crore. And manufacturing, it has been enhanced to 50 crore. So PMEGP is one of our main focus here. And Ministry of MSME under the CGT-MSE, we have also enhanced it now to rupees 5 crore. Earlier it was only 2 crore. Now we have enhanced it to rupees 5 crore. And under the CGT-MSE, as on June this year, 2.34 lakh guarantees have been approved for an amount of 30,450 crore. And CGT-MSE has been given a projection that 14.34 lakh guarantees will be approved for rupees 1,14,781 crore in this financial year. So this is one of the highest as far as CGT-MSE is concerned. MSMEs, apart from accessing the credit, if they get the seed funding is taken care of by the DPIIT ministry, so we don't give seed funding here, but then we have growth funding. MSMEs come to a standstill where they have the potential to grow and grow beyond the bracket of MSME and become champion. But many a times they face the obstacle of getting the capital for growth. And so here the Government of India has announced SRI Fund, Self-Reliant India Fund, which is a fund of fund with a 50,000 crore corpus. And Government of India will give the mother fund, which is 10,000 crore, and the daughter funds will bring in 4 times of that, and then it will be invested in the MSME ecosystem. So as of now, we have more than 45 daughter funds empaneled, and we have committed more than 50% of the budget. And so this is doing very well in the MSME sphere, and this is for the growth funding. Now, this is one of the Atmanirbhar Bharat package, and the objective is to enhance equity, quasi-equity, and debt financing as permitted under the SEBI law. And it also supports faster growth for the MSME businesses and thereby ignite the economy and create employment opportunity. It supports the enterprises which have the potential to graduate beyond the MSME bracket and become international or national champions. It supports the MSME in helping India self-reliant by producing relevant technologies, goods, and services. So this is the objective of the SRI Fund. These are some of the initiatives under the MSME Atmanirbhar Bharat program. MSME Sambandh portal. Now, MSMEs are very small. As I said, 95% of our MSMEs are in the micro segment. And so when they face delayed payment, then they face a huge problem. So government has also introduced this MSME Samadhan portal where delayed payments are monitored and certain number of days are given to them, and if they do not pay within that time, then there are certain fines and liabilities to meet up to. And if you are following our news, you will know that on the upcoming 17th, we are going to also launch the Prime Minister Vishwakarma scheme, PM Vishwakarma scheme, where 18 trades, which are in a sense artisans and trades, which has been a traditional trade for the family. Now, we want to also help those people come in the formal sector. That is why we are launching this one, and it's going to be a 13,000 crore project for 5 years. And so we are also working how we can best help our MSMEs. They will have the access to the loan credit facility up to ₹1 lakh, and then later on 2 lakh rupees. So these are all initiatives taken up by the Ministry of MSME, Government of India, to help our MSMEs. Now, Government of India as a whole, if you look at the credit services, you will know that public sector bank loan initiatives at 59 Minutes portal that was launched in November 2018, and Pradhan Mantri Mudra Yojana that was also launched in 15, and the loan is up to ₹10 lakh, and TREDS, which is also, you are all aware of that, and also the ₹5 lakh crore emergency credit line guarantee scheme. So these are some of the very broad initiatives that Government of India has taken, keeping in view the importance of MSMEs, which plays a huge role in the development of our country. So we have shared our views, our comments with UNCITRAL also throughout our negotiation for this document. And we're very happy that you are here. And I'm very sure that today's deliberation, the various sessions, technical sessions that we're going to have, I think it is going to help especially the South Asia, and also we can learn from each other the best practices, and also help each other. We are also helping our MSMEs to export. So for that also, we have taken up one new initiative called Capacity Building for the First-Time Exporters. And here we are helping the MSMEs register with the export councils, and we are also helping them with insurance of their goods, and we are also helping them get their products and services tested for certification. So these are some of the initiatives also that we help our MSMEs come up so that we can also play a greater role in the global value chain system. Thank you very much, and yeah, I give time. Thank you.
So thank you, Ms. Mercy Apau, for providing a synopsis of the various kind of measures taken by the Government of India. In particular, I would actually say the kind of supportive measures. Supportive measures, incentive schemes, and the various categories of steps taken not only by the MSME Ministry, but even by other agencies like CTIL and institutions like that. I would like to have a slightly, maybe time, 15 minutes for interaction as well, for having questions from the audience. So I would request the other speakers to take maybe 8 minutes for their presentation. So let me invite now Ms. Hemlata Mahalingam, Advisor to the Regional Industry Director, IFC, South Asia.
Thank you very much. So I think we've heard a lot about the different MSME, the schemes that the government has, as well as how important MSMEs are for the growth of the country. Maybe I'll just take a little step back to try and quantify the extent of financing gap that the MSMEs have, and also probably list a few challenges that they face in terms of, as to why they face so many challenges in accessing finance, right? So we've heard various adjectives, and I think I'd like to adopt some of them, like MSMEs are really the backbone of the South Asian economy, and they are the lifeblood of the economy. So just to give some statistics, in India as well in Bangladesh, I think MSMEs, around 50% of employment in the workforce is employed is in MSMEs. MSMEs contribute almost a third of the GDP for India and almost 1/4 of the GDP in Bangladesh, right? MSMEs are actually incubators for entrepreneurship and innovation. They create significant job creation, and they are driving force for the economy, right? A World Bank study actually estimated that the financing gap, the credit gap for MSME in the South Asia region is estimated around US dollars 386 billion. So, so the gap is significant, but I'd like to focus on two specific sectors of MSME where the gap is very serious. One is for women-owned MSMEs, right? It is estimated that around only 30% of the women-owned MSMEs have access to credit, and around 70% of them do not have access to credit, right? And the other aspect is on the trade credit. MSME, especially when you're talking about export and trade credit, MSMEs, only 10% of MSMEs in the South Asia region have access to trade credit. I think these are two very critical shortfalls which need to be addressed. And how, what are the key challenges and why do they face this challenge in accessing credit? I think the first and the foremost is the collateral requirements. Most of the banks and financial institutions are only comfortable lending to MSMEs against collateral. And the smaller MSMEs and the very small MSMEs that Ms. Mercy spoke about do not have such collateral to give to, right? The second one is fairly complex application processes. They are, very complicated, require a lot of data and paperwork, many of which the MSMEs do not have, So I think there is a necessity to simplify this, right? A third very important aspect is that, both Mr. Kumaran and Ms. Mercy, they detailed the number of government schemes that are there for MSMEs. But at the ground level, there is a significant lack of awareness of these schemes of the government. And this actually impedes them from accessing the credit, right? If you look at countries like Nepal and even to some extent Bangladesh, the geographical spread where a lot of the MSMEs are situated in remote and hilly regions, and this creates a problem for them, right? But and maybe the last but definitely not the least is lack of access to digital infrastructure. We've been hearing since morning how important digital is for the growth of the economy, and the lack of access, lack of awareness, lack of education on how to use these digital infrastructures is again another limiting factor for the MSMEs to access the credit, right? I think given this, there is definitely a lot more that the financial sector can do to disintermediate savings into credit for the MSME sector. I'd like to probably touch upon a few of the things that IFC has been working on to try and help bridge the gap, right? And I will again here focus on very specifically two segments. One is the for women-owned access to finance for women-owned enterprises and access to finance for trade for the MSMEs, right? IFC's basic, we have a very large program on banking on women, where we have globally disbursed more than $10 million to women-owned MSMEs. This is across 150 investments across 58 countries over the last, I think, 7-8 years. In addition to this, today we have almost 30, in the financial institutions group in IFC, we have around 30% of all our investments is targeted towards financial institutions to support women-owned MSMEs. And we hope that by 2030, we are planning to increase this significantly to almost 80% of all our commitments, right? This is, in addition to investments, we also have a lot of advisory services. We advise more than 200 financial institutions across the globe on building specific targeted capacity building services for advisory to address the collateral constraints that MSMEs have, to build in health insurance products, as well as to build targeted products for women, with bundling up of services which they require. In addition to this, we also have a pretty strong suite of what we call as non-financial services, because it's other than access to finance. I think what the women-owned MSMEs need is really training. In some of the non-financial services that we do offer is online digital training platforms, coaching and mentorship, and we also have face-to-face kind of business academies to help these MSMEs and the women to understand the basics of finance and principles of business, right? In terms of trade, I think our basic trade platform is we have the GTFP or the Global Trade Financing Program, which I think since its inception, it has financed almost $66 billion of trade. A significant focus of this is on MSMEs. We recently also started what we call the Global Trade Supplier Finance Program, which is focusing on the supply chain financing for the MSMEs, but there's also a focus on climate and gender, that is women-owned MSMEs in the supply chain itself. In addition to this, I think as IFC, we have, we have invested in quite a few venture kind of investments, which focusing on the technology and the digital side, where we focus on platforms like digital platforms where more than 7 million MSMEs have gotten access through these digital platforms, access to both markets as well as finance, right? We have a platform, for example, called a Startup Catalyst. And India's largest B2B e-commerce player, which is Moglix, is kind of started off because of from the Startup Catalyst platform. I think one more point which I would like to highlight is in India we've been working a lot closely with the government to try and focus or give impetus to these micro SMEs, especially the women-based micro SMEs. So India is a huge success in terms of microfinance, but we've seen very few of these women who access microfinance growing and being able to be entrepreneurs in that sense. So we have a program where we are working very closely with the NRLM, which is the National Rural Livelihoods Mission, where the IFC advisory, the World Bank and the IFC advisory is working closely with NRLM in terms of capacity building, product design, helping in the underwriting of the MSMEs, helping the NRLMs and the state rural livelihood missions to digitize their platforms, developing a toolkit for graduation of these MFI women to micro-entrepreneurs. We also kind of working on connecting these MSMEs to banks so that they are able to access formal finance. I think I will stop here. Thank you so much for the opportunity.
So thank you, Mr. Hemaladi. In fact, I mean, the figures that you quoted is, pretty discouraging actually. So what you mentioned is that only 10% of the MSMEs have a proper access to credit. That is actually a disturbing figure. So what is actually lacking? I mean, from what you mentioned, even IFC has been doing a number of steps. Is the problem real in terms of communicating what you have, or maybe what the policy and other agencies have to the people who work on the ground? That may be a possible issue, because I mean, I will definitely give you more chance to respond to that thing, but I'm just trying to give you some provoking thoughts as well. So we need to really make sure that this gap has to be bridged through some kind of a proactive steps as well. The other important issue is actually the problem of, MSME finance market. So what we actually see is that there is a huge concern of a missing market in this area. So I would like to invite Mr. Jianqing Lai, Principal Operations Officer, to talk about the need for developing a credit market.
Thank you for your invitation, and good morning to everyone. So we have heard a lot about what the government had done to facilitate SME access to finance and the subsidies, guarantees, those kind of things. But let's not forget that the market will not work unless the market has the necessary soft infrastructure, the foundational infrastructure that is needed for the market to function. And this is often the most difficult part, and the performance overall had not been very good in the developing countries. So first I will indicate some figures about access to finance, or in short is A2F. And this is from the Enterprise Survey of the World Bank, which is one good database that is comparable across the economies. So as you can see that overall in Asia, the ratio of firms which has access to formal finance, or the percentage of firms that identify A2F as a major issue, on these two indicators, Asia overall is actually lower than upper middle income country. I am not saying it's lower than the developed country. It's only upper middle income country. So, and particularly South Asia's ratio is quite low. So why there is such a difference across economies in the degree of their A2F, or access to finance? It is mainly a problem of enabling environment. It's not that lenders don't want to lend or borrowers don't want to borrow. They are all the same across the economies. And this has mainly to do with the activeness of governments in building the soft infrastructure, which we normally say financial infrastructure. It basically means the legal infrastructure. And the activeness of the law and rule-making authorities. And these are typically not the Ministry of SME. These are typically the judicial authorities, which is the main audience for today. Now, the so-called enabling environment can be characterized by three layers of elements. So at the bottom is normally the need for financial infrastructure or legal infrastructure. In the middle, these are the sector capacities and the regulatory permissions and the frameworks. And at the top one, these are competency, governance of the financial institution. So today I will only focus on the bottom one. The so-called bottom one, in common sense, it means collective arrangements that are necessary for the market to function properly. But this cannot be done by one or two financial institutions alone. You will need both the government and the sector-level organizations to do it. So, but why these foundational things are necessary, going beyond subsidies, guarantees, expos, those kind of things, is fundamentally because any lender, any creditor and debtor relationship is so difficult. They are not a normal business relationship. Fundamentally, there are four issues which cannot be overcome by lender or borrower alone. I will not explain what they are. You can see in the slides. These are information, like how do I know you have capacity to pay? Incentive, which do not mean subsidies. This is a theoretical word. It means how do I know that the debtor will be willing to pay, even if the debtor has cash flow. And then transaction costs, and then exit mechanism. So how do I exit if there is something wrong? If an economy cannot provide adequate arrangements on all these dimensions, do not expect that your SME finance will be good. I'm only talking about commercial finance, which means SME finance, excluding micro, which is retail finance. In retail finance, the requirement is small. So there are three fundamental infrastructure that are necessary to overcome the 4 difficulties that I mentioned. And one is a credit reporting system. And going beyond that nowadays, the economy will need a third-party data and analytics framework to enable the industry to grow. So there are 2 data. One is credit data, which means credit bureau data. The other is non-credit data, means any other data that are necessary for the credit assessment. The second one is the so-called secure transactions system. This means, as a lender, can I use movable asset efficiently as a collateral? Remember, collateral is not about collateral. Collateral is about information, incentive, exit, and transaction cost. So in business lending, about 80% of all the lending will be collateralized. Nothing wrong with that. The only problem is what collateral you are taking. If you always ask for immovable, that's a problem. If you ask for movables, that's good. So the other one is the insolvency system, which means the exit mechanism. So in economies where this work is done very well, and if the regulator and SME promoters are active, in the past several years, a new regime for SME finance had already emerged. Under this new regime, there is no more difficulty about acceptable collateral, no complaint about financial statements, and no complaint about arbitrage behavior, transaction costs, etc. So such a new regime consists of 3 elements. Number one is mostly based on receivables and inventory, which is the main part of movable asset. And if you do that in an organized way, that is called supply chain finance. And there are numerous e-platforms that have emerged for this space. Larger economy has several thousand e-platforms. So in India, you have the trade receivables discounting system, which is a very good initiative. And the second element is an expanded use of data and data analytics, going well beyond credit bureau data and the emergence of ecosystem lending. Not only e-commerce, but also include things like franchise system, property management system, and etc. And the third element is the increased use of non-traditional and non-FI debt investors. This matter is no longer about banks. It's no longer about licensed financial institutions. Any entity in the economy, any individual, if you are qualified as eligible investor, if you have surplus funds, you are SME lenders. So let's not just look at banks. So there are several cases. So one case is we have a client which has developed an automatic lending solution for SMEs. This is not micro. So these have been used by a certain number of banks. 100% automatic is data and analytics driven. But the condition is that you will need to have a framework for the use of the third-party data. Often developing economies do not have. Another example is all these different kinds of receivables finance platform, inventory finance platform, or supply chain finance platform. They have created a wonderful new ecosystem to enable financiers that are well beyond banks to participate in the financing of business and SMEs. So it looks more or less like this. Given the time, I will not go into explain, but there are several parties here which on the electronic platform enable other players to do it. So suppose I am a high net worth individual, I can easily go on such platforms to buy receivables. When I buy receivables, I actually finance SMEs. Pension funds, foundations, NGOs, debt investment funds, whoever they are, they can easily finance receivables or inventory. So thank you. I will pause here.
Thank you, Mr. Lai, for a very, very interesting presentation. So, if you really look at the law and development literature, there's a basic school of thought that the markets are not actually self-created and self-developed. They may not even self-sustain for that matter. So that is why it is extremely important for the governments to have, for the governments to really take efforts in creating these kind of institutions in terms of providing the enabling environment for that matter. So we don't have too much of time. We have only 9 minutes left. And I would like to give 5 minutes for a Q&A. But I just want to have one quick reply from all the panelists. So given the kind of issues that you have highlighted now, what can be done? I mean, what are the one or two priority areas where you think we can actually spend our attention and our focus?
So in South Asia, one area that has not yet really developed well is the efforts and the energy to do financial infrastructure reform. This means legal foundations for the financial sector to function. So compared to East Asia and Pacific, or Eastern Europe and Southern Europe, the efforts in South Asia is not sufficient. And these are areas that is very, very difficult, and Jason also mentioned it. So without strong leadership, it's not going to happen. You will need the legal community to support. And these are new legal framework, new legal ideologies, which the existing legal professionals may not be familiar with. And typically, legal workers, of course, they are very strong. They have strong opinion. So it's not very easy to move these kind of things. And so far, the performance has not been very good in this area.
I think it's from South Asia, more specifically in India and Bangladesh, I think it is the formalization of the MSMEs that is really very important. There are so many MSMEs which are operating at very minimal or subsistence levels and more like microfinance. I think what needs to be done is to how we can kind of graduate these micro enterprises to medium enterprises and to small enterprises. That will actually give a huge boost to the job creation and the growth in the economy.
Thank you. I also echo with Hamlata. One of the gap that I can think of is awareness. We are doing a lot of awareness at the Ministry of MSME level by not only engaging the social media platforms and also having a special campaign, but we are also organizing state-level conclaves. And wherever the MSME pockets are, we are also going there and then conducting conclaves. But we are also trying to also synergize with all the related ministries, not only the MSME in silo, but also all the related ministries together, creating synergy. That is also one of our focus activities. And we are also engaging banks, because bank officials up to the district and sub-district level is so required. So the lead banks and their officers, we are also trying to build capacities for them. And we are also having monitoring meetings, review meetings, so that this kind of initiatives, programs reach out to the last mile. These are some of the initiatives that Ministry of MSME has taken, and I totally agree, awareness and support hand-holding, especially we have Samarth initiative, which is focused on women. All the participation in domestic, international fairs, 20% are reserved for women. We are having special Udhyam registration because bringing them under the formal umbrella is very, very important, because that enables them to access the various benefits that government has for them. So formalizing the MSMEs, that is one of our initiatives also, and we are giving a lot of focus on those.
Thank you. I think I'll just follow what Jinchang said. I think legal reform, legislative reform is very important, but I think I just want to highlight the need for intergovernmental coordination. When you talk about secure transactions reform, you think that it's for MSMEs, so the Ministry of MSMEs are relevant. But it's a legislative reform, so the Ministry of Justice is informed. And then, but since it's about the financing market, it's the Ministry of Finance that's also relevant. Unless there's a strong push within the government actually to coordinate the efforts and to push for such efforts, such a legislative reform is not possible. And that is why, while we call for legislative reforms, I would also call for coordinations among the ministries to actually get together and make sure that this legislative reform results in a successful reform as a whole. Thank you.
Thank you all the panelists. Now we have got around 5 minutes for our questions. So I would like, we can only take 4 or 5 questions maximum, please. Announce your name and keep it very targeted and precise. Yeah, the lady over there.
Good morning to the distinguished dignitaries, ladies and gentlemen. I'm Ananya Tyagi, I'm an advocate. So my question is to Ms. Mercy and Ms. Hemlata. Women-led MSME in India are currently facing funding challenge, especially in the Tier 2 and Tier 3 cities, because they don't have enough awareness about the digital lending space. Post-COVID-19 pandemic, the most of the women-led MSME have unfortunately phased out. What policy change can be made to cater this issue specifically, apart from the HRLM? Thank you.
We will actually take 1 or 2 questions more. Yeah, the gentleman over there, in the middle, yeah.
Thank you. Namaskar, everyone. My name is Piyush Pandit. I'm a 4th-year law student at NLU Shimla. I also run one of the 6 crore MSMEs here in India. My question is to Mr. Lee. You said initially that MSMEs do not have a standardized even definition throughout the world. I would like to ask you, as a legal officer from UNCITRAL, how do you formulate legal texts, for example, the model law on secure transactions or the guide to access to credit, so that the regulations are formulated in a very harmonious and uniform manner? Thank you.
Thank you. We have one more question from over there. The one who raised the hand first. Yeah, thank you.
Good morning, ladies and gentlemen. Good morning to all the dignitaries present on the dais and off the dais. Sir, my question is to Mrs. Hemlata. Ma'am, you talked about training programs given to women by IFC. However, when you stated the fact that 30% of the women do not have access to credit in their own MSMEs, so do you not think that it is actually correcting the mindsets of the people who are leading these women to not have access to credits, rather than to ask women to attend the training programs? And if there is any change which is brought by the training programs, what is the change and what is the statistics that have been stated by the training programs? Thank you.
And now we will actually give the floor to the panelists.
Thank you. Thank you for the first question. For the women, I know digital literacy and also financial literacy is one of the biggest gap that we keep hearing. And so in our training schemes, under our training, various training initiatives, schemes, programs that we have, we are also trying to engage the women associations and also other trainers who can also identify women entrepreneurs to come, and we are giving special hand-holding support to the women, especially for accessing credit, number 1. That is why UDM registration is very, very important. Our special focus is on women when we carry out our UDM registration campaign. And if you talk about the credit, PMEGP, as I said, that is our flagship program. 35% of subsidy is given to women, SCs, and STs. And so that's higher, because for the others, it's around 15%, 25%, different subsidy rates are given. Digital literacy, we have been hearing a lot from a lot of women associations. So we have taken that, and we are also engaging the training institutions to give these two particularly, digital and financial literacy, to the women.
On the question about harmonization, as a body responsible for harmonization of international rigorous standards, the texts that are prepared by UNCITRAL are not jurisdiction specific. They are prepared by the working group so that they actually can apply regardless of the legal tradition and regardless of the economic development. And I think in particular, we had this difficulty in working group 1 because MSMEs are considered quite differently in different jurisdictions, and that is why we try to avoid defining MSMEs, but try to kind of look at the common characteristics regardless of where they are, and then try to address the problems that they face in accessing credit. That is how we approach the issue.
Thank you.
Yeah, thank you very much for the questions. I'll first try and address the question on training. It's very, financial literacy is very important for women-owned MSMEs to get access to credit. It's financial literacy at its basic, as well as the second point to address is also awareness of all the schemes that are there. So we try and address this through two ways. One is when we are working with our partner financial institutions and banks, we insist on at least some percentage of the lending to MSMEs to be specifically to women-owned MSMEs. And when they lend to the MSMEs, they have to go through certain basics to understand that, like for example, some of our clients require that the underlying client has an UDYM registration. So automatically it kind of feeds in, basically takes in from the, or rather, adds to the effort that the government is making to get these registrations in place, right? So in such a way, that's one way of ensuring that these women get educated and aware about the schemes. And the moment they become formally registered, their access to a lot of schemes opens up. That's the first point. The second point is some of the initiatives that we do are through, like I mentioned earlier, the non-financial services. So again, we tie up with our partner institutions and partner banks to offer tailor-made non-financial services for the women-owned enterprises that they finance. And these can be many things, like for example, it can just be a whole digital training module on what are the benefits available to women-owned MSMEs. It could be on how to make your income tax filings or how to make your GST filings online. So it can be very small things, but this goes a long way in helping them because their digital footprint increases and there is more digital data available on them, which will kind of open up doors for different ways of financing for them, right? The other thing is, it's not really to say instead of asking women to take training, why don't we change the mindset? So if mindsets could be changed so easily, we would be somewhere else. It's a long process to change the mindsets. And we try and do this indirectly through whenever we are doing the financing to insist on women-owned financing, right? So the one particular aspect that comes up is really collateral. Still today in India, I would say 95% of all financing is collateral based. There is very little unsecured financing. And many women do not have access to collateral. They do not have property. So when we are doing housing finance or, access to low income housing, again, there we insist on women being at least a part owner of the property. That gives them access to some collateral. So these are small baby steps that we are taking, but it will kind of, it also kind of dovetails with what the government is doing. In many states, you have lower stamp duty if the woman is a part of the collateral. So these increase the access to collateral.
Mr. Lai, anything?
So if you look at the figures I just presented, so typically in developing countries, only 30% of SMEs has access to finance. The question is asked this way. In the last year, do you have a bank loan or line of credit? Yes or no? So in the developed country, it's normally 50% to 52%. In developing countries, it's normally around 30%. In South Asia, I think is 21%. So in East Asia, is around 29%. So there is indeed a gap there. So let me emphasize again that those gaps are actually not because of not enough subsidy or credit guarantee, those kind of things. Not because of those. It's mainly because the foundational infrastructure, the legal infrastructure is not really there. So, and those kind of things are most difficult. You will take time, and you will need the cooperation between the legal side and the government ministry and the private sector. So we have been doing this kind of work for some years. And in some countries have been very successful. In some countries, it's just never move. So this is really the hard part. So once this is resolved, then the other things they will naturally come about. So if lenders always ask for immovable land and building, you are not going to solve the problem. So, but if they are flexible to use receivable inventory, other movable assets which produce transactional data, then the things will be much more beautiful. And now this kind of work is all based on electronic platforms. It's very easy.
Thank you, Mr. Lai. So in fact, we're coming to the end of the session. I would like to have one more session, one more round on questions, but we don't have time. We are really running out of time. So what I feel is that we had a very insightful and very comprehensive discussion on a range of issues. What we really learned from all the participants is basically the constraint faced by the MSME sector, not only in India, but within the South Asia region and beyond. And we know that, I think one point that came out very clearly is that in order to provide access to finance, there is a greater need for formalization. So once you are actually formalizing the sector, you're bridging the gap between the MSME, the entrepreneur, and the banks or the financial institutions for that matter. And there is also a greater need for participation of the enlightened community, like the lawyers in this framework, because ultimately, this is a very complex transaction. This involves financial transaction. It is a money transaction. And no bank would like to lose the money. And at the same time, the MSMEs or the startups should also get easy access to finance. And that is very important for an innovation-oriented economy. So in that regime, we need legal institutions. We need better laws. We need more harmonization with respect to laws, and a better framework and a securitization structure which can basically underpin these transactions. So thank you very much to UNCITRAL, the Ministry of External Affairs, and UNCCI for giving us this opportunity. Let us give a big thank you and a round of applause for all the participants.
I request you all to kindly gather for a group picture. Thank you all for your expertise. It has given us a great insight on access to credit, especially access to credit for women in MSME to get through collateral issues, seed funding, and other issues regarding trade, and also how UNCITRAL regulations can help in the same. Friends, it's now time for Chai Pe Charcha. Please proceed for the coffee break and carry on the conversations over a brewing cup of coffee. I request you all to kindly join back at 12 p.m. for the next session, which starts in 20 minutes, on ADR in the context of addressing financial difficulties and the role of courts. Thank you. Of this session. I would also like to call upon Ms. Samaira Maisuyuwa, Honorable Miss Justice Indu Malhotra, Honorable Mr. Justice Anselmo Remes, and Ms. Mega Kinnear. Friends, Justice Arjun Kumar Sikri is an eminent jurist, former Justice of the Honorable Supreme Court, and a prolific arbitrator, and also an author. As a judge in the Supreme Court, Justice Sikri authored several key judgments dealing with aspects of arbitration. Since 2019, he is an international judge at the Singapore International Commercial Court and Singapore Supreme Court. He was sworn in to the post by President of Singapore. He is also the chairman of News Broadcasting Standard Authority. Not long ago, his book, Constitutionalism and the Rule of Law, was released and got an overwhelmingly support from the crowd in New Delhi. Over to you, sir.
Thank you very much, and good afternoon to all of you. I hope that others also who are still having their coffee would be here in a couple of minutes. But notwithstanding that they are absent, we have to start our session on time. That is absolutely essential. In this session, we are talking about alternate dispute resolution in the context of addressing financial difficulties and the role of courts. Now, when we discuss about the financial difficulties, it is the enterprise which is facing financial crunch and maybe at the cusp of insolvency. So how in that difficult situations of that enterprise, alternate dispute resolution can salvage the situation. That would be the theme of the discussion in this panel. Let me say some few introductory remarks in the process before I go to the panelists, that whenever a particular enterprise is facing financial difficulties and maybe at the verge of insolvency, as I said, it has three different dimensions. On the one hand, the promoters of that particular enterprise or the company, they are striving hard to revive the company, to bring it back to its original position or bring it out of the financial difficulties. In the process, maybe they have to take care of the creditors and other stakeholders. On the other hand are the creditors who are thinking that this company may go insolvent any time. We have invested a lot of money in that. There may be, invested financial creditors, there may be operational creditors who have supplied goods and material and have to recover a lot of money. They think that, look, we should be able to salvage our situation and our position, and we should be able to recover as much as possible, which is their legitimate interest. In these two competing interests comes the third interest, that is the public interest. Because any enterprise or any company, it may be in production, it may be in services, so it contributes to the economy of a nation, and at the same time there are issues of employment, production, services, which may be affected if the company is ultimately wound up. So we have laws, insolvency laws, in almost all jurisdictions. UNCITRAL, as we'll come to and mention, that has also come out with model laws on that. And the systems are either, we call it creditor-dominated or debtor-dominated system, that during that period when it's a twilight zone for that company, what should happen? And as we know, normally and if I may say, for the sake of simplicity only, in the context of insolvency and bankruptcy code, when a petition is filed and it is admitted, there is a moratorium, because it is our system now that this particular law is a creditor-dominated law, so therefore the erstwhile management would be ousted, insolvency resolution professional would be appointed who will take charge, and then he will try or she will try along with committee of creditors to come out with a resolution plan for turnaround of the company. If that happens or that is feasible and gets the imprimatur of the National Company Law Tribunal, then the company would be revived, but it can go to somebody else's hand. At least the company would survive or would be revived. If that is not possible, it will go to liquidation. But in the meantime, the moment petition is admitted, there is a moratorium insofar as the third party claims are concerned, they can't proceed with. So in this whole process, time becomes the essence, which is stated in the IBC as well for each process. And to, take into consideration the interest of all the stakeholders. Normally, the system is, which is in IBC as well, and almost in all insolvency regimes, that it is court-dominated, court, or insolvency court we can say, or tribunals, etc. They look into all these aspects. And it is expected that there would be a fair resolution. As far as creditors are concerned, it would be equally, there will be equal distribution if insolvency takes place on pari passu basis, etc. Now, many times, and we have seen in India also, these timelines which are mentioned in IBC, they are not met for various reasons. May not necessarily be attributed to the lawyers or the parties or the tribunal's efficiency, but I need not go into all that. And in a regime, as I said, where the time is the essence, then and the resolution is not coming into effect in minimum possible time, it may have far-reaching consequences. In this whole process, I would say alternate dispute resolution mechanism or the mediation in particular, they become important. And it is now of late realized that they may be instrumental in taking care of so many of these situations. And therefore, mediation in insolvency-related cases is now gaining momentum. For last couple of decades. Although mediation has been there in America, we know it started almost in 1960s. In late 80s, it was introduced or, experimented in insolvency also, but did not gather much momentum. But in last few years, we have been thinking of so many advantages of mediation in this whole process. And other, in some circumstances, even the arbitration, the ADR. There's some of the disputes which may be better resolved through arbitration. So this would be the theme, and around that there would be many questions. We have very expert panel here, Justice Indu Malhotra, former judge of the Supreme Court of India. We were colleagues there. And you know, she has authored books on arbitration, and today well-known domestic and international arbitration, who is so much busy with arbitration work. And we have Justice Anselmo. He is my colleague today in SICC. We have done together arbitrations as well. In one case, award is given about a month ago, where Justice Anselmo was the presiding judge or the chairperson. We have Meg sitting on the extreme left of my, and she's very well, known as far as ICSID arbitrations are concerned, which relate to bilateral investment treaties, to which we'll come to, and we'll try to connect the today's theme with ICSID or BIT arbitrations as well. And we have Samira, who represents UNCITRAL, and she has been there, I think, since 2004, if I'm not mistaken. She is associated with UNCITRAL and has rich experience, because UNCITRAL role in ADR, if I may say so, has been tremendous, and the kind of model laws which it has come with, in respect of insolvency only I am talking, and that would be also a matter of discussion and would throw tremendous light on the ADR methods in insolvency. So with this background, let me first turn to Justice Indu Malhotra. You see, if I may say before asking you the question, that as I said about the mediation in, generally, we may say so, I may refer to the Pound Conference, where Harvard professor Frank Sender, he introduced what he called, in inverted commas, if I quote, multi-door courthouse, and encouraged looking for different dispute resolution methods. And he emphasized that we should look for alternate doors, and there is a rich variety of different processes which singly or in combination may provide for more effective conflict resolution. So he was mentioning 3 basic pillars of ADR here. First, different doors. That is, its court is not the only system whereby the disputes can be resolved. Secondly, those mechanisms can be used singly or in combination, where it is very, very important. We know our Section 89, it's court annexed mediation. Even when the matter comes to the court, it can be referred for mediation. And likewise, we have introduced, and in ICSID, Meg will throw light on that, methods, etc. And thirdly, what he was mentioning, that it must be effective. So how to choose a particular method to, or a particular door, which door we should enter in order to see a particular situation and how best it can be resolved. So with this, my question to you is, are there characteristics of arbitration and mediation, which are the 2 main forms of ADR, that make them more or less, either more or less suitable as means of resolving insolvency-related disputes? In other words, what according to you are the main advantages of both forms of ADR in insolvency cases? And I'll like you to throw some light on this aspect when we are talking about arbitration, and you are also author of one of the judgments in the Supreme Court that some of the matters are not arbitrable. So are there any aspects of insolvency disputes which may not be arbitrable? So please, over to you.
In most jurisdictions, the adjudication of insolvency issues is normally entrusted to specialized courts or tribunals. In India, we have the National Company Law Tribunal and the appellate body, which is NCLAT, that's the National Company Law Appellate Tribunal, which have been given overriding effect over all other statutes to decide on issues of bankruptcy and insolvency. Now, insofar as mediation, etc. is concerned, now even though traditionally it's always been entrusted to these tribunals, but I think in the last 5 years in India, or even a little more, there has been recourse taken to mediation. It's also been taken with respect to arbitration of subordinate rights. The main issue, if it's of insolvency, that's an in rem issue, which affects the public at large. So that is not arbitrable. It's to be adjudicated by these tribunals. But if there are subordinate rights which emanate out of a proceeding which is in personam, that is between two parties, inter-parties, those have been referred for arbitration. And I'll give you an example. Currently, there is this company which is ILNFS, which had gone completely bust, and there were huge amounts of claims which were made by thousands of parties. So the National Company Law Tribunal appointed a retired judge to prune all these applications, and he has successfully done it within a short period of time. So at various junctures and points of time, it is mediation or, different aspects are being explored and which have worked very well. Now, within this ILNFS company, the government superseded, the board took over because of the large impact on the public. And there were also companies, group companies, which then made an application before the NCLT and said, we have recoveries to do on behalf of consortiums. So those were referred to arbitration. So arbitration, mediation are now being resorted to even in IBC proceedings, only if it's once, the Supreme Court in fact has recently passed a judgment, a 3-judge bench, wherein they have said that before the process starts, you can resort to appointing a mediator. In fact, Justice Sikri was appointed by the NCLAT, which he successfully settled between the parties, and the settlement was taken on record by NCLT, and an order was passed on the terms of the settlement. So prior to the CIRP starting, that's the insolvency resolution process, it can be resorted to. Now, the court has said that until it is admitted, the petition, because once it's admitted, it becomes an in rem issue, you can explore various modes to try and resolve disputes. Once it's admitted, then third-party rights come into play, and anyone can move the court in this proceeding which is pending. In fact, in cross-border transactions also, mediation has been resorted to. I'm sure all of you are aware of the Lehman Brothers and the Maxwell communications. In Maxwell, there were bankruptcy proceedings which were initiated both in England and the United States, and each country has its own national legislation. So an examiner was appointed to mediate and resolve conflicts amongst various national jurisdictions, and they were able to develop a coordinated plan and a scheme that harmonized both US and UK insolvency laws. Similarly, in the Lehman Brothers case, they had resorted to the process of claims mediation, which proved to be very successful. So cross-border insolvency issues also can be addressed by resorting to mediation. And of course, arbitration is, if it's in personam, of course, an in rem issue has to go to the tribunals. So this is basically now disputes which have been considered to be inarbitrable, which is common amongst all jurisdictions, are issues, for instance, criminal matters, marriage, testamentary cases regarding a will, then even with respect to the patents, grant of patents, trademarks, because they create an in rem right, these are not arbitrable. And in fact, Section 2, subsection 3 of the Indian Act specifically provides that if there are disputes which are covered by a special enactment, those will not be arbitrable under the General Act, but they'll be resolved under the special enactments which have been passed in that case. Mediation has been very successful because of the confidentiality of these proceedings, because parties do not want it to be disclosed or it to come into the public domain. Various information which is exchanged during the process of mediation. So confidentiality, flexibility to come out with out-of-the-box kind of resolutions has been very successful both in India and in cross-border transactions. So this is broadly the conspectus of the issues raised by Justice Sikri.
Thank you, Indu. And let me now turn to Samira. Indu has mentioned various advantages of ADR methods, mediation, as well as arbitration. So it becomes, in many ways, it's an alluring way to resolve the disputes. Yet there may be some difficulties as well, which she has also mentioned. And in the beginning, I stated about the three kinds of stakeholders which may have been, and particularly creditors and the promoters, which may have competing interest in the entire process. So insolvency dispute distinguished by public interest, involvement of numerous persons, ranking of claims, and strict rules for distribution of debtors' assets. In this whole scenario, is ADR a suitable way to reconcile all these differences? That is my question to you.
It doesn't. Oh, it works. Yes, thank you for this very complex question addressed to me, how to reconcile all of interests in insolvency proceedings. The area of insolvency law is one of, I guess, most difficult because it touches upon all other areas of law. This is where the judge has to really reconcile the different legislative regimes. But we should keep in mind that insolvency proceedings, those are collective enforcement proceedings, and therefore special insolvency rules apply to them, because there are certain principles that need to be respected during those proceedings, such as equal treatment of similarly situated creditors. And UNCITRAL promotes the use of alternative dispute resolution in different contexts when it deals with financial difficulties. The first one is the use of alternative dispute resolution in pre-insolvency or rather pre-commencement stage. And this would be regulated by UNCITRAL contract and commercial arbitration and mediation frameworks. But at the same time, insolvency law texts of UNCITRAL acknowledge that insolvency law may have multiple impact on that pre-commencement stage. For example, the outcomes of any mediation or arbitration may need to be considered by insolvency court if insolvency proceedings are commenced. How court would approach those outcomes? Avoidance proceedings may become relevant, and other issues that really pertinent to insolvency law framework. Then UNCITRAL also addresses the use of arbitration and mediation in the context of insolvency proceedings proper. And examples were already provided. One prominent example where alternative dispute resolutions techniques were used is negotiation of reorganization plan, when the different stakeholders' interests are involved. They could be employees, they could be creditors, financiers, major financial institutions, of course, the debtor. And in micro and small enterprises context, the involvement of a neutral forum is becoming crucial and very often employed by the court in order to ensure that the debtor is treated fairly. Because very often, micro and small enterprises, they simply do not have bargaining power to negotiate on equal terms with their counterparts. And mediation is valuable and other alternative dispute resolution forms because usually emotions are very, very high at that stage. The debtor losing its business, clearly if it wants to preserve it, it doesn't think that particular creditors may behave fairly, and insolvency practitioner wants to finish case as soon as possible. Creditors, as you mentioned, Justice Sikri, are preoccupied by grabbing as much as possible as many assets of the debtor, and employees, of course, are very much interested to preserve their jobs or at least to get something in terms of their salaries and other entitlements. So in this case, a neutral mediator may really be helpful because it not only provides neutral, impartial view, but also brings all these conflicting parties around the table and try to focus on the problem, on the needs at hand, and find mutually mutually beneficial solution. Whether that solution would be acceptable to the court, and here a public interest element is coming into play, that of course remains to be seen, because in the end mediated settlement would come before the court, and the court may exercise its public law powers to seek some adjustments or approve as agreed by the parties. So UNCITRAL text built many safeguards to ensure that mediation in fact works at the stage of insolvency proceedings. And the Honorable Judge also referred to cross-border insolvency cases. And UNCITRAL is very famous for its framework on cross-border insolvency cases. And in model loan enterprise group insolvency, for example, there is explicit reference that courts, one of several, if we are talking about concurrent insolvency proceedings, may in fact ask parties to go to arbitration if they agree, or may ask parties also to go to mediation. And there are many practical cases where indeed both arbitration and mediation were helpful in resolution of cross-border insolvency cases, including in negotiating of cross-border insolvency protocols, when parallel proceedings take place with respect to the same debtor, or in enterprise group insolvency context with respect to multiple members belonging to the same enterprise group. So I stop at this stage, and I may intervene later on. Thank you.
Thank you, Samira. And now let me request Anselmo to say something. Actually, only 3 days ago in Tokyo, we, Samira and Anselmo, we were there. It was a conference on insolvency, and Insol International, along with the UNCITRAL and SIAC, had organized that. And there was a complete session on ADR, or mediation, in insolvency proceedings, where Anselmo played a very important part. As I have been watching him, even in the previous Insol conference last year in London, we were together when it came to mediation in insolvency. So Anselmo has very rich experience, practical experience, insofar as mediation in insolvency is concerned. You would find that a recent study, it has revealed that there are 3 ways for resolving insolvency disputes arising from serious financial distress. One is out-of-court workouts. Then other is pre-commencement debt restructuring. And third is formal, that is reorganization and liquidation, which happens in the court. Now, in this scenario, this formal reorganization, liquidation in mediation, So in a my question to you is, in a multi-party dispute resolution, pre-mediation between the debtor and the creditors can efficiently resolve the case at hand and avoid a lot of cost. What are your views on that? Also, do you think that mediation has the potential to be the most preferred ADR methods when it comes to resolution of insolvency-related disputes, especially for MSMEs?
Thank you very much. I'll take the second question first. I suggest that mediation should be the preferred way of dealing with cross-border insolvency disputes in particular, especially between MSMEs, but it need not be confined to the situation involving MSMEs. So my first point would be, I suggest, contrary to what Samira just said, that arbitration is not really that helpful in a cross-border insolvency situation, because arbitration is basically a two-party agreement. Two parties agree to be bound by an arbitration award. But insolvency, as Justice Sikri pointed out at the beginning, involves numerous stakeholders, including creditors. And not all of them, in fact, most of them, will not be party to an arbitration agreement. There may be many arbitration agreements involved. Those will only be between one or other party, one or other creditor, and the company that is insolvent. So it's not going to help where you have a public element, where you have a lot of interested stakeholders. So that's the first point. What about mediation? Take one of the situations that Justice Sikri just outlined. Let's say that insolvency proceedings have begun. Under the UNCITRAL model law, Article 27, the judge in charge of the insolvency proceedings can appoint a person to assist the judge in the handling of the cross-border insolvency. So that person, we can call that person a mediator, can help to try to mediate the various interests involved. Mediation, in other words, is much, much more flexible because it can address multi-party issues. Now, the judge, using the power under Article 27 of the model law, can require the stakeholders before the court to engage in discussions with the mediator in order to try to narrow down the issues involved in the cross-border insolvency. The third point. Samira mentioned just a moment ago the possibility of avoidance procedures following a mediated settlement agreement. But there's an interesting factor when you have cross-border insolvency, or insolvency for that matter. Usually, if a scheme of arrangement is going to be agreed or ordered by the court has the power to order a scheme of arrangement, even though not all stakeholders, not all creditors, not everyone agrees to the scheme, to the proposed scheme. Usually if some high number, anywhere between 2/3 to 90% of creditors in a particular class agree to a particular scheme of arrangement, then the court will, having looked at the matter, order it. So in that sense, a mediated settlement agreement, in terms of coming to a mediated a scheme of arrangement, doesn't have to have complete agreement amongst all stakeholders in a cross-border insolvency. The court can order it, notwithstanding that there are a few people who oppose settlement, provided the necessary threshold under particular legislation is met. So mediation has this advantage over arbitration. Arbitration, let's say you arbitrate, you agree, you come to some conclusion. Well, take, for instance, the last point I make, the pre-insolvency state. As again Samira signaled, in many jurisdictions, India included, the insolvency dates is usually backdated from the time when the petition is presented. In most common law jurisdictions that I'm aware of, it is usually backdated to 6 months before the petition was presented. So if you came to some sort of arbitration award in that 6-month backdated period, that may not be ordered by the court. The court may say, well, that may constitute what is called a fraudulent preference, and the court may avoid it. If you have a mediated settlement agreement in that pre-insolvency stage, in that stage before the petition, and if you get a requisite number, the threshold number that I referred to, of stakeholders agreeing, there's a very good chance that the court will order such scheme of arrangement shortly after the insolvency commences. So it seems to me that there's every advantage to a mediation or the use of mediation in cross-border insolvency, or indeed even insolvency proceedings, as opposed to arbitration. Arbitration, I suggest, is limited.
Thank you very much, and I think that is a very valid point made when we discuss the merits and demerits of arbitration vis-a-vis mediation, and here how mediation is more helpful than arbitration in such a scenario. Let me now request Meg to intervene at this stage and as you know, in recent past, or rather last many years, bilateral investment disputes have caught the attention of various stakeholders. And there are various awards given by ICSID, which have raised some, I would say, eyebrows. We in India faced with that white, what was it? White Industries case. Likewise, there are some other cases also. We know, I mean, it may look to be something away from the topic we are discussing, but maybe remotely, if I'm able to connect, is that many times when the investor brings a dispute against a particular country, that investor is trying to salvage the investment which it has made, and if it is not, that investor is not able to recover, that investor may go into bankruptcy. I have seen one such case where I was in the arbitral tribunal, member of the, of course it was an arbitration case. But in this scenario, would you like to connect the ICSID disputes or bilateral investment disputes with the insolvency and how mediation helps in the whole process?
Absolutely. Thank you very much. And your point is well taken that we don't normally think of insolvency issues as international law, much less international investor state. But there are some overlaps or some links. Probably the main difference, though, is that what we've been talking about to date is where you have a court looking at insolvency, and that is the jurisdiction of the court. In terms of investment, it will perhaps be an insolvency or bankruptcy context, but obviously an investor state tribunal is not authorized to decide insolvency issues. Rather, they're deciding an investor state issue that arises in the factual context of an insolvency, a bankruptcy, that kind of a situation. So I'm going to bring this back a little bit to ICSID, and as I think most of you know, ICSID is the world's premier international investor state dispute settlement institution. It has done more than 70% of all known cases. ICSID has a number of ADR mechanisms that are available in investor state disputes. The most popular one, of course, is arbitration, and I would say about 98% of the cases are arbitration. But it has also had conciliation since the very beginning, so it saw the use and the utility of ADR-type mechanisms. In the last year, we have passed a new set of rules in 2022 after 5.5 years of consultation with our member states, and that included a standalone set of fact-finding rules and, most importantly, a standalone set of mediation rules. Now, if I can just talk for a moment about the context of bankruptcy or insolvency in terms of an arbitration in the investor state context. We have seen a number of cases where somebody has gone bankrupt and they then bring a case to an investor state arbitration. And you will understand that perhaps the typical way that this comes about is you have somebody whose sole asset perhaps was in a foreign jurisdiction and they are allegedly expropriated contrary to the provisions of a treaty. They become bankrupt as a result, and one of the things they may see as a recourse is to go to an investor state tribunal and to have an award made in their favor that there was an expropriation contrary to the treaty. And if they are successful, of course, the usual remedy is damages. They may be able to recover lost profits and damages if they were an ongoing established concern, or they may simply recover, for example, sunk costs. If they were a new enterprise without a track record, they may be able to recover sunk costs. But you can see that's obviously important both to the person that's become bankrupt and also to their creditors, that there now are some assets that they might look to. One of the interesting things that arises in this context, as well as in others, is the whole question of third-party funding, which is a very controversial issue right now in investor state. And one of the new items that was added to the new rules of ICSID was that there would have to be a disclosure of the fact of third-party funding. And so that would apply equally in the context of a bankrupt who may very well need some kind of funding to be able to bring their case forward before a tribunal. What I'd like to spend more of my time on is the mediation rules of ICSID, and these are the first standalone investor-state mediation rules. They are obviously tailored to be extremely flexible, and they may be available either because a treaty says you may or you shall mediate, or they may be available because the parties decide we would like to mediate, and so they make an ad hoc consent to mediation. The process under the ICSID rules was specifically designed to be one where if there is a successful resolution, that will be subject to the Singapore Convention on Enforcement of Mediated Resolutions. So it will be an effective resolution. And there is an alternative way to resolve these or to enforce these, and that will be if the mediation arises in the context of an arbitration, it can actually be memorialized into the award of the tribunal and would be subject to the simplified enforcement procedure that ICSID is so famous for. All of the mediation hallmarks under the ICSID rules are those I think you're well familiar with. So participation is voluntary, and obviously a mediation is only as effective or ineffective as the will of the parties to be a part of that process. It can arise in the ICSID context at any time, and one of the things that we thought of in particular in treaties, you have a provision usually called a cooling off provision, where before you actually get into a full debate between the parties, you're expected to have a consultation, a discussion, and give a good faith effort at resolution. And we thought that in many instances, mediation might be a very useful tool for parties before they actually get into a full-blown arbitration. So we made the rules flexible so that they could happen before a formal proceeding is taken, but they may also happen during that proceeding, and we have even seen times where parties get to a decision on liability and decide to mediate what are the damages or those kind of concrete outcomes from their mediation. The scope was also made very large so that it was very much available to parties, and so all of the normal issues you have in an ICSID case, things like nationality, things like jurisdiction, those are much less in the mediation context, and what really matters is the consent of the parties. The ICSID Secretariat will be supportive to the parties if they decide they would like to mediate, and they will help the parties to start up the process. If the parties would like assistance having a mediator or co-mediation, they can also assist the parties with that. Once the process is ongoing, it's very much a product of how the mediator would like to run that in consultation with the parties. So again, all of the tools you think of in mediation, things like caucusing, those kinds of issues, are all a part of investor-state mediation as well. And really the only key is that you are trying to, in good faith, get to some kind of a resolution of all or part of the dispute. In terms of cost, we have also tried to make this an inexpensive process because we want it to be very available to parties and of great interest to the parties. So we are starting to see that this is very attractive to parties, and we're starting to see increasingly mediations in terms of investor-state situations, including those where one of the parties has become bankrupt. So we're at the very early days of this, and I think one of the most important parts right now is technical assistance training, not only for mediators who might be in this circumstance, but also for counsel so that they will think about this as a realistic option to resolve their disputes, including insolvency disputes. So that's a little bit of how we think perhaps there would be an overlap in terms of investor-state dispute settlement and a situation with financial insolvency. Thank you.
Thank you very much, Meg. That was insofar as how ICSID is imbibing mediation into its entire system, which was up to now driven by only arbitration. It is quite encouraging to know that. And let us come back to insolvency per se and mediation in that. Here, I'm going to ask both Anselmo and Samira. Before that, let me tell you to the audience, many of us here who are sitting, they may not be knowing much about the cross-border insolvency, but they have fairly good idea of how insolvency and bankruptcy code in India works in respect of domestic insolvencies. And as I said in the beginning, the timelines which are stated in the code are very important, which are to be met in order to secure the interest of all the stakeholders. But that many times doesn't happen, and therefore mediation in the whole process becomes so important. There may be various types of cases which may erupt even after the case is filed, apart from pre-insolvency petition cases, but even after the case is filed. I have seen, and many of you who are, if you have the idea of working of IBC, would have experienced that when the CIRP process, resolution process is being worked out, many types of disputes arise. The applicants who file their applications for resolution, there may be dispute inter se. If application of one is accepted by the committee of creditors and ultimately approved by the NCLT, other may go up to the Supreme Court. We have seen these things. There may be disputes about the creditors inter se, about what kind, in what categories they should fall, whether they are the secured creditors or otherwise. Those disputes arise, and they want, before the resolution process is settled or it is formalized, no, the NCLT should decide these kinds of disputes. And therefore, my experiences and few cases which I have done of insolvency mediations, that in such cases, if the disputes, instead of NCLT deciding this dispute by adjudicatory mode, then the matter taken up to NCLAT and then Supreme Court, if these aspects are mediated, they are capable of mediation, and mediation brings wonderful results. So after giving this kind of small introduction to how in IBC mediation can be introduced, let me now focus more on cross-border insolvency, to which earlier Anselmo and Samira both alluded to a bit. But here what I am trying to say is that UNCITRAL has come with model laws on this. First was model law on insolvency itself way back in 1997. And based on the cross-border insolvency law, many countries have already legislated. Of course, Indian IBC was enacted much later in 2016, but we have still not introduced the chapter on cross-border insolvency. But anyway, that is the first law. Second is UNCITRAL model law on recognition and enforcement of insolvency-related judgments, which we call this, how the insolvency-related judgments are to be recognized and enforced, etc. That 2018, and then in 2019, another model law came. So having regard to all these model laws, then could you please provide us a real-life example first, Anselmo, as to how these have worked in, and ADR is used in resolving these kinds of disputes where there are so many parties from so many different countries, so many different jurisdictions, etc.
Thank you very much. I'm afraid I can't quite provide a real-life example, because I think the use of mediation in cross-border insolvency cases is just beginning, and perhaps not much experience in it. You referred a moment ago to various model laws that UNCITRAL has prepared in connection with cross-border insolvency. Taking those model laws, my concern is this. Assume that you have a mediation along the lines that I suggested earlier. Assume that the mediator or co-mediators have managed to achieve a settlement or a scheme of arrangement that 90% of the creditors, or 90% of creditors in every class agree to, but there's a 10% dissenting minority. Assuming that the court, and let's assume for the moment it's a court in the center of main interest, something called the COMI, has sanctioned, has agreed to order that scheme of arrangement so that the 10% holdouts have their dissent overridden and they must abide by the scheme of arrangement. Now, an attempt is made to have that scheme of arrangement as ordered by the COMI recognized in some other jurisdiction. My concern is if that other jurisdiction applies the model law on cross-border insolvency-related judgments, the recognition and enforcement of insolvency-related judgments, then there is scope in Article 14 of that model law for the court of the enforcing court to reopen the scheme of arrangement that has been approved by the COMI, by the Center of Main Interest. Even though there has been a substantial number, a substantial percentage, 90% in our example, agreeing to it, the 10% minority can still raise issues, whatever issues along the lines that Justice Sikri just commented on, raise issues in this non-COMI, non-Center of Main Interest jurisdiction in order to resist recognition and enforcement of the scheme of arrangement there. So in effect, you reopen the whole matter, the whole cross-border insolvency because of a disgruntled small minority. Now, there are ways of dealing with this, but I'm not sure that the commentaries to the UNCITRAL model laws go far enough in dealing with this. If you look at the other model law on mediated settlement agreements, in particular, if you look at Article 20, that allows for a stay of a mediated settlement agreement pending concurrent or parallel proceedings. And if you look at paragraph 48 of the commentary there, the commentary says a mediation is good for insolvency proceedings along the lines we've been discussing. But it seems to me that there's a contradiction because on the one hand, you say mediation is good, mediation is encouraged. On the other hand, every step of the way, especially enforcement in some other jurisdiction, you're allowing the possibility of reopening the whole package, the whole agreement, mediated settlement agreement that has been ordered as a scheme of arrangement. And I'm not sure that the commentaries to the model law, especially in relation to cross-border insolvency, give enough guidance on how courts should deal with this. But perhaps that's a question addressed by me to Samira.
So that's why I said in the beginning my question to both of you, because I knew when Anselmo is going to raise some interesting issues. So Samira, how you answer these?
Yes, indeed. This is one of the delicate issues that UNCITRAL had to tackle when it prepared model law on recognition and enforcement of insolvency-related judgments. However, the issue is not new, I would say, so it's not just pertinent to that model law of 2018. So let's look back at what happened when model law, the first one on cross-border insolvency, was prepared. At that time, there was no such thing as cross-border insolvency cooperation and coordination among courts, and also, except for maybe a few, and also on the basis of committee, and mostly it was territorialist approach to insolvency matters, meaning that courts simply defended their territorial local interests and considered each insolvency proceeding as local, territorial. And UNCITRAL tried to change it by adopting model law on cross-border insolvency in 1997. And there, as specific to mediation, and Anselmo already mentioned that, there is Article 27A, which says that the appointment of a person or body to act at the direction of the court is considered to be for the form of cooperation contemplated by the model law. So one of the principles of the model law is indeed cooperation and coordination among courts across borders in order to achieve the common goal. And the common goal is indeed to rescue business as much as possible. However, different jurisdictions, of course, take a different approach, and some indeed protect until now local interest, and indeed until now take more conservative territorialist approach and are not even prone to accept modified universalism, which is promoted by UNCITRAL insolvency text. Practice guide, this is a text that implements model law on cross-border insolvency, talks a lot about how cooperation and coordination among courts may be achieved. And here again, it highlights that a mediator may assist parties in parallel insolvency proceedings to negotiate a framework or protocol for cooperation or coordination across jurisdictions. It also highlights that those protocols themselves may define terms of resolution of the disputes that may arise between or among proceedings, whether between or among insolvency representatives or between or among creditor committees. And indeed, in practice, there were examples of cross-border insolvency protocols that referred to mediation and also arbitration of particular issue in that context, especially in complex enterprise group insolvency cases when one, for example, needs to arbitrate how proceeds would be distributed after realization of assets of all entities of an enterprise group. Then came about, indeed, model law on recognition and insolvency, recognition and enforcement of insolvency-related judgments, and it is broader in scope than model law on cross-border insolvency. Why it's broader? Because it covers judgments not only originating from main, as Anselmo mentioned, COMI jurisdictions and then main, but also from other jurisdictions. For example, where insolvency proceedings may commence just on the basis of location of local assets. So this shows how difficult it was to negotiate model law on recognition and enforcement of insolvency-related judgments, and how a delicate balance was achieved among different considerations, including that in certain cases, the local court, receiving court, when it faces the need to recognize and enforce foreign insolvency-related judgments, it would again need to look at local public policy considerations. It would need again to look at how this would intervene and interact with locally opened insolvency proceedings. And those all issues are coming again into play, the same as in 1997 model law. And that's why you see Article 14 drafted as it is drafted. Indeed, it requires, I think, a little bit more study, and that's why UNCITRAL now promotes closer dialogue between Working Group 2 and Working Group 5, and between arbitration and mediation community and insolvency community, in order to study those issues a little bit deeper. And another issue arises from the model law on enterprise group insolvency, and this is where Anselmo disagrees with me that arbitration has maybe little place in cross-border insolvency proceedings, where we do have a specific reference in Article 9, again in the context of cooperation and coordination among courts, that says that indeed parties, the court may ask parties, if they agree, to refer their disputes to arbitration or compel even mediation. And this is another subject of discussion, difference between arbitration and mediation, and why this wording is found in the model on enterprise group insolvency. So only if parties agree, they can go to arbitration, but mediation could be, in fact, imposed by the court on them. And in digital insolvency context, for when we're talking about insolvencies of crypto exchanges, etc., this type of cross-border insolvency coordination and cooperation framework proved to be very, very pertinent and useful. Because, for example, FTX case, it's running across many jurisdictions, and Delaware Code in the United States cannot agree with Bahamas Code how digital assets should be distributed between two insolvency states. So cross-border insolvency protocol was adopted that regulates these issues. So I agree that there are many delicate issues involved, and UNCITRAL did it best to reconcile interests of different states that not necessarily embrace all modified universalism, but still it was faithful to that principle of modified universalism. Thank you.
No doubt UNCITRAL is trying to do its best insofar as to resolve some of these conflicts, etc. And when it comes to insolvency, yes, these three model laws, let us see how they strive towards mediation in insolvency, cross-border insolvency. With this, let me come back to India, again, hometown, and my last question, because time is running out, before we give floor to the House and question-answer session starts. I'll request Justice Indu Malhotra about the role of the courts. Let me tell you, in 2002, CPC, Civil Procedure Code, was amended and Section 89 was introduced. With this, mediation came into being. And many of you know, as it happens, mostly when such laws are passed in India, somebody comes forward and challenges the validity of the law. So this Section 89 constitutional validity was challenged. At that time, the advocates thought that this ADR mediation would amount to alarming drop in their revenues. So in that sense, and one bar association, Salem Bar Association, filed a petition in the Supreme Court challenging the validity of this. Of course, Supreme Court rejected that petition, but one good thing which happened, which normally doesn't happen in India, because many times laws are passed, but then they remain on papers. They are not implemented. But here, Supreme Court took the lead. Supreme Court, after dismissing the petition, ensured that mediation takes its roots in this country and not only its tribes. So therefore, they passed series of directions and then followed up also. If you know that you have read Salem Bar Judgment 1, Salem Bar Judgment 2, and the Supreme Court also created a committee known as Mediation and Conciliation Project Committee, which supervises the mediation throughout India when it comes to in the context of Section 89, because Section 89 is court annexed mediation. So this is an example where we can say that courts can play a very significant role in furthering mediation. So what role court can play when it comes to mediation in insolvency-related disputes?
Thank you. In India, in our IBC code, we have not made any provisions so far, in contrast with the Commercial Courts Act, where statutory mediation is provided at various stages of the proceedings. But in the IBC, this is where the court's innovative role has become very, very relevant. It's often seen that financial creditors in India or lenders in general are often very hesitant to go in for mediation because they would prefer to take recourse to statutory provisions to get their disputes settled. And here is where the role of the referral court assumes significance. The referral judge plays a most crucial role One is that at the stage prior to the insolvency petitions being admitted, that's the pre-insolvency stage, parties can be encouraged to go in for mediation. And very often disputes get resolved, so they don't need to undergo court-supervised processes of insolvency. Thereafter, once the proceedings start, at various stages, the courts can intervene and refer parties to mediation for individual disputes. For instance, they must motivate the parties to try and resolve it consensually rather than it going to, a long-drawn process where the target company cannot be revived, it leads to insolvency, etc. So there, they can encourage the parties, motivate them to go in for mediation. Then, even while the matter is before the committee of creditors, the creditors inter se may have several disputes as to who's to get priority, who's a secured creditor, who's an unsecured creditor, and inter se disputes between the creditors themselves. These issues can also be resolved through mediation. And as Justice Anselmo put it very correctly, it's amongst the ADR processes, it's mediation which has gained most success at the intermediate stages of the insolvency proceedings. Intercreditor disputes can be resolved. Then if there are third parties involved, for instance, suppose the estate on which the debtor company has its premises, its office premises, now it's a third party involved, that can also be mediated and settled out. So at various stages of the proceedings, depending on the nature of disputes or individual claims, for instance, in Lehman Brothers, it was individual claims which got resolved through mediation. It's at various stages that mediation can be resorted to successfully and disputes can be resolved, so a more equitable resolution of disputes takes place.
Thank you, Indu. And as far as Meg is concerned, we have asked only one question to her. So Anselmo is not happy with that. He wants to ask another question, so please.
I thought I'd give Meg a little bit of a run for the money. She referred to third-party funding. Now, does Meg or does ICSID have a position on this? The third-party funder is out to make a profit, like any other business. So is there a problem with a third-party funder putting together portfolios of the parties that it's funding? In other words, securitizing its third-party funding. It takes slices of individual cases, puts together these portfolios, and then sells them to the public as securities, so that it immediately makes its profit. Once it's got sufficient number of cases on its portfolio, it immediately gets its cut, and then it's not too concerned about the outcome of the case. And the actual funders become the parties who've bought into a particular portfolio of third-party funded cases. In other words, we're talking about the tokenization or securitization of third-party funding. This would be my concern as a judge. What would, or as an arbitrator, what would ICSID's position be?
We haven't had a position for or against third-party funding per se. That's something that's very well accepted, as you know, in particular in commercial arbitration and big commercial cases in many domestic courts. The point for us was that there was transparency about who was involved in the funding, so that the parties knew whether there was any potential conflict of interest. And certainly the point you raised was part of the debate among our states. A number of states feel third-party funding is critical to access to justice. And the example of the bankrupt who has no funds and couldn't even pursue what might be a very meritorious case probably is one example of why third-party funding can be very useful and important. There are other states who feel that it fuels non-meritorious cases. Now, I have to say, in the ICSID context, I don't see that argument because we have a number of other procedural devices, things like registration of cases that filters out cases with no jurisdiction, manifest lack of merit motions. So there are other more targeted rules that look to that kind of issue. But as an institution, we do not get involved or take a position on funding as long as the parties disclose who are the funders.
Thank you very much, Meg. We have still 5 minutes, so any questions audience wants to put to any of the, please tell your name and to whom the question is addressed to. Okay, please.
Good afternoon. Good afternoon, ladies and gentlemen. My name is Shantanu Pachahara, and I'm a professor of law at Rashtriya Raksha University. My question is directed to Meg. How would you elucidate and resolve the issue of predetermination of the claim value in mediation proceedings in cases of indirect expropriation, as that is often treated as an insurmountable challenge of successfully conducting mediation in ISDS claims, specifically from a state's perspective? Thank you.
If I understand your question properly, I don't think there is per se a predetermination of what might be called the damages measure or the value. That would be something that could be mediated, or the mediator has the ability to get, for example, a professional valuator if the parties agree on it. But we don't have any kind of a predetermination in the mediation context.
Please, you may ask.
Sundar Raju from Malaysia. This is actually to Mac and also to UNCITRAL. My country has gone through a horrendous arbitration called the Sulu arbitration. And we have actually expended considerable resources to deal with a third-party funded arbitration that completely went out of control. So I think in 2018, we tried to bring in legislation for regulation of third-party funding in Malaysia. Didn't work because the only jurisdiction that had it was in Singapore and subsequently in Hong Kong. So and my question is that what is the movement towards regulating third-party funders, and whether UNCITRAL will come out with some kind of model regulation or law to regulate such funding? Thank you.
1 minute, let this question be answered.
Well,
first, you answer your exit part.
I can try, certainly.
Samira
exactly.
will answer UNCITRAL part.
You're right that we're starting to see some domestic jurisdictions such as Singapore or Hong Kong legislate funders, what they need to disclose, how they need to be capitalized, and that kind of issue. So it would not be surprising if we saw that more and more frequently.
In the presence of my colleagues that serve as Working Group 3, ISDS reform, I think it would be appropriate for me to give the floor to the secretary of that working group. But speaking of third-party funding, I just want to mention that currently Working Group 5 works on asset tracing and recovery in insolvency proceedings, and there is one of these issues considered how much and what safeguards should apply for third-party funded asset tracing and recovery cases. But please, I would defer to Jay.
But I agree with Dr. Raju. It's a very important issue, and Selmo has also raised. UNCITRAL should do something into it. Many states are feeling the brunt of this because of this third-party funding. Apart from even in the private, arbitration cases, third-party funding is coming under lots of criticism. So it needs to be regulated. Yeah, anyway, yes. Any other question? One last question.
Good afternoon, everyone. I'm Meghna Sengupta. I'm a practicing lawyer with Claris Law Associates. This question is to Justice Anselmo and also Justice Malhotra, Justice Sikri. Just a question that it was greatly disheartening to know that even after maybe like the necessary threshold of a mediation agreement is agreed to, dissenting parties can kind of reopen the case. But is there a place for mediation where prior to the admission of an insolvency petition, after which the moratorium would be in force, to use mediation as a tool to crystallize the issues and also identify the creditors? Like instead of a full dispute resolution mechanism, but to crystallize the issues which then the insolvency specialized court would deal with?
Thank you very much. Yes, the answer to your question is definitely yes. But then you have to be aware, you said before the insolvency proceedings begin, there's usually a backdating of insolvency proceedings. I think that's true in India if it's 6 months before the petition. So what is normally done, or what can be done, is to have a mediation to try to resolve as many stakeholders as possible, get as high a number of stakeholders agreeing to a scheme. Then a petition is presented, and then almost immediately after, you can get the approval of the court. Hopefully it's the center of main interest. There may be problems if it's not the center of main interest. But if the court is the center of main interest and you get approval of the court soon after, then you may be able to resolve the insolvency or the cross-border insolvency pretty quickly. So yes, if you're interested, you can look at the practice of what is called prepackaging in jurisdictions such as the United States and in, I think, Singapore as well.
And in Indian context, if I may add, you see, when the petition is presented, and as Justice Nedumpara also said, before it is admitted, judge can call the parties and at that stage can find out what are the disputes, and the debtor against whom that company or establishment petition is filed, it can, because it is possible that one of the creditors has filed, but then it's not only that creditor, there may be other creditors, there may be other disputes, etc. And in Indian context, we now know even the, in the cases of these these property matters, etc., and the flat buyers and others, they are also now treated as creditors because of that amendment in the... So if all these issues are... Okay. So therefore, all these issues can be discussed and then can be sent to for mediation to the mediators. And Chair, you wanted to, wanted to say something. Please go ahead.
Brief, because we're actually having lunch right after this. Just in the context of the ISDS reform, not in general third-party funding, in October next month, the working group would actually be looking at a provision to regulate third-party funding. We're going a little bit further than ICSID, possibly not only requiring disclosure and possibly limiting some of the third-party funding in the context of ISDS. So it is in the program of the working group. Whether it becomes a treaty, whether it becomes a rule, we'll have to look into it, but there are plans for the UNCITRAL Working Group 3 to look into third-party funding regulations.
So it's good to hear that, yeah. So with this, we come to this session, and I hope you had enjoyed. At the end, I would say, I would quote first our former President Abdul Kalam, who said, "Discussion is an exchange of thoughts and knowledge. Promote it. Argument is an exchange of ego and ignorance. Avoid it." So that is, I always use it as promoting the mediation. And Mahatma Buddha said, discussions are always better than arguments, because an argument is to find out who is right, and discussion is to find out what is right. So let us strive for what is right, and then thank you.
Thank you all for this wonderful session. I would like you all to gather for a group picture. It was great how you enlightened us on the role of mediators, cross-border insolvency, introduction of mediation in IPC, and the role of our courts in solving some of the very specific problems. We have our next session on the regional perspective of UNCITRAL, but we would not want you to wait for lunch because I know you're keenly waiting for it. So please proceed for lunch, but we would want you to all gather here back at 2:15 because our next session will begin at that time. Or the speakers, panelists, and judge may please proceed to Shakuntalam for lunch, while all the other attendees may please proceed to Nalanda Hall on the ground floor for lunch. Thank you.
The Ministry of External Affairs. I'm honored to be your MC for guiding you through our post-lunch enlightening sessions. Our fourth session today is on the regional perspectives on UNCITRAL. I hope you had a chance to refuel yourselves. Of course, unlike lunch, our sessions are calorie-free, and you can indulge in guilt-free. Now let's tackle the afternoon sessions through a nap-free zone. We have a compelling schedule ahead, so let's get started. Please join me in welcoming on the stage our esteemed moderator, Dr. Prabhash Ranjan, and our distinguished panelists, Ms. Anna Jubin Brett, Mr. N. Venkataraman, Ms. Madhavi Diwan, Dr. Kamaleen Pinit Puvudal, and Ms. R.V. Anuradha. May I request the admin to get the chair above? Two more. It gives me immense pleasure to introduce our moderator for this session, Dr. Prabhash Ranjan, Associate Professor at the South Asian University. Dr. Ranjan is an accomplished scholar, and his illustrious career in academia is characterized by his remarkable dedication to the pursuit of knowledge and his significant contributions in the field of law. With an impressive academic journey spanning over numerous years, Dr. Ranjan has established himself as a prominent figure in the realm of legal scholarship. His expertise encompasses a diverse range of legal disciplines, including international law, trade law, and constitutional law. This multifaceted knowledge has earned him the admiration and respect of not only his peers, but students as well. Beyond his role as an educator, Dr. Ranjan has made invaluable contributions to legal research and publications. His insightful analysis and scholarly work have not only influenced the academic sphere, but have also had a tangible impact on legal and policy discussions. His profound insights and expertise promise to enhance our understanding of the subject matter and elevate our discussions. Dr. Ranjan, I request you to take over from here.
Thank you very much. I thank the organizers for this kind invitation and for the opportunity to moderate this session. I hope you all had a good lunch. Post-lunch sessions are always difficult, but I'm sure that with the interesting panel that we have, we are going to have some very good discussions. So as you know from the program, in this session, we are going to look at regional perspectives on UNCITRAL. And we have a fantastic panel to discuss different dimensions related to the issue. Now, the organizers have given us 1 hour, 15 minutes for this session, and therefore, keeping the fact that we'll keep about 5 to 10 minutes for comments and questions from the floor, I'll request all the speakers to kindly restrict themselves to about 10 to 12 minutes. Unfortunately, Mr. Pramod Nair will not be able to join us because of a health issue. So let me set the ball rolling straight away. And I have the great pleasure of inviting Ms. Anna Jubin-Brett from UNCITRAL to kindly address us. Thank you.
Thank you very much, and thank you for the kind introduction. And if you will kindly indulge me, I will give my speech from the chair here, because otherwise I will disappear behind the lectern. So I would just like to take a few examples to highlight the UNCITRAL perspective for South Asia. And the UNCITRAL perspective is pretty much not regional. We work as a global body. We have activities and also presence and membership from all over the world. But in the Asia-Pacific region, we have our only UNCITRAL office outside of Vienna. So I'd like to share with you a little bit of what this office has achieved for us in the last 3 weeks, and share with you that from their base in Incheon, they have helped us organize a number of events that have kept us on our toes and literally on the road for the last 3 weeks. So we started with the Singapore Convention Week in 2023, that was held in the last week of August, which headlined by the UNCITRAL Academy Conference and capacity building workshops on new and pressing issues in the area of dispute resolution. This is part of an ongoing partnership that we have with the government of Singapore to jointly promote the Singapore Convention on Mediation that was open for signature in Singapore, but that was negotiated in UNCITRAL, and thereby we both promote UNCITRAL's contribution to international dispute resolution, and we also showcase year after year the development of the legal industry in Singapore. We also went to have the signing ceremony for the United Nations Convention on the International Effects of the Judicial Sales of Ships, which took place in Beijing on 5 September. This convention is now named the Beijing Convention. It opened for signature very successfully, and we are hoping that it will continue our engagement with the government of China, which began with this convention, but which has also now resulted in the Chinese government bringing a project to UNCITRAL for development. And I mentioned yesterday during my speech the draft convention we are working on multimodal, negotiable, and electronic cargo documents, bringing together various areas of expertise of UNCITRAL, one in the area of maritime law and the other one in the area of electronic transactions and mutual recognition of electronic texts. We then went back to Singapore for a 2 days intersessional meeting of our Working Group 3, which is the working group that focuses on the proposed, which focuses on reform of investor-to-state dispute settlement. And this intersessional meeting that was organized jointly with the government of Singapore was about the proposed standing multilateral mechanism and the appellate mechanism for ISDS, and it was hosted on 7 and 8 September. The last event before coming to New Delhi was organized in Korea, our host country in the region, and it was the Incheon Law and Business Forum highlighting the work of UNCITRAL on digital trade that was organized by our colleagues in the regional office for Asia and the Pacific earlier this week. So this is really to highlight our presence and our way of working in the region through strong partnerships with countries in the region that to us are a complete win-win, in the sense that it gives us a better way of promoting our texts, making sure that there is uptake in the region for our texts, and at the same time also allowing the hosting government to showcase all the achievements they are making in a particular area of interest for UNCITRAL's work. So this is very much what I would like to initiate with India. We had a first very successful 50 years anniversary for UNCITRAL in 2016. We had an equally successful but much more modest than the event we're having here today, first South Asian Conference in 2019, and we're so glad to be back here with a view of having regular meetings of that sort to maybe go a bit more in depth into a particular area of UNCITRAL's work, be it arbitration, be it mediation, be it digital trade, be it insolvency, and you name it. So I would say I started with what can be considered as, for us, the glass half full. But we also have a glass half empty that we are still considering as one of our major challenges in the region. And let me start by the accession to the CISG. This is really one of the areas where we are very keen on getting more uptake in South Asia for this convention. We had the accession to the International Convention on Contracts for the International Sale of Goods, CISG, by the Kingdom of Saudi Arabia in August 2023, by Turkmenistan in May 2022, and China also extended its territorial application to the Hong Kong SAR in December 2022. So Asia and the Pacific as a region has been an active one in the uptake of the CISG. Other countries are considering joining, including the Philippines and Thailand, and we have to continue working actively on its promotion. We believe that this is an instrument when a country wants to become a hub for manufacturing, for industry development, such as is the case in India. This is an instrument that really provides the necessary security for entering into contracts for the sale of goods. The CISG establishes a comprehensive code of legal rules governing the formation of contracts, including the obligations of the buyer and the seller, remedies for breach of contracts and other aspects of the contract, and provides an equitable and modern uniform framework for the contract of sale. Unlike domestic laws, UNCITRAL, the CISG, was specifically drafted to meet the needs of international trade, taking into account cross-border transportation and payment needs, as well as trade practices. So the CISG is really the perfect set of default rules when entering into a contract in the specific area of the sale of goods, which once again should be an important instrument for the region where a lot of manufacturing and industrial development is now taking place. And let me end by saying that we also have the work on, I mentioned the work on mediation with Singapore. I mentioned the work with China. We have a strong memorandum of understanding also concluded with the Kingdom of Saudi Arabia in order to uptake all the instruments of UNCITRAL, particularly in the area of digital trade. So I really hope that this way of working in a jurisdiction as big, as powerful, as strong as India will be a way of achieving a greater penetration of UNCITRAL texts and, of course, with the other win side, which is showcasing what India has to offer in terms of its jurisdiction for international trade. Thank you very much.
Thank you very much, Ms. Jubenbrett, for that very interesting perspective. I'll say the glass is half full and quickly filling up. So I'm sure India and South Asia are ready for a deeper engagement with all the initiatives that you have mentioned. Now I turn to Mr. N. Venkatraman, Additional Solicitor General of India, to kindly address us. Thank you.
Namaste, distinguished panelists, distinguished guests, young Turks, ladies and gentlemen from across the globe. After a great international G20 event, we welcome you again for one more global event in the form of this UNCITRAL sponsored sessions on various aspects of international trade and international law. And deem it really a privilege to share very few thoughts as to what is running in a mind of a counsel who works for the government in international matters. You can take this as either personal views, preferably a personal view. Let's see how we calibrate it beyond that. That caveat is important. But it is indeed, we should be very, very thankful. Two things had happened in the last 4 years, which has possibly ingrained what each one of us could take 15 years to learn. We could learn it in 3-4 years. Thanks to technology, though the downside is COVID. And two, the global space was easily accessible and available in terms of consultancy, in terms of advice, in terms of support across continents. So we share, we say this with a sense of responsibility, having worked in all the continents, matters of international importance, where sovereign nations' stakes are involved. There are a few things which we thought we should place it in this very august forum to discuss, deliberate, and give. This is just a perspective. Plural perspectives are welcome, and it's bound to be there also. But we share some of our perspectives walking through this experience of this international arbitration. What does a sovereign nation actually expect from an investing country or an investor? The takeaways are the transaction should be clean, valid, and legal, threshold. It should benefit the investor and also the nation. It should be mutual. The investor should comply with all the regulations and statutes. And there must be respect to the system, and he must be treated with dignity. These are threshold requirements for any nation when an investment comes into force. And it's always a partnership, it's a healthy relationship, and it essentially moves on trust. When you work with a nation, working for the nation's responsibilities as a council, I say this, when you work with a nation, the nation always moves with trust. It first trusts, it opens with that aspect of it. So the tool of trust, when it breaks down, for some reason or other, it could be on one side, it could be on both sides, it could be on several sides. Then conciliation, mediation is more a protocol. I'm happy Anna touched about the mediation process, which we will also be highlighting in the concluding part of our talk. It's a need of the hour. And it breaks into arbitration, whether it's commercial arbitration or business investment arbitration, involving cross-border arbitrations. There are 4 or 5 concerns. I would only request the listeners to appreciate it, how a sovereign nation understands it when it faces. See, it's a nation in which investments happen. It's a nation which works with governance models to help. And it's a nation, for some reason or other, invited into a litigation. So, it has several hats to wear. And when it participates as a litigant in an international arbitration process, there are a few things which we thought we should share here. Our experiences, this is not any case-specific, number one, nor is it nation-specific, number two. We had the good opportunity once we got into this branch to understand it, we started to understand how it operates in different parts of the world also. So this is gathering inputs as to how it's happening across. So we can say one concern which sovereign nation has is this whole process, the pendulum swings from one end to the other end across the globe. That's one issue which we thought we should flag it for you to deliberate upon. Standardization happens only in 2 areas. In terms of the arbitral tribunal and in terms of the firms which prepare their cases on behalf of the litigants. We look for a broader standardization and see how all parts, it's difficult, see, it's not easy. We understand the process, we are going through the process. Because it's different shades, different cultures, different values, different eventualities, different perceptions. Everything is different. But still, you have to have a model which is all-inclusive. So, the oscillation is something which a nation is concerned when it's a litigant. The oscillation happens in terms of advice, in terms of strategy, and also sometimes in terms of outcome. Now, coming to the second feature, it could be cases where nations can be wrong. It could be cases where the other parties could be wrong. It doesn't matter to it. Ultimately, what happens? This sort of aggressively fought cases interlaces most often with the International Arbitration Forum and also the sovereign courts of various nations. It intertwines in some way or the other. And we see, I say this with a deep sense of responsibility, having watched matters, having briefed matters, having participated in matters, having seen live hearings across continents, there is the same issue when pursued by a tribunal and pursued by a sovereign court. Both are only litigation. The approach to it looks to be distinct. This is the second issue which a sovereign nation walks through when it does or involves itself in international arbitration. The third, that which we need to flag for your consideration is, see, it's a very noble idea. In fact, several articles have come on that and several people have spoken about it. And it's a very good thought process, undoubtedly. When they say, see, the game plan between a sovereign dispute in a sovereign court and an arbitral tribunal process is, it's a treaty tribunal. It emerges out of your contracting terms. And you choose your judges. This is the process. A very healthy process indeed. And therefore, finality has to be there at the earliest. It's a very, very noble process. Absolutely, the concept is fine and clear. Absolutely. So there can be no doubt about it. But all of us know, as a matter of law, as a matter of practice, as a matter of jurisprudence, see, I have 34 years experience in practice, standing every day in courts. Me and Madhavi, she was a law officer till 3 months ago, we used to handle 10 cases a day. Every day we used to handle 10 different matters in 10 different fields. So it's that type of experience which God has gifted us in our lives. One thing is certain, when there is element of discretion left to a body, then there is a corresponding responsibility to that discretion. This is mutual. They are Siamese twins. You can't break one from the other. When the idea is really noble, then the discretion should also be in that path. The discretion and the result, because finality is one, it looks at least 4 or 5 years, seeing several cases across, can say that it is not that easy to break or reverse a tribunal's findings. There's several restrictions, several conditions, several ways to say why tribunal should not be disturbed. That's the kind of power and discretion which is vested. And therefore, all of us know power and discretion go together. This is the third aspect which a nation looks into. Fourth, once an award comes, the concept of an enforcement proceedings is something which thrills a set of people whom I don't have to mention. All of you will wholly agree when I say that it does thrill a set of people. And it does. So, ultimately, when we answer, see, there is checks and balances in the system. We often go for meetings, so they do read us and say, so much of time has been spent, so much of resources has been spent, so much has been added in terms of value. What's the net of it? All of us know. What are the likely outcomes of an enforcement proceedings across destinations and jurisdictions? A finality, see the arc of almost finality, an ensured enforcement proceedings, and nations working their remedies in a very, very tough and a genuine way. So it's the fourth aspect. And of course, the last one, which I think I will leave it with that, is the doctrine of elasticity when it comes to competence doctrine. It's extremely wide. And we have seen in the last 4 years, not only in our nation, but across, the inter-sea, ultimately, this formation is because all sovereign nations on trust has given this responsibility to all of us. All of us are part of the system because we are working in that. So, please understand, sovereign nations don't cede power because it's a ground rule, at least in this part of the world. Sovereign power is imperishable. That's our doctrine. It comes with the nation and it dies with the nation. It's imperishable. So there is no cessation of sovereign power. It is only an understanding. It's only an allocation. It's only a working arrangement. So when there is interplay, interlace, intersection, intervention, and virtually an impede, then there is a lot of pressure on sovereign nations and sovereign courts. So when this happens to sovereign nations, we keep periodically reviewing all this. Then we start to work. That's why I was very impressed when Anna flagged off about mediation. See, when all these things happen, one way or the other, it results in a nation to think about 4 Rs. With that, I leave the talk. It makes us to review what the process is all about. And what we did in 2016 is one such action point. It makes us to think, should we do something within our control to revamp? The second R. It makes us to think, should we reduce litigation? Because we are a responsible sovereign nation. People trust us. And we should now go into government-to-government dialogue and settle disputes, which is welcome. Many, and in fact, in one of our meetings, we did think it's not just a government executive body of the nation. In India, it's the executive which does it. Let's support the executive with a strong panel of experts who will surf through the whole material so that the investor and the nation understands this has been done, a clean work has been done from them before they come on the table for government-to-government dialogue. So, reduction, and of course, we should leave with this. You come to India. India is known, in fact, one of the leading practitioners in one of the forums said, in double taxation avoidance agreement, India contributes more than 50% of judgments in the world. And we are very happy to hear, and very, very responsible person who said that, and we are extremely happy to hear this. So we have trained judges, we have trained courts, we have trained young people who toil a lot to learn all this. See, in 4 years, all of you has taught, should thank each one of you here. Each one of them has taught to us. We are obliged to them for commendable effort taken to impart your knowledge to all of us. It's in 4 years all this we have gained. That's the kind of abilities which all of us have been ingrained over a period of time in this part of the nation. Therefore, we leave with the 4th R. We have been progressing well with Make in India. We will also resolve to have resolution of disputes from India. And we look forward to work with UNCITRAL, with work with each one of you. Let's look at an era where investment arbitrations turn out to be investor-friendly, nation-friendly, investment-friendly, and litigants should become mere participants and settle disputes amicably and smoothly. Thank you so much, please.
Thank you so much, Mr. Venkatraman, for that very interesting perspective on investment arbitration from a sovereign nation point of view. Thank you very much. I now turn to Anuradha to kindly address us. Thank you. Sure.
Thank you, and thank you, Prabhash, and thank you, organizers, for inviting me to this exciting panel. Mr. Venkatraman has set the stage in terms of one of the areas which has occupied mind space to a tremendous extent in India in terms of ISDS disputes. And to a large extent, the work that is being done in the Working Group 3 has significant relevance in terms of streamlining, in terms of lessons on how we actually organize and prepare for this area. I will move on to a slightly more mundane aspect of the arbitration, which is actually the activity of Working Group 2, Mundane in a sense, but also exciting because of the practical relevance that it has across all areas of arbitration. And this is the subject matter of Working Group 2, which is technology-related dispute resolution and adjudication. Now, this area, interestingly, is something which emerged initially as being specific to technology disputes or construction disputes, but there has been growing recognition of its sector-agnostic relevance across various aspects, various disputes. And it was quite heartening to see the latest report from the Working Group 2, which I understand will be considered in the forthcoming meeting next week, which has laid down model clauses on a variety of aspects, right from highly expedited dispute resolution to expert appointment and using experts as part of the tribunal's process for adjudication. Each one of them has significant relevance, but at the same time, a significant amount of issues for concern and perhaps further deliberation as well. So to set the context a little bit, one of the areas I want to make a slight distinction is also, moving on from the fact that Mr. Venkatraman alluded to in terms of increasing use of technology during the pandemic years. And all of us have adapted to innovative mechanisms for virtual hearings, right from case management to arguments being presented before tribunals, even cross-examination, the entire process of document production, objections, and the resultant orders pertaining to that. And a lot of it evolved to a significant extent in terms of use of the virtual mode for resolving disputes. But again, the experience, at least for high-stake disputes, is that the allure of in-person hearings is significantly going to remain, because as things have moved back to somewhat normalcy, while the hybrid mode still continues, the use of the virtual mode to a large extent is not as much as it perhaps was in 2021-22. But the area that the Working Group 2 deals with goes much beyond that. It is not just about use of technology, but really more in terms of how for certain specialized sectors of disputes, whether it pertains to the technology sector and increasingly construction sector, financial services sector, which is what the Working Group 2 also talks about, there are a number of areas in which further innovation can really happen. And 4 of the model clauses that the current Working Group 2's report reflects on, which is what I want to briefly touch upon in the next few minutes, is one, of course, the concept of the highly expedited arbitration with specific time limits. Now, interestingly, this is, again, conceptually nothing new, because the concept of fast-track arbitration does exist even in the existing model rules. It has been adapted across institutions. It is part of the India's Arbitration and Conciliation Act as well. But what this envisages is a far more highly expedited mechanism for resolving disputes. Now, the second aspect it pertains to is the appointment of experts, and then the third on having experts as part of the tribunal itself. Again, as far as the appointment of experts is concerned, this is something which the UNCITRAL model rules already have factored in. It is, again, something which has been adapted into India's law, as it has been in the laws of various other jurisdictions. And the concept is, in terms of first principles, it's fairly universal. For example, even the WTO's Committee on Technical Barriers to Trade, when it comes to complex technical regulations, relies on the appointment of expert committees, not individual expert, but expert committees. And then there are several eligibility criteria. For example, it can't be nationals of the parties which are involved in a dispute. There has to be the qualification-related criteria. And similar to what the model rules talk about in terms of the UNCITRAL's existing model rules, they also refer to the opportunity for parties to have access to the material that the experts are privy to, have an opportunity to examine the report of the expert when it comes out with its expert committee report, and for the expert committee to consider those elements as well. Now, these are the specific elements of due process which, to a certain extent, don't seem to have been dealt with in sufficient detail in the highly expedited component of the dispute resolution and the current form of the model clauses, which leads to the question in terms of the relevance, the utility, and the possible complexities, actually more in terms of the possible challenges that can be envisaged. Is it worth really considering eliminating those steps? The concept of fast-track dispute resolution, we understand, with the consent of parties, if parties agree not to have an oral hearing, for example, or not to have cross-examination, have an entire process of dispute resolution based on documents alone. But that's entirely based on the consent of parties. But the moment when it comes to appointment of experts, the suggestions, some of the issues which are yet to be deliberated upon deal with questions, for example, whether the experts' decision on certain specific aspects, such as payment-related obligations arising from a contractual dispute, would that be a fast-track determination that is final and binding? Would that actually move on to determination on specific performance on certain, for example, in a construction dispute, it's highly technical and specialized, and can an expert's view on that again be final and binding? To what extent does that substitute the arbitral tribunal from adjudicating on a particular issue? There's one very interesting point that Mr. Nariman had raised in the inaugural session yesterday in terms of at least the ability to challenge independence or impartiality of arbitrators, for example. And is that something which should be open and available for parties when it comes to challenging experts, potentially? So these are some of the aspects which need further deliberation on before any kind of finalization of these model clauses or model rules are concerned. In the other aspect, which the working group 2, very interesting aspect that it deals with, is the question of early dismissal of claims. Now, again, the concept of early termination of arbitral proceedings is something which we are perhaps more familiar with. In India particularly, this is something, a very rarely used provision of the Arbitration Conciliation Act came up for discussion in the Amazon and Future dispute, where, and there is a provision which talks about termination of the proceedings on grounds of unnecessity or impossibility for going ahead with the proceedings. And to a large extent, the Delhi High Court has clarified the ambit and the nature of that provision. But what the UNCITRAL Working Group 2 rules talk about is reference to early dismissal of specific claims. And to the best of my understanding, this is, again, already dealt with within the current arbitral procedures for preliminary objections, for preliminary determination on, say, jurisdictional issues or any other kind of preliminary objections that parties can agree to, subject to agreement with the tribunal. And there is already a possibility for adjudicating certain specific claims before others are taken up on the grounds of procedural efficiency, cost efficiency, etc. So again, when it comes to the concept of early dismissal of claims itself, does this really need to be crystallized in the form of a rule as part of our rule book, as part of our statute? Or is this something which is more of a facilitative measure that should be left open to parties to determine, is again something which perhaps needs further thought process and deliberation? Many of the elements in the Working Group 2's model clauses have significant relevance for a variety of aspects. Mr. Venkatraman already mentioned the idea of developing India as an arbitration hub. There is already a move towards it. As we speak, there is a working committee which is looking at establishing an international arbitration center within the Gift City as part of the International Financial Services Centers at the Gift City. Of course, there are several regulatory reforms which will have to be undertaken to operationalize and to make it relevant for institutions beyond the Gift City itself. And many of these clauses in terms of expedited resolution and confidence building within the arbitration mechanism itself will have significant relevance for the new rules that emerge from any of these initiatives. But the caveat that I would like to emphasize on is really the concept of due process. I would want to see greater assurance in terms of how that is achieved and whether we really need to move beyond what the model rules already talk about, or whether that can be further crystallized and enhanced for operationalizing it. These are some of the thoughts I'd leave the panel with. Thanks.
Thank you so much, Anuradha. You're completely right that it is Working Group 3 of UNCITRAL which gets a lot of attention, because ISDS undoubtedly is one of the most controversial issues in international law. But I'm so happy that you highlighted on the work of Working Group 2 of UNCITRAL. Thank you so much once again. I now turn to Dr. Cameline Punitpuvril, Secretary General of Asian African Legal Consultative Organization. I apologize if I mispronounced your name. Yeah, thank you.
Yes, good afternoon. First of all, I'd like to convey my sincere gratitude to the MBA India and especially to the Economic Diplomacy Division for giving the opportunity to meet, to come to be a part of these very important events, and also to give opportunity to our staff of ALGO to be attend in these very important events. As in capacity of the ALGO Secretary General, I'd like to share some thought about the work of UNCITRAL and ALGO. But before that, perhaps let me talk a bit about my organization, ALGO, ALCO. Perhaps some of you wonder what is ALGO. If we search at Google, we find another organization called ALGO. But our organization, ALGO, is come from the word Asian African Legal Consultative Organizations. It's an organization, we can say that the inter-regional organization set up in 1956. It's not the new one. At least it's 10 years older than UNCITRAL. UNCITRAL set up in 1965. We can say that we, as the tangible outcome of the Bandung Conference held in Bandung in 1955, that time, after you go back to see that the issue of the anti-colonization, issue of a newly independent state, the countries can say from the South or European countries or LDC came together to have a meeting at the Bandung to see about the future, about the perspective of the countries in Asia and Africa. And later, 1 year later, in 1956, the ALGO established. That's why we consider as a tangible outcome of the Bandung Conference. And mostly we work on the international. We, as a forum or a legal advisor for the countries in Asia, Africa, on the matters of international. Mostly we try to provide the codification and developments of international. We not ourselves codify or develop, but we provide our perspective to some other international forums as the ILC. International Commission, we provide the perspective of the countries in Asia, Africa on many matters of international law when they draft the convention or some instrument on international law. And now we compose of 47 member states from Asia and Africa. We have 15 from Africa and the rest 32 from Asia. And now we still open the membership to all countries in Asia and Africa. We work on many issues on international law, including the international trade law also. We work on today around 18 topics of international law, including the law of the sea, the human rights, violation of human rights in Palestine, the issue of the environment and sustainable development, refugees, the peaceful settlements, many topics under work programs. And the topic of trade law is included in our work programs quite a long time. For example, I'd like to mention that in 1961, we have the conference we call the annual session. We have the topic on the conflict of laws relating to state and purchase of in commercial transaction between state and their nationals. Now we can say that it's a kind of CISG, Convention on Sale of Goods. And during that time, we developed many topics according to the international trade law, include other topics as the arbitration, mediations, and many topics. And with the UNCITRAL, we can say that ALCO and UNCITRAL have maintained a close and fruitful cooperations quite a long time. And we include the topics or some work of the UNCITRAL in every year when we organize the meeting we call annual session. We prepare the brief on the work of UNCITRAL. It's aimed to lead our member state into the in-depth discussion about the work of UNCITRAL during the annual session every year. And also, similarly, the UNCITRAL has participated in ALCO session quite in the years 80, and UNCITRAL sent someone represent UNCITRAL to make statement on some new developments of the work of UNCITRAL during the annual session of ALCO. I'd like to mention that the topics of the arbitration is came to the organizations in the year 70. At the session in 1924 in Tokyo, the topic regionalization of arbitration center was suggested by the UNCITRAL representative to ALCO to the annual session. And in the report in the year 1922 on problems concerning the application and interpretation of existing multilateral convention and international commercial arbitration and related matters by the UNCITRAL Special Rapporteur for International Commercial Arbitration at that time, Mr. Ion Nestor. He mentioned that, and with the suggestion that the network of regional arbitration center will be fruitful for the developments of international commercial law and international arbitration law. And in the result of this, the ALCO, in cooperation with some of our member states, set up the center we call the Regional Arbitration Center in some countries of members in Africa, in Asia. So now we have 6 regional arbitration centers. In the first one set up in Kuala Lumpur, in Malaysia in 1928. Second in Cairo, in the Arab Republic of Egypt, 1929. The third in Lagos Regional Center in 1980 in Nigeria. The fourth in Thailand in 1997. The fifth in Nairobi, Kenya in 2016. And the last one in the Hong Kong SAR in cooperation with the government of China. All the center is set up under the auspice of ALCO. It means that ALCO conclude agreement with the host state. And all the regional centers were accorded the immunity from the host state. And also, every year when we organize the events as an session, the director or someone of the center will join and report to the session about the work. And we'd like to learn more about, well, for example, the topics of the ISCS, some center hosts the arbitration of interstate dispute settlement in their center. And as I mentioned that ALCO has practice to preparing the report for the annual session. For example, this year, we will organize the annual session in Bali with the government of Indonesia in October. And also we will have a topic on the work of the UNCITRAL. And our legal team staff at the Secretariat are preparing the brief, we call the brief, when we bring all the new developments of the UNCITRAL to the report. Mostly in the past, we have many topics. For example, may I raise as example the topic on the issue of legislative guide on secure transaction, arbitration and conciliation, public procurements, transport law, e-commerce, insolvency laws. And since last five years, we include mostly the topic on the Working Group 3 on the ISDS reform, including many issue developments, the code of conduct, the guideline for mediations, and also the new topic as the appellate mechanisms or the multilateral advocacy center. This is very useful that our members can make the statement and deliver some thought about particular topic of the work of UNCITRAL. And we can say that when state join the annual session of ALCO, it's a kind of state practice when they deliver their thought, their comments, suggestions during the annual session. And also we like very much to look forward to have close cooperation with the UNCITRAL. As I can say that UNCITRAL can use the ALCO as a platform or a link to the country in Asia Africa for the legal cooperation. If you like to hear some voice perspective of the country from Asia Africa, it's very useful, this organization. We work, apart from UNCITRAL, we work with many UN agencies as UNTAD, the Hague Conference on Private International Law with the UNIDROIT. And we like very much to be part of the developments of international law, especially of trade law. And also we like very much to engage more of our member states to the work of UNCITRAL. So we're looking forward to have close cooperation in the future. So thank you very much. Thank you.
Thank you so much, Secretary General, for refreshing our memories of the historic Bandung conference, which led to the creation of ALCO, and for sharing the work that ALCO has been doing, including on UNCITRAL. As a student of international law, I can safely say that ALCO is undoubtedly a very important international organization, and it deserves to be strengthened by all its member countries. Thank you very much once again. Last but not the least, I now turn to Ms. Madhvi Devan, Senior Advocate, Supreme Court of India, and I request her to kindly address us. Thank you.
Good afternoon, and this is a very impressive turnout on a Friday afternoon. I happen to be a courtroom lawyer, and some of us tend to ramble on. And therefore, I think it is just wiser for me to try and stick to a written text. I'm going to speak to you a little bit about cross-border insolvency, a subject of topical and pressing relevance, particularly as India takes its place among the top-ranking economies of the world. Indian businesses are increasingly acquiring an international footprint, straddling multiple jurisdictions. The modern enterprise transacts, imports, exports, and holds assets and undertakings in different jurisdictions. In a globalized world with shrinking barriers, businesses must be free to realize their optimal global potential unconstrained by territorial or geographical barriers. And in order to enable businesses to operate with a cross-border seamlessness, as it were, there must be seamlessness in the enforcement of legal rights. Therefore, the age-old adage of India, that is Vasudhaiva Kutumbakam, the world is one family, the motto for the G20, must apply in equal measure when it comes to cross-border insolvency. It is imperative that domestic laws are realigned to meet uniform global standards. There is no better time for that than now. The Insolvency Bankruptcy Code brought into force in 2016 was, along with the GST, it ranks amongst the most important economic reforms in India in recent years. This one legislation, which marked a radical change from the debtor in possession to creditor in control, took India several notches up on the ease of doing business. And that is a jump of about 80 positions in the span of 6 years. I happen to have had the privilege of defending some of the constitutional challenges which arose in the Supreme Court to various provisions of the code. And the constant refrain that we heard from the petitioners on the other side was that there are just far too many amendments being made to the IBC. And while it is true that a series of amendments were made sometimes just as we were sort of, that the ink was drying on the judgment, you had another amendment, and we as counsel on behalf of the Union of India also found it difficult to keep pace with. But nonetheless, most of these amendments were upheld by the Supreme Court. And what the court held there was that in matters of economic policy, the state must be allowed latitude for economic experimentation, and there must be freedom to the legislature to change course based on experience and trial and error to amend the law when it encounters the need to. Taking a cue from that, I'd say that the next big amendment must come in the form of changes to encapsulate a more robust, practical, and workable regime on cross-border insolvency. The law must be taken to its logical next level and brought up to speed with the UNCITRAL model. This is a measure imperative to inspire confidence in those who wish to do business in India and with India, and to give fillip to the Make in India project. Those who do business in India with Indian enterprises must rest confident that creditors from foreign jurisdictions will be treated at par with domestic parties. Indeed, the principle of non-discrimination lies at the heart of cross-border insolvency law. The idea of non-discrimination in cross-border matters is not something alien to India, because as far back as 1962, the Supreme Court of India, in the context of a winding up proceeding under the 1956 Companies Act, held that any creditor, regardless of whether such creditor was resident in India or belonged outside, had an equal right to apply for winding up of a company. The principle underlying that judgment was that there must be free distribution, fair distribution of assets among the entire body of creditors, regardless of where they belonged. The cross-border insolvency provisions in the IBC Code of 2016 have yet not been brought into force, but that has not prevented the courts in India from applying the comity principle to recognize awards of foreign insolvency courts and to provide assistance to asset administrators. A recent example of this is a judgment of the Delhi High Court in the Toshiaki Aiba case, where the court not only recognized an award passed by an insolvency court in Japan, but also allowed the bankruptcy trustee administrator to take control of the insolvent individual's assets in New Delhi. But there is uncertainty, because, for instance, in another matter on a similar issue, the Madras High Court declined to exercise jurisdiction. The Jet Airways case is an interesting case in point. After the CIRP was commenced in India, it was found that a Dutch court had already initiated insolvency proceedings earlier in point of time and appointed a bankruptcy trustee in Netherlands. The company's aircraft parked at an airport in Amsterdam had been seized. The Dutch administrator's petition for recognition of the proceedings in Netherlands was allowed by our appellate tribunal. The administrator was allowed to be part of the committee of creditors and attend its meetings, but without voting rights. Now, the whole point of cross-border insolvency is that a foreign creditor should not be treated any differently. So what one may say is the point of being party to the proceedings but not having voting rights. But of course, this was considered a progressive step forward by the Appellate Tribunal in India because the IRP and the Committee of Creditors were directed to consider the prospect of cooperating with the Dutch trustee so as to have a joint corporate insolvency resolution process and to reach an arrangement with the Dutch trustee to extend cooperation to the Dutch trustee. But my research shows that eventually the claims of the trustee were settled at about rupees 10,000. While the courts in India have time and again come up with unconventional methods to recognize and enforce foreign insolvency awards, the point remains that one cannot be left to the ingenuity of the courts as a matter of course. The existing provisions in the code are contained in sections 234 and 235, and they are clearly inadequate. Section 234 empowers the central government to enter into bilateral agreements with foreign jurisdictions in order to resolve issues of cross-border insolvency. Section 235, on the other hand, empowers the adjudicating authority to issue letters of request to the courts of the country with which the bilateral agreement has been entered into under Section 234. Now, bilateral agreements involve a long-drawn process, and that can leave matters open-ended and uncertain. Agreements may vary, and cross-border insolvency in a single case may apply not to just two jurisdictions, but multiple jurisdictions. Balancing competing clauses of diverse treaties entered into with separate jurisdictions could become unwieldy and cumbersome. In March 2018, the Insolvency Law Committee acknowledged that sections 234 and 235 failed to provide a comprehensive framework to address cross-border issues. The UNCITRAL model law on cross-border insolvency, brought out in 1997, seeks to assist states to equip their insolvency laws with a modern, harmonized and fair framework to address more effectively instances of cross-border insolvency. The model law focuses on encouraging cooperation and coordination between nations. It functions in the form of a guidance note, and states are free to retain their local insolvency ecosystem while aligning itself with the international framework. The four principles governing the UNCITRAL model law are access, that is access to foreign representatives with giving them access to courts of the enacting jurisdiction. 2 is recognition of insolvency proceedings taking place in a foreign jurisdiction. 3 is cooperation. The courts in the enacting jurisdiction are to be equipped to determine the mode of cooperation with foreign courts and representatives. And 4 is coordination, that is coordination between the courts in the enacting jurisdiction and the foreign country. Now, in 2018, the Insolvency Law Committee submitted its report on cross-border insolvency to the Ministry of Corporate Affairs. The ILC recommended the adoption of the UNCITRAL model law with certain modifications to fit the same into the Indian insolvency ecosystem, and this came to be known as the Draft Part Z. There are provisions in Draft Part Z granting access to foreign representatives and creditors for participation in ongoing proceedings, for recognition of foreign proceedings, and for recognition of a foreign proceeding as the foreign main proceeding. There are provisions for cooperation, coordination, communication between the adjudicating authority in India and foreign courts and representatives for joint hearings in matters of concurrent proceedings. There are some areas where there is a departure. For instance, the UNCITRAL model law allows for foreign representatives to cross-examine witnesses in India, while our draft only allows representatives to gather documents and evidence. Another example is Section 7.2 of the Draft Part Z, which subjects foreign representatives to a code of conduct as may be specified. This is an interesting provision as it seeks to empower the regulators in India with the power to regulate foreign representatives. In January 2020, the Ministry of Corporate Affairs formed the Cross-Border Insolvency Rules Regulations Committee. This committee issued its first report in June 2020, which made certain key recommendations. And among those recommendations were, 1, capacity building in the adjudicating authority. This is important in terms of both infrastructure, adjudicating members, the facility of e-filing, electronic access, facility for electronic hearings, and facilities to enable court-to-court communication and cooperation. The second is, of course, capacity building in the IBBI, which is our regulatory body. And that really needs enhanced capacity because right now, as I do know, it is flooded with disciplinary proceedings relating to errant, what are called foreign representatives or trustees, that is insolvency professionals. There are going to be many creases to be ironed out. One will be, for instance, defining public policy. The ILC draft states that the adjudicating authority may refuse action under cross-border laws if implementation of such an action were to be manifestly contrary to public policy. And that can be worryingly elastic, as we do know from the past. The second is, for example, the question is what is to happen to group insolvencies? There is no clear provision on this. Group companies, that is, which may be part of large international conglomerates, where would be the center of coordination? What is going to be the cross-border protocol? So these are some of the questions. What is, for instance, the COMI, the Center of Main Interest? Is it going to be the registered office which determines that? Is it where the main business is located? Is it where creditors or the majority of creditors are going to be located? Or is it where the assets are? So these are questions which are going to have to be dealt with. But in conclusion, I would only say that make in India must mean making it easier to do business in India and also making it easier for Indian businesses to operate outside India. It is time to make a start on cross-border insolvency, and that time is now. Thank you very much.
Thank you very much, Ms. Devan, for that very interesting perspective on cross-border insolvency. We have a few minutes, and we can accommodate a couple of questions, maybe, if there are any. If you could please identify yourself. Yes, the lady at the back. Can we have the microphone, please?
Hello. Greetings of the day. My question is directed to Madhvi Devan, ma'am. Ma'am, like you said, there should be fair distribution of assets of creditors, irrespective of where they belong. So, ma'am, what is to happen in cases where there are no bilateral agreements between countries and assets of the Indian debtor are located in a foreign country and no guidance is provided on remedies available to Indian solvency professionals so that they can take action against assets of the debtors, of such debtors?
Thank you. Madhvi, is it fine if we collect a few questions and then, so we'll collect maybe a couple of more questions and then come back to the panelists. Yes, please.
Good afternoon, everyone. My question is directed to Anna, ma'am. So if we consider the history of CISG, in the history of UNCITRAL, in the very onset after the World War II, there was an approach to make international law or the law somewhat specific to the interest of the post-colonialized world. So if we consider Article 9 of CISG, that had a doctrine which adopted the Soviet approach or the neo-colonial approach as well as the Western approach. However, after we see that with the advent of new laws, it's much more realistic in nature as to what the law is. It is written in nature, and it isn't recognizing customs. So do you think that UNCITRAL should take into consideration other customs to make it much more approachable towards regional countries?
Okay, thank you very much. Maybe one more question. Yes, please.
Good afternoon to the dignitaries on the dais and off the dais. My question is directed to Madhavi ma'am. How can we expect a common approach when the relations with the other countries is not so common? For example, India might share some different relations with USA, at the same time, different relations with Russia. To solve the problem of insolvency, in that case, what would be the common approach with all the countries? Thank you.
Okay, thank you very much. Ms. Diwan, since two questions have been posed to you, so therefore I'll request you to please answer them.
I'll try and answer both together. First of all, as you know, the Section 234 and 235 are not in force as we speak, and they have already been regarded as very inadequate to deal with the situation. So bilateral treaties is not going to be a great idea. One is, of course, because you may be involving more than two jurisdictions. And, you know, it's a very long drawn process. I mean, even in the, you know, it requires sending a letter of request even after the treaty is entered into. So it is a very cumbersome process, and it only will involve two countries. So even coordinating different provisions between different countries is going to be very difficult. That is, well, what the model law seeks to do is to provide that common meeting ground. And I hope that we do make a start with the draft Z as it's referred to. I'll say this, that look, this is all pretty much relatively uncharted territory. So there are no very easy answers. There are going to be a whole lot of differences on, for instance, what one country regards as a center of main interest. As I said, is it where the assets are? Is it where the registered office is? Is it where the business is? Is it where the creditors are? So there are going to be no easy answers, but the point is we need to make a start and find a common meeting ground. We're going to run into a lot of issues, but the importance is you have to send out that message of public confidence in the business community internationally by coming out with that draft law. And as we've seen with the IBC, even domestically in India, it's undergone so many changes by way of trial and error. The court has recognized that. Justice Nariman in his judgments has recognized that, you know, by trial and error you have, I mean, economic experimentation. So it's going to happen. I can quite see it happening with cross-border insolvency, but we have to make a start.
Yeah.
Thank you.
Thank you very much. Yeah, sure.
Am I audible? Just to add to what Madhvi says, see, we are not, in terms of enforcement, we are not that helpless. Of course, IBC doesn't extend today. But there are two other investigative agencies which can do something. One is the SFIO under the Ministry of Corporate Affairs under the company law. But their reach is not that adequate. They can identify the asset, but they don't have the power to travel cross-border. So the other agency is the Enforcement Directorate, ED. And today, ED has a power to reach. And PMLA laws are there to go and freeze assets across the world. And FATFA is supporting it. Of course, it's a long drawn process, a time consuming process, an evolving process, all that is accepted. But slowly we are inching towards this. So the tax havens which protect, almost, if you keep your IBC proceedings, park your assets only in a haven. It's the normal default rule. So the reach today is through ED and the PMLE. That's the option available today in law.
Thank you. Ms. Jubin-Britt, if you could answer the question.
Thank you very much for this very good question, which allows me to come back on the CISG and the numerous countries that have signed on to the CISG, which span all sorts of legal systems. And I think that beyond this historical reference that you are making, the way we work in UNCITRAL is much more on the technical level in bridging legal systems and the more participation we get from legal systems from around the globe, the more acceptable it becomes in all these countries. And let me take one example, which is related to the recent accession of Saudi Arabia. Saudi Arabia is a country where Sharia law plays an important role, and where the articles of the provisions of the convention that deal with serving interests, of course, come contrary to the principles of Sharia as they are translated into the positive law of the country. And so the accession by Saudi Arabia, and I speak under the control of my colleague Luca, who has been seeing this through, has been to accede to 2 of the titles and to leave 1 title aside, to make a reservation, if you want, in acceding, which is possible for states who have a particular issue with this instrument of broader application. And while I have the microphone, I would like to thank my co-panelists who made a very strong pleading for cross-border insolvency, and assure you that my colleague Samira and her team stand ready to help answer the questions and advance on this journey with you. Thank you very much.
Thank you very much. I'm sure there are many more questions, but we are completely out of time, and I don't want to stand between you and your well-earned cup of coffee. So I'll end the session here. I would like to thank all the panelists. Please join me in giving them a big round of applause. I thank all of you for attending this session, and I hand over to the organizers. Thank you very much.
It was truly an enlightening session, giving us insights into the initiatives taken by UNCITRAL and the concerns faced by sovereign nations while participating as litigants in international arbitrations. We also learned about the UNCITRAL working groups, the role being played by ALCO, and also on cross-border insolvency. I thank you all for your continued enthusiastic collaboration and for your participation in our sessions. I request all the panelists to kindly come together for a group picture. Following this stimulating discussion, it is time for a well-deserved coffee break. Please enjoy your coffee and networking opportunities that await you right outside the hall. I would also request you all to kindly gather back into the hall by 4 p.m. when we begin with our next session. Thank you. On investor-state dispute settlement reforms, I request you to please join me in welcoming on the stage our Honorable Chair, Honorable Mr. Justice K.V. Vishwanathan, and our esteemed panelists, Mr. J. Sungli, Mr. George Pothan Pothikot, Mr. Salim Mulan, and Mr. Shane Spelisi. It is both an honor and a privilege for me to introduce our Honorable Chair for this session, none other than the Honorable Mr. Justice K.V. Vishwanathan, a luminary in the realm of legal jurisprudence. He is currently a judge of the Supreme Court of India, bringing with him a wealth of experience and legal acumen that is second to none. Honorable Justice Vishwanathan is a well-known and respected former senior advocate and an eminent member of the bar. He started working as a junior under eminent senior advocates K.K. Venugopal and C.S. Vaidyanathan. He was designated as a senior advocate in 2009. In 2013, he was appointed as the Additional Solicitor General of India. Furthermore, he has also been an eminent member of the editorial board of the Supreme Court cases, SCC as we call it. During his tenure as an advocate, he appeared in a varied range of cases on diverse subjects including constitutional law, criminal law, the law of insolvency and arbitration before the Honorable Supreme Court and the other high courts. His stature as an eminent member of the bar has been recognized by the Honorable Supreme Court in numerous cases wherein he was appointed to assist the court as an amicus curiae. He is also amongst the select few advocates who have directly been elevated from the bar to the bench of the Honorable Supreme Court of India. And in his presence today, we are exemplified with his dedication to advancing the discourse on vital legal matters. Please join me in extending a warm welcome to Honorable Mr. Justice K.V. Vishwanathan as he guides us through his insightful and pivotal discussion. I would now request Sir to kindly take over the floor.
Good evening, ladies and gentlemen. My distinguished co-panelists, Mr. Jae Sung Lee, Mr. George Pothan, Mr. Salim Mul, King's Counsel, Mr. Shane, ladies and gentlemen. At the outset, let me congratulate the organizers of this South Asian UNCITRAL conference, and particularly the topic that we have chosen for discussion today, the investor-state dispute settlement reforms. Now, opening the discussion, I just want to float a few ideas for the panel to then elaborate on it. But before we get to the problems and the consequential need for the reforms, a couple of thoughts on this investor-state litigation. Some of us homegrown in the atmosphere of the courts tend to view a dispute resolution from the prism of the traditional resolution by the courts. At the other end of the spectrum are the arbitration practitioners, the hardcore arbitration practitioners, with their bee in the bonnet of party autonomy. But I think somewhere at the end of this discussion, you will have to find a model which adapts the best practices from both and which fits in a dispute resolution mechanism which effaces and eradicates what I might call a trust deficit, or what George calls it in one of his articles, the legitimacy deficit, how far it can be eradicated. But before we get there, investor-state disputes per se, even on the substantive aspect before we get to the procedural, present some interesting perspectives. Some of the defenses which are very common in normal commercial litigation, I'm not excluding this from the commercial sphere because that itself is a topic for discussion today, are no longer defenses available in the investor-state disputes. For example, the advent of a new statute which could normally give rise to a defense of frustration for a defendant would, on the contrary, give rise to a cause of action for an investor in a dispute. Equally, normal principles that there is no estoppel against a statute are no longer available as defenses, because the advent of a statute frustrating an investor's investment could itself be the cause of action in an investor-state dispute. So all this then requires that there is ultimately in the dispute resolution a ring of fairness, so that parties who go to the dispute go back with the feeling that at the end of the day that it is a fair tribunal, it has followed some consistent principles, there is neutrality in decision making, there is no tilt or bias, the participants are fairly objective, the judges were objective, they had no issues of policy bias or prior utterance bias. On the one hand, you have that. On the other hand, the citizens of the state should also have confidence in the dispute resolution, because at the bottom of the administration of a country is the sovereignty of a country. Is there any compromise with the sovereignty part? Are the investors, because they are foreign investors, getting a better deal when normally maxims like salus populi, suprema lex would prevail? Are the foreign investors being given an exception from this? And if so, are there legitimate grounds in the adjudication? These are some of the questions. Ultimately, I think it is common for a citizen to feel that as far as the state is concerned, it is really between a rock and a hard place, in the sense that while you cannot dispense with foreign investments, particularly for the developing countries, at the same time, you cannot be subjected to the dictates of the foreign investor, as long as the procedure involved in resolution inspires confidence and there is no trust deficit in the mechanism. Now, in this background, what is the immediate problem that one encounters or that is perceived to encounter? I don't want to illustrate with any case in question, because the option is not that you completely renege, as some countries have reneged. That's a policy decision. I don't know what the policymakers will decide. But if you are in this mechanism, one of the major concerns is that this mechanism is very ad hoc. There is no permanent tribunal. Apart from the fact that there is no permanent tribunal, there is no consistency and coherence in the development of the law. There is a fear that the same treaty norms could be interpreted differently in the same or identical factual scenario. There is no body of precedents. Awards are normally what one would call one-way rail tickets, getting you to the destination for that case. There is a fear that expressed in writings that individuals who sit as arbitrators argue as counsel, with the result that the view that they have taken or the view that they have canvassed might, as an inarticulate premise, loom large in the decision-making when it comes to the award. But the gravest concern is, as was expressed by the Honourable Chief Justice yesterday and eminent jurist Mr. Nariman, the Attorney General also touched upon it, the absence of any appellate mechanism. The awards have now become what was once called Roma locuta causa finita est. The arbitrators have spoken, and that's the end of the matter. Are we to leave it at that, or are we to provide a second tier which will review on aspects of law, aspects of policy? There are also concerns that domestic disputes, by a process of upstream and downstream arrangement in companies, are converted into investment treaty disputes. In this background, what is to be debated is, are these concerns exaggerated, or are there genuine apprehensions? Should mediation be an option, as suggested by Justice Sri Krishna? Will the establishment of a permanent code with a fixity of tenure for judges and a diverse composition, keeping in mind the concern of the states involved, help in the development of a coherent system? How do we avoid inconsistent interpretations of the same investment treaty standard? How do you develop an opinio juris? And how do you restore a perceived notion that there is a trust deficit and that the states are coming in for a raw deal? To discuss this, we have a very eminent panel here. Mr. Sung Lee, Senior Legal Officer of the International Trade Law Division. We're looking forward to hearing his views. Our own homegrown Mr. George Pothen, Legal Consultant to the Ministry of External Affairs. And Mr. Salim Mullen, King's Counsel at Brickcourt Chambers, Chambers of Lord Sumption, and a prominent name in the investment treaty sector. We have Mr. Shane, and I would invite them to respond to some and to advance their views so that we could also have a second round. Thank you very much.
Thank you very much for this introduction. The way we're going to proceed is that we're going to, first, I'm going to introduce the project at UNCITRAL, how we got to Working Group 3 working on ISDS reform. Jay will then explain to you where we are, Shane will tell you where we are going, and then George will give you an Indian perspective on that, and then we'll have a second round later. It's a pleasure and honor to be here. Thank you very much to the MEA and UNCITRAL for inviting me. As some of you may know, I chaired UNCITRAL's work on transparency in ISDS, which led to the adoption of the UNCITRAL transparency rules and to the Mauritius Convention on Transparency. The Mauritius Convention was not the product of deliberate planning. Prior to its elaboration, UNCITRAL, we had been working on nothing to do with investor-state arbitration. It was pure commercial arbitration. And the issue first arose in 2008, February 2008, I remember vividly as if it were yesterday, in New York. As many of you will know, the 1976 UNCITRAL rules provide in the Article 25(4) that hearings shall be held in camera unless the parties agree otherwise. Even though the rules do not contain any other express provision on confidentiality, most users thereof in the field for which they were designed, commercial arbitration, see in that provision the manifestation of a wider underlying assumption of confidentiality in commercial arbitral proceedings, with the result that third parties and the public at large have no place within the arbitral process, no access to documents and no access to hearings. But the UNCITRAL rules, of course, were already by then, 2008, more and more frequently used in the field of investment arbitration. And this is a field where, it was being said, different considerations militated for a different approach. The arguments put forward by the propounders of transparency at the time were as follows. First, this is a field where tribunals are not simply adjudicating on commercial acts of commercial parties, but on sovereign acts of states. And that is an issue to which the learned judge just alluded. Are we in the realm of commercial law? I might come back to that in my second allocution later. Secondly, the substantive issues which arise for determination can have a real impact on citizens of the respondent state. For instance, because it concerns the supply of water or electricity of the capital city, or the price which users will have to pay for access to these essential services. Thirdly, awards from investment tribunals may have a very significant impact on public finances. The example very often wheeled out is that of the award in favor of CME against the Czech Republic of some $250 million, the payment of which necessitated the levy of a special tax. So these factors led to NGOs militating for a right of access to the arbitral process. The argument was made as follows in the Aguas del Tunari case in 2005, and I quote, "There is a strong and widespread public skepticism concerning the legitimacy," so I think that's where George got the word, "of this tribunal's resolution of Aguas del Tunari's claim, based in large part on the secrecy of the tribunal's proceedings and their potentially broad impacts. If not addressed, that skepticism could weaken public acceptance of this tribunal's award, as well as the operations of other arbitral tribunals." As of February 2008, work on the new UNCITRAL arbitration rules had been ongoing for about 18 months. NGOs, supported by a number of states, I seem to remember in Canada in particular, requested that these questions of transparency be dealt with as part of the work on the rules. Their demands were as follows. First, a separate treatment for investment arbitration and commercial arbitration, with transparency being the rule for investment arbitration. Transparency was to be the rules for everything involving a state or parastatal, whether ISDS or pure commercial arbitration. And the transparency regime had to include access to documents, amicus curiae, so the right to make submissions in proceedings, public hearings, and publication of awards. The NGOs were supported by Professor John Ruggie, who was then the UN Special Representative on Business and Human Rights, appointed by the Secretary General of the United Nations. There was, as you can expect, very strong reaction from the commercial practitioners in the room. And this led to a decision by the UNCITRAL Commission that very summer to separate that question from the work on the new UNCITRAL arbitration rules, what were to become the UNCITRAL Rules 2010, and to deal with this as a matter of priority immediately after the conclusion of the rules. So the manner in which the topic came to be singled out as one for immediate work by UNCITRAL is accordingly in itself symptomatic of the lack of trust of some in civil society in the way in which investment tribunals operated. And the difficulties which the working group then faced in carrying out the mandate given by the Commission were equally revealing of the lack of trust of a number of states themselves in investment arbitration more generally. And this rendered the whole work intensely political and fraught, which is very rare within UNCITRAL. Now has become the norm, but remember, in 2010, UNCITRAL works on technical issues, not political issues. But it took 3 years of work, and a solution was found in the form of the UNCITRAL Rules on Transparency, which, from the 1st of April 2014, created a transparency regime linked to the UNCITRAL arbitration rules for investor-state arbitrations conducted under future treaties, that is, under new post-2014 treaties. The difficulty, however, is that most arbitrations conducted today are conducted not under new treaties, not post-2014 treaties, but under a network of more than 3,000 pre-2004 treaties. So how could one render the transparency rules applicable to them? The creative answer which UNCITRAL came up with is the Mauritius Convention. The convention relies on the rule of public international law codified in Article 30 of the Vienna Convention on the Law of Treaties, which deals with the application of successive treaties relating to the same subject matter. In a nutshell, the Mauritius Convention operates as follows. Where a state party ratifies the Mauritius Convention, it effectively signifies its agreement to apply the UNCITRAL rules on transparency in any future dispute under its old investment treaties. So if you take the simplest example, if therefore the two state parties to an old BIT have both ratified the convention, this operates as an agreement on their part to replace their offer of confidential arbitration in the original BIT with the offer for transparent arbitration, which is in the successive treaty in the Mauritius Convention. This development has very significant ramifications. First, it is a significant development in its own right. The UNCITRAL transparency rules and the Mauritius Convention have effected a complete shift of paradigm away from confidentiality to transparency in this field dominated by issues of public interest and involving often a vast amount of public funds. But secondly, and of more direct relevance to today's topic, it showed that reform of ISDS, investor-state dispute settlement, was possible. First, on a practical and political level, as it showed that it was possible to reach multilateral agreement in the field of ISDS, despite the often stark differences of viewpoints which exist in the field. Importantly, and I ask you to keep that in mind as we move on through this panel, and again, bearing in mind some early remarks which the learned judge has made, that agreement was procedural, not substantive. Secondly, on a theoretical level, for years, those opposed to a change relied on the fragmented nature of the ISDS field, on the fact that the source was 3,000 separate treaties, to argue that even if desirable, reform was simply not possible, as it would entail the case-by-case amendment of all those treaties. The Mauritius Convention showed that the relevant changes could be made in one stroke through one multilateral convention. What then happened is that detailed research was commissioned. I won't bore you with the details, and there was then a commission decision on the back of that research, which showed that Article 30 could take further procedural weight to work on wider ISDS reform, including whether it might be possible to create an appellate mechanism or what was referred to in the paper from Michele Potesta and Professor Kaufmann-Kohler as a permanent investment tribunal, which everyone now refers to as the Multilateral Investment Court. So with the legal basis for wider reform of the ISDS system thus clear, UNCITRAL set out to do what it is now doing within UNCITRAL Working Group 3. Before ceding the floor to Jay, let me address one final point as to the process, which is, again, I think important to bear in mind. It wasn't a given that this project, this process, this reform would come to UNCITRAL. We, and when I say we, a number of developing states had to fight for that to happen. Because as some of you may know, the major proponent, or one of the major proponents of that reform, particularly of structural reforms, is the EU. And their initial inclination was to have regional conferences whereby they would go to Western Africa, Eastern Africa, Southern Africa, parts of Asia, and sell their idea, which we had no hesitation in telling them was really a new form of colonialism. If they wanted to debate reform, it had to be done in a proper format which would allow everyone to put their ideas on the table. And this is how we ended up at UNCITRAL. And to their credit, the EU, the moment this was raised, agreed to it. So the positives are now that we have a forum that looks for consensus and will hopefully create legitimacy. The drawback is that, of course, it's a very slow and painstaking process, which gives rise to multiple opportunities to derail the process at every juncture. And that is something we'll talk about a bit later. Jay, over to you.
Thank you, Salim. Jay, please give your views. Thank you for that insightful presentation, Salim. Thank you very much.
So thank you, Salim. So I'll tell you where we are with the working group. So just 2 months ago, on 7th of July on 2023, the Commission met in Boardroom D of the Vienna International Center, where UNCITRAL takes place, and they finalized the first set of reform elements during its annual session in Vienna. This included 2 texts to promote mediation to resolve investment disputes, so guidelines on the use of mediation, and model provisions for insertion into investment agreements, and a code of conduct for arbitrators and a code of conduct for judges. Of course, the code of conduct for judges was adopted in principle because we don't have a standing mechanism yet. But as Salim had mentioned, you have to rewind back about 6 years ago, and it was actually exactly 6 years ago on 10th of July, in the same boardroom that I had mentioned, it's Boardroom D, that the Commission met, and Salim was there, Shane was there, and entrusted the working group to, with a broad mandate to work on the possible reform of ISDS. I think this was based on as Salim has mentioned, this was based on the conviction that more broader reforms than transparency was needed, and that UNCITRAL was the appropriate forum to discuss these reforms. The Commission at that time agreed that the working group should identify the concerns about ISDS, and I think this is where Justice Viswanathan had mentioned some of the concerns that he had seen, consider the desirability of reforms, and to develop relevant solutions. And it is actually that resolution or that mandate that the working group got, that working group was able to present its first set of texts to the Commission this summer. The Working Group 3 began its work in November of 2017, where Shane was elected as the chair of the working group. Since then, the working group has held 12 one-week sessions, 8 in Vienna and 4 in New York. We also had a 2-week session in Vienna and a 2-day session also in Vienna. Progress is being made on the basis of a revised work plan that the working group agreed in May of 2021, and preparations are underway for the upcoming sessions to be held in Vienna in mid-October, which is 9 to 13 October of next month. I just wanted to touch upon the process of the working group itself. As mandated and in line with the UNCITRAL practice, negotiations at Working Group 3 have been led by governments. It has been based on consensus and fully transparent. While the Commission and the working groups are composed of 70 member states, we currently have 65 because we need to elect 5 more in 3 years. But other member states of the UN also participate as observers, along with a number of invited IGOs and NGOs. And in particular, efforts have been made to coordinate and cooperate with a number of international organizations, including UNCTAD, the World Bank Group, OECD, PCA, and since Meg is here, we have been cooperating exclusively, intensively with ICSID on the recent process. And while the submissions by governments have formed the basis for the first phase of discussions, it is a multi-stakeholder process. It involves developed and developing countries, academics, practitioners, as well as a number of interest groups. Most recent working group session attracted 580 people, so it shows that there is continued interest in the work of Working Group 3. And as with all decisions taken by the Commission, the texts that are prepared by the working group have been prepared on consensus basis. While the duration of the cooling off period for arbitrators was heavily debated, and whether we should be adopting a code of conduct for judges was also debated because the standing mechanism is not there, all decisions taken so far by the working group and the Commission have been based on consensus. All working papers, documents or submissions by governments, and the reports are publicly available on the working group website in all UN official languages. Information about the sessions, related events are all sent to the registered participants. And based on the positive experience gained during the pandemic, the Commission decided to continue the live streaming of the sessions to ensure inclusiveness and transparency, and also to allow the working group to adopt its report through a silence procedure, akin to a silence procedure, making it possible to devote the entire 5 days to substantive discussions. So while the pandemic has posed some challenges to the working group, resulting in the cancellation of a session, reduced conference time, limited in-person participation, progress was made in a hybrid format, and working group returned to its full in-person mode in September of 2022. Another lesson learned during the pandemic was how to make the most use of informal meetings to facilitate discussions prior to formal sittings. And in accordance with the working plan, the Secretariat organized a series of informal meetings, including intersessional meetings, the most recent one being in Singapore last week, where exchange of views on different reform elements took place. In some cases, compromise was sought. So with the vast number of reforms being discussed simultaneously, it became obvious that additional resources were necessary, and therefore a request was made to the General Assembly for additional resources, and therefore the working group meets 3 weeks a year instead of the 2 usual working group sessions, and we have that resources until 2025. In summary, while the negotiations in Working Group 3 is broadly in line with the practice of UNCITRAL, I see that there has been a number of new aspects that has been introduced by Working Group 3, and as such, it has also attracted a number of academics to conduct research on the process itself. I wanted to highlight the process of Working Group 3 a little bit, because what comes out of Working Group 3 needs to also be seen as a legitimate product. And that is why the process that Working Group 3 has embarked is to ensure the acceptance of the reform elements developed by the Working Group, to ensure the legitimacy of the process itself, including to the final reform, or the comprehensive reform of ISDS in general. And that is where we are now. With that, I would like to pass over the floor to the chair and possibly to Shane.
Thank you, Jay. Thank you, Jay, for that wonderful opening. Very, very relieving to know that the UNCITRAL group is actively engaged in considering the aspects of cooling off, of mediation, and that a rigorous process is underway. With that, may I now invite George Porton, Advocate Supreme Court, legal consultant, member UNCITRAL, has been writing about this, and invite him to present his views in the matter.
Thank you, Judge. Good afternoon, everyone. We've heard how we came to the project, which all started way back in the boardroom in 2008, followed by how the current system or where we are. I'll just touch upon the investment arbitration regime, how the Indian picture. We've heard the backlash against investment treaties from the inaugural session to the session prior to this, and at the chair's remarks. But not many would recollect the Indian experience on investment arbitration began with the Dabhol case. It was one termination of contract which led to 9 different treaty claims. This was the first case, but died a quiet death as the matter was settled before the arbitration commenced. Then came the White Industries case almost a decade later. This was the watershed moment in terms of investment treaty arbitration for India. It was not just the first arbitration which concluded, but this was also the first investment treaty award, which was an adverse award against India. There are questions as to the correctness of the award, whether it's right or wrong. This in itself is a debate for another day, so I'll not go into that. Well, the picture is not all that bad when it comes to India. Until date, among concluded arbitrations, we've had 5 adverse awards, but at the same time, we've had 6 awards which are which are in favor of India. It's post-white industries that we had an adverse award and India decided to revisit its investment treaty regime. After numerous discussions, consultations, finally in 2015, the cabinet adopted a new model BIT, which would form the basis for future treaty negotiations. This model, which is the initial point for initiating negotiations, was finalized taking into account the various experiences and lessons learned over the period, where we had some arbitrations initiated where essentially acts were treated or would be treated as essential sovereign space. Tribunals or investors were trying to impeach onto probably what was seen as sovereign space to bring about claims. Now, speaking about ISDS reforms at UNCITRAL Working Group, well, we've heard in yesterday's address where the Honorable Chief Justice mentioned the important role India played in having the subject allocated to Working Group 3. Just to touch upon that, it was 2016 when we had the last UNCITRAL conference, and UNCITRAL was looking at future work programs. The same year, India had hosted the International Law Week at the UN. Many in the room are aware of what transpired during those discussions, what happened then. There were various topics which are considered as probable future work for UNCITRAL. It was actually only in 2015 that the Commission first took note of the fact that the current ISDS system posed a number of challenges. Following on these discussions at the UN International Law Week, at the UNCITRAL conference hosted by India, and in 2016, the Commission also called for various presentations. The presentations at the International Law Week included many of them who actually represent states in these discussions. If you also read through India's 6 committee statements, you can know how vocal India was about having this subject as part of the UNCITRAL deliberations. Finally, after a lot of to and fro and after a lot of meetings, in 2017, UNCITRAL allocated the topic of ISDS reforms to Working Group 3. Today, 6 years later, after numerous deliberations, 6 years after the deliberations began, we have our first text on ISDS reforms adopted a couple of months ago. The draft code of conduct for judges and arbitrators, a welcome step. India was at the forefront and active in participation in the deliberations. However, I would like to point out that India was perhaps way ahead of time in this, because a model BIT in 2015, which is almost 8 years before the UNCITRAL finalized the text on arbitrator bias, had already a provision for arbitrator conflicts. Article 19 of the model BIT titled Prevention of Conflict of Interest of Arbitrator and Challenges. This is a very detailed but short article on what amounts to a possible conflict of interest of arbitrators and the procedure for a challenge in such a scenario. Like I said, this is almost a decade before UNCITRAL had finalized its text. Talking about the Transparency Convention, I'm sure Salim has been advocating countries to sign on to it, the Mauritius Convention. But if you look at the Indian model BIT, we have adopted almost the entirety of the Transparency Convention into it. And I use the word adopted because yesterday Mr. Nariman had told us in his language what is the difference between adopted and adapted, giving examples of the UNCITRAL model law on arbitration. When the model BIT of India was finalized, during the very process, it was finalized in 2015, the time between 2012 to 2015, during the discussions, India had envisaged the standing mechanism or a standalone appellate mechanism or appeals facility. And provisions for the same are envisaged in a model BIT in Article 29. In fact, Article 29 actually mentions about a future standing mechanism if India were to become a party to it, or if both countries who signed the treaty were to become a party to it, how that would be adopted to the existing BITs. Or in case of a standalone appeals mechanism, how the same could be adopted into the treaty without having to amend it. In fact, it is the Indian Supreme Court which had given a landmark judgment on the appellate mechanism within the arbitration system. This was in the Centrotrade case, Centrotrade versus Hindustan Cooper. In this case, it involved 2 layers of arbitration, a first round of arbitration seated in India, followed by a second round in London. The second round was an appeal mechanism. The commercial contract, I should say, envisaged an appellate mechanism, and the appeal outcome of the appeal would be the final outcome of the arbitration. So the appeals mechanism is still under discussion when our jurisprudence had already recognized it again a few years ago. So whilst India has been actively participating at UNCITRAL, India, through its jurisprudence and other means, has also been contributing very effectively to these deliberations and also to build jurisprudence in this area. Thank you. With that, I hand it over back to the chair.
Thank you, George, for that comprehensive presentation. You touched upon a wide range of topics. With that, may I now invite Shane. Shane is the Director General and Senior General Counsel, Trade Law Bureau, Department of Justice, Global Affairs, Canada, and the Chair of UNCITRAL Working Group 3. Shane, over to you.
Thank you, Justice, and thank you to Salim for explaining essentially how this all started, Jay for explaining where we are right now, and to George as well for offering us the Indian perspective and a description of what India itself has been doing over these past years, which brings back my mind to think that this is something that has been going on for quite a while. This is not a new project reform. Salim mentioned the work on transparency, and indeed, Canada was involved in that paper that started it, and I see my former boss, Secretary General Kinnear, who tasked me with a draft of that first Canadian position on one of my early days working in the Government of Canada. So some of us have been doing this for quite a while. It is, as Salim mentioned, slow and sometimes painstaking progress. That is in part due to the multilateral nature of the work. We have, as Jay mentioned, hundreds of delegates coming each time, representing countries from all corners of the world, usually over 100 states, and they all actively participate. Investor-state dispute settlement is something that many countries have direct experience with it, not all of it good. And so there are many perspectives that have to be shared. There's much we can learn from everybody who comes to participate at the working group. It is one of the more, sometimes I think, active working groups at UNCITRAL, in that sometimes when we're debating a question, the real question for me as the chair is there anybody left who hasn't spoken? Because I think we've heard from all 140 states who might be there. We do now, though, have some momentum. As Jay was mentioning, we have now completed work on some of the projects and brought the first projects to the Commission for approval. The other reason, of course, that this is so, might seem slow is not only do we have perspectives to hear, but we wish to move at a pace that ensures that every state can continue to participate. As Salim was mentioning, one of the reasons for going to UNCITRAL was the true multilateral nature of the work that UNCITRAL does. It is a forum where every state, regardless of if you're big or small, regardless of whether you're capital exporting or capital importing, regardless of whether your investors bring the claims for the most part or whether as a state you defend the claims, you have an equal voice in UNCITRAL. And it was important, therefore, not only that we bring it to this forum, but also that we move at a pace that allows governments to keep abreast of the work that we're doing. Governments have different resources, different capacities, and we certainly didn't want to outstrip any of those officials who were able to come and participate in their capacity to keep up. Because of course, this is all about where we're going in the end. The work that we do now has to lead to some sort of product in the end, some sort of reform of a system which I can say has been recognized by consensus in the working group as needing change, as needing reform. Now, obviously, I can't say with certainty where this project is going. That will be for the working group to decide. What I can offer you is really some perspective as the chair of the process and where that might be headed. We are currently engaged, as was discussed, in a number of pieces of reform. We have broken our work up into a number of work streams in an effort to make the individual sessions manageable. One cannot simply sit down at UNCITRAL with 500 delegates and say, okay, let's fix the system. You would just get a bunch of blank stares. That's too much to do. So we have these individual pieces. But these pieces are really like pieces in a puzzle. None of them in and of itself is enough to give you the whole picture of the reform that we are trying to adopt. For example, as Jay mentioned, we just finished our work on codes of conduct for arbitrators and judges, as well as some pieces on mediation. These are, without doubt, extremely important pieces of reform, but they are not in and of themselves sufficient to solve all of the problems with the system. They are essentially first steps. We have a number of other pieces that we're developing. Salim mentioned the multilateral investment court, an appellate mechanism. There is work ongoing on procedural rules. There is work ongoing on an advisory center for developing states to assist them in their work. All of these pieces of the puzzle will be developed over the next few years, but then there is the big question at the end. How does this all become a single package? How does this all fit together to give a comprehensive set of reforms? And this is why it was so important for Salim to start us off with talking about the Mauritius Convention, because it does lay the theoretical foundation for much of what we are doing. That what we are trying to do is reform an existing mass of treaties with hopefully a single multilateral convention that can introduce into those treaties various different elements to bring them up to what we would consider modern best practices. The real question is no longer, can that be done? We learned with the Mauritius Convention that yes, it can be done. Legally, we can do this. The question that the working group will have to address is how does each of those individual reform elements fit into that convention? How does that create this picture that we're trying to get out of all these individual pieces? As I look forward, what it seems to me we're moving towards is some sort of framework convention, as it's been called. There are other names for it. But an overarching agreement that would include some core elements and then possibly some optionality. Now, why is there that additional level of optionality? Why not just a standard convention that applies to all existing treaties? One of the big reasons for that has been the desire of states to be able to reflect upon their own experience and make their own sovereign decisions as to what types of reforms suit them the best. That is essentially the process for UNCITRAL. UNCITRAL works together as a global community to develop conventions, to develop model laws, but each state in the end has a sovereign decision to make. That will be the case here. However, there is also on the other side of that the question of further fragmentation, of harmonization. One of UNCITRAL's goals is, of course, the harmonization of international trade law. Developing any sort of convention where there is too much optionality risks further fragmentation. So as we move towards this ultimate goal and this ultimate hopeful result, we see a core, a convention, a framework convention with a core set of elements that hopefully there can be consensus on. perhaps some optional protocols that states might be able to sign on to if they so choose, whether they could be called other things than optional protocols. I think they're annexes, they could be through reservations, but some level of optionality while trying to ensure that there is an appropriate level of harmonization so that we can avoid a further fragmentation of the system. The plan and the detailed work plan we have calls for this to wrap up in about 2027, I believe. That is still ambitious. There is much work to do. There is much work amongst delegates to keep abreast of developments, to keep up to date on the topics to ensure that we can get this done. But we have been working on it since 2017, and so the year 2027 was not chosen by accident. That will be a decade of working on this type of reform, which I think when we were talking about what that end date would be, everyone recognized a decade should hopefully be enough to get this done. We'll all be much older and grayer and looking at the next generation who will be taking this over from us. So that is hopefully where we are headed, to some sort of agreement, and hopefully we reach that by 2027. Thank you.
Comprehensive address. In the second round now, we had Shane going first, but I think you already discussed the compromise formula, or do you want to elaborately deal with it? Yeah. Would you then introduce the compromise formula of the two tracks, and then I'll invite Salim.
Maybe I won't get up for this one then, since I just sat down. One of the big questions, and I did mention, how do we organize our work here? We had a three-part mandate in Working Group 3. The first part was to identify concerns with respect to investor-state dispute settlement. The second was to consider whether those concerns warranted reform. And the third was, if we concluded they did, to actually develop the reforms. We spent a couple of years talking about talking about the concerns, having the ability of states to express their doubts, their problems with the system. By the time we got to the third phase of our work, which was developing the actual reforms, we realized exactly how much we had on our plate. There were numerous ideas to address, numerous concerns raised by states that needed to be scheduled, various options for reform that needed to be considered. And so what we essentially needed was some sort of rough work plan. Even though this was a procedural question about what would our next sessions look like, it turned out to be probably one of the most intractable that I've experienced in my 10 or so, 15 years coming to UNCITRAL. It was at a New York session where it became clear that there were really two different groups in the room. There were those who felt that the concerns about bias that had been mentioned by the justice about the unfairness were endemic to this system. That in any system of ad hoc party-appointed arbitration, where there was not a standing mechanism, that these concerns would continue, that concerns about consistency and correctness without a standing mechanism could not be fixed. And so for that group of states, the key really was structural reform, the creation of a standing body. On the other hand, there was a group of states who did not want to engage in that discussion of structural reform. They felt the concerns could be best addressed instead through, I'll say, non-structural reforms, like addressing a code of conduct, procedural rules that would modernize many of the older treaties that Salim mentioned were the subject of disputes, but would keep intact the core part of party-appointed ad hoc arbitration. There wasn't much shared vision amongst these two groups. And so it took a very long, informal session in a separate room on a Thursday morning in New York to hammer out a compromise. And that compromise was essentially to move both structural reform and non-structural reform ahead simultaneously, to ensure there was an equal balance between consideration of structural reform and non-structural reforms, and that's why you will see in our work plan that we might have a week of work dedicated. There might be 3 days on the appellate mechanism and 2 days on procedural rules. So instead of devoting all our time to one type of reform, finishing that and moving to the next, we have this compromise developed where we are pushing forward various different types of reform at the same time, trying to move them to the Commission when they get ready, but ensuring that equal balance.
Thank you, Shane, for that additional input. And now I invite Salim to elucidate on the structural reforms. But I would also request Salim and George, practitioners as they are, to also touch upon the feasibility of an appellate review. What kind of review would be there, or would it compromise on time? And secondly, on also the aspects of enforcement.
Yeah,
enforcement of awards.
If I may, I might just deal with structural reform for now, because it's a broad enough a topic as it is, with your permission, Judge. I've been looking at all of you, and I get the feeling that you are all a bit disappointed, right? No? I mean, you've been told this is the most controversial area of law in the world at the moment, and all these guys are standing out in front of you making it as uncontroversial. Now, I know why that is, and I figured it out. They've told us, in fact. Shane, of course, is the chair, so he can't be controversial. And his former boss is here. George's boss is here. Jay's boss is here. What do you expect? So I'm going to try and make this a bit controversial, okay? So let's try. I'm here to talk about structural reform. So essentially, this is, as you've heard, the multilateral investment court, or at the very least, the possibility of an appellate mechanism, right? The premise of this proposal is that the problems with the current ISDS system are systemic. They are structural. And therefore, they call for structural or systemic reform. Why is that? Just pause for a second. Where does ISDS come from? Because in the 1960s, it was decided that instead of having a fight about what the substantive standard would be for breaches of rights of foreigners, let's put it as broadly as one can, in a foreign country, in a given country, there would be a procedural solution found. One would go to arbitration. Fantastic. And of course, arbitration is a long pedigree for state-to-state disputes. But what was the model that emerged from the beginning when those cases started being heard? It was the paradigm that was adopted was the paradigm of commercial arbitration, which is precisely why you see, perhaps accepting ICSID, but why you see the UNCITRAL rules being adopted to do these cases. And look at the personnel that was used. It was personnel from commercial arbitration. Now, commercial arbitration is by its very nature a fragmented system. There's no problem at all with that. There's no reason for coherence in decision-making between a contract between Toshiba and some other company for spare parts in India and Areva and Siemens on sales of uranium. There's no search for consistency there. There's nothing systemic in there. It's fragmented. If you read, for example, there's a lovely judgment by the Court of Appeal in England called Lincoln and Son, where the judges say the only duty of the commercial arbitrators is to the parties. Now, for many, investment arbitration is entirely different. The duties go well beyond that for the reasons I mentioned earlier. There are duties to the system, not just to the parties. So what happened is you've had this system of ad hoc arbitration that has fragmented the whole field, which means that today you cannot have any body of jurisprudence, coherent, binding, and you've got to maneuver this. And so the premise of the systemic and structural approach is to say, to fix that, you need to create a structure. You need to create a system. And how do you do that? Well, obviously, if you have a permanent court, if you have a multilateral investment court with on top of it an appellate system that can finally decide certain issues, then you introduce structure. It would also deal with consolidation and joinder. It would deal, very importantly, with a problem that many have identified, including those who are not in favor of structural reform. And I'm talking about the lack of neutrality of party-appointed arbitrators. And I think it's a problem that is more and more recognized. The reality is that this has developed as a business model. If you are known as a claimant arbitrator, you will get appointments by claimants. If you are known as a state arbitrator, you get appointment by states. If you have the unfortunate position of having to chair the whole thing, you hear the case being re-argued by your co-arbitrators. Is that how it's supposed to work? And this is what led Jan Paulsen, of course, to suggest that all arbitrators should be appointed neutrally. So again, the idea is if you have a court, then you would get rid of all of this. So that, if you want, is the core of the proposal. There's much more granular than that, but that's the core. There's a lot of resistance from states that see their investors derive significant benefit from the current system, and from practitioners who, of course, benefit very well as well from the status quo. And that's based on a number of assertions or assumptions. Let me mention three of those that are most often wheeled out. One is, oh, you're going to have an appellate mechanism, but you can't have a body of coherent jurisprudence because you've got fragmented treaties. You've got 3,000 treaties. And this was, no, I won't say which country in particular puts that forward, but that particular country must then not have a system of contract law in its country, in domestic law, because every contract is drafted differently. Surely, then you can't have principles of contract law. Doesn't stack up. Another argument that's frequently made is that a permanent court will necessarily be biased in favor of states. And I say it could be, doesn't have to be. The current system, which investors want to retain, was created by states. So the idea that because you're going to have judges on a permanent court, they will, by their very nature, be biased against states, when in fact there will be within the states forming the court investor-friendly states. Not sure one can take that as a given. And then there's a big question about execution of the court's judgment, which are technical, but to which there are answers too. So the resistance has come, as you've heard from Shane, by pushing non-structural, systemic, non-systemic incremental reform. And it said, oh, these are low-hanging fruits, but they're so low-hanging that they're not really worth catching. Is a code of conduct really going to change the face of everything we've been discussing now? Mediation? Yes. If you're going to have, we hear of these funds being invested in the field, yes, you can be sure that their aim is mediation. An advisory center, these are all important steps. Are they going to cure those systemic questions? And there's a question as to the legitimacy of this type of resistance to say today, we do not want to work on structural reform, or we will oppose at every step, re-arguing the same points. Why do you need a court? Why do you need an appellate mechanism? The whole point of the compromise, which Shane was talking about, was that everyone could build his own building block within UNCITRAL and then opt. That's the whole idea. That's how we worked on transparency. So I would say there's no good faith if, having agreed to that, you don't let those who want to work on particular solutions to work on those particular solutions and make Shane's work so much easier. So in conclusion, I would say, I'm not saying structural reform is going to work. I'm certainly saying one cannot assume that it is not going to work, as those with a vested interest in the current system assert. And also, and very importantly for our part of the world, it would be a fantastic opportunity to introduce diversity, both, of course, regarding the identity of the decision makers, if you have judges appointed by countries including ours, and also geographic locations. You could have, that court need not be localized in a given place. It could be localized in the region where the given state is. I had more notes, but it's been too long and probably too controversial. Thank you.
Thank you, Salim. Thank you. May I now invite Jay for the talk on the incremental reforms. Jay.
Thank you. It's always difficult to go after Salim, especially as he was the chair of the working group that I also serviced. And I'm also supposed to talk about incremental reforms, but I would like to actually rebut Salim's point in a number of, in one aspect. I think the distinction between the structural and non-structural reforms is becoming a little bit unclear in the working group. It is not two different reforms, it is actually reforms that go together as part of the bigger package. For example, the establishment of the advisory center. It is a structural reform because we are creating a new structure. That is supposed to be discussed by the working group and will be presented to the Commission in the summer of next year. We're also having a guidance text on dispute prevention and mitigation, and we're also thinking about whether the court or the standing mechanism would have certain roles to play in dispute prevention and mitigations. So the borderline between structural and non-structural reform is a little bit different. The working group is going to be discussing in October a paper on procedural and cross-cutting issues. It's easier said, it looks like one document, but if you look at the contents of it, it deals with exhaustion of local remedies, right to regulate, calculation of damages, denial of benefits, shareholder claims. These all apply whether it's structural, whether it's a standing mechanism, or it's in arbitration. So in a sense, these procedural and cross-cutting issues are actually cross-cutting, therefore they apply to both structural and non-structural reforms. And that is why I think from the Secretariat perspective, we don't try to distinguish whether this is a structural reform, whether it's a non-structural reform, and the recent paper on the procedural and cross-cutting issues have been prepared actually to apply to any proceedings that will take place in a court. I think that is why, as Shane had mentioned, the working group has to address not only the big policy questions, but now how the different reform elements are going to be put together, how the puzzle pieces will be coming together. And I think that is why it's almost time for the working group to have a discussion on the delivery mechanism, the framework agreement, to ensure what will be the core provisions that will be the center of that framework agreement. That would make our Secretariat life easier, because that would also make it easier for us to indicate what are to be the core provisions and what are to be the optional provisions. As with any other reform options, reform projects, I think it is time, and this is, I quote the justice from yesterday, it is with great respect to the working group and the chair of the working group, that it is time for the working group to make choices on how best to improve the system. As noted, this requires consensus of the working group and the Commission. And I think, as Shane had mentioned, the current work entails more complexity as it aims to leave a lot of optionality to the states to choose from those options. And then in the end, the investors would then have a choice to whether they opt into that mechanism or another mechanism. So I think this optionality is a big burden, especially for the Secretariat to prepare our working papers, and that is why I call on the working group and the chair to make certain decisions to make our life easier as well. Thank you.
Thank you, Jay. Thank you. That was useful. May I now invite George to give his concluding remarks and his overall thoughts in the matter.
Thank you. We've heard both the mechanism, the incremental and the structural reforms. So what could be a possible way forward? Well, the answer is we definitely need to discuss both reform tracks, that's incremental reforms and structural reforms. Incremental reforms, if you ask me, needs priority, as many existing and older treaties, old generation treaties, provide for arbitration as the dispute settlement mechanism and arbitration under the UNCITRAL rules. We've learned about the problems here in this mechanism and need to fix them, as the existing cases under this system, even if treaties are terminated because they excess of sunset clauses, are under the current system. We can't just let it be. The permanent structure is an ambitious project, the success of which can only be determined once we have it in place and once we know how many join the system. The draft code of conduct for judges is a welcome development, but I ask this question: isn't having a code of conduct before the formation of a court like parking the cart before the horse? Questions like who are the judges? What is their mode of appointment? How are they going to be appointed? The permutations and combinations of the judges of this permanent structure who are going to decide on a particular case need careful consideration. Then comes the finality and enforcement of the outcome of this permanent structure, which needs further clarity. In conclusion, I echo the words of the Honorable Chief Justice of India on the possibility of floating courts, where other reputed institutions like the PCA can contribute to the host country agreements. And as mentioned, it would add to the process of access to justice and may also contribute to reduction in cost. But as always, any new mechanism could have its fault lines, and we all learn from our experiences. What is important is to have a mechanism to redress or reform the system which can have further reforms without hassles. This topic on structural reforms definitely needs deliberation and definitely needs to go forward. But as of today, it is still academic, and we need to see what the outcome at UNCITRAL is. With that, I'll just address the two questions Justice Vishwanathan had asked. First, on the enforcement. If it's on the enforcement of the appellate mechanism, I believe it should be something which can be merged seamlessly into the existing legal systems. One such possibility is to recognize the outcome of this structure as awards under the New York Convention. Well, there is still a debate on whether it is covered under the commercial reservation, but I still believe recognizing them as awards under the New York Convention would allow for seamless enforcement of the award through the already established mechanisms and legal system across the world. The New York Convention today has 170 plus signatories, so that wouldn't be a problem. On the other question of appellate mechanism, the Indian jurisprudence, as I mentioned earlier, has already recognized an appellate system within arbitration in the Centro Trade case. And interestingly, this was arbitration, so the first level was in a particular jurisdiction and the second in a foreign jurisdiction. The arguments and the deliberations were, as usual, on the public policy debate, the unruly horse, as Jan Paulsen calls it. We do not know how other jurisdictions see it, but we know how the Indian jurisprudence has developed on this, which could perhaps help in formulating the jurisprudence in other jurisdictions. But how do we look at the relevance of seat of arbitration if you are looking at an appeal system within arbitration in different jurisdictions? At what stage do you go to a court? At what stage does the law at the relevant seat of arbitration be applicable? Is it in the first level of arbitration? Or at the first level of arbitration, is it that you have no remedy and you go only to an appellate mechanism? And is it there that the seat of arbitration is relevant? These are questions which need careful consideration and need to be addressed before you create this whole system. The other system is the standalone appellate mechanism. Here the question is, if it's a standalone permanent mechanism, is there a relevance to the seat of arbitration? Is it going to be something like the ICSID, where there's no relevance to the seat of arbitration? In such a case, how are you going to treat the awards? Like I mentioned, are they going to be under the New York Convention? How are they going to be enforced? And the last point on the enforcement and the appellate mechanism, do you envisage judicial supervision at all? Judicial supervision, by judicial supervision I mean not judicial intervention, but supervision in the form of the law at the seat of arbitration. Thank you.
Thank you, George, for that address. Now, do I have the permission to throw open the floor for questions? Because how many minutes can we have? Anybody wanting to ask, please identify yourself and address your question to the panelists. Yes, Piyush? You are sufficiently audible. I don't know what.
My question is just,
Thank you, sir. My question is just the fact that the main issue that arises in interstate investor-state disputes is that in the framework that has been established to protect the investor, there's a sort of skewed mechanism which has resulted in three basic consequences. One is that the investor could even be a shell company. Now, there's no real mechanism around that because a whole lot of jurisprudence that has evolved is essentially saying that if the company is incorporated outside the event, that is a foreign investor. So this has a imbalance because the shell company can disappear, but the assets of the state are very much there for people to see. So that if a claim is there against, say, the Republic of India, you still cannot go after the invalid investor, but the invalid investor can go after India's assets everywhere. The second issue that comes is in my nature of which damages are claimed, because a whole lot of damages that we have seen in BITs are not the type of damages that will survive any domestic test, because they are more like consequential damages that had I continued to invest for the next 25 years, I would have earned 10 times, and that is my claim against the state for having done something. At the same time, there's no balance for a counterclaim. Like, India cannot counterclaim against an investor for sitting on its resources for 5 years, and India losing out on the opportunity to export or develop something which may have been vested with that investor. And consequently, there's a clear imbalance, and therefore investors see it. Investors see it as a way to get around a domestic system and also get better returns than having actually invested. So I just wanted to know if these points could be covered in these reforms in any manner.
Shane, would you take the first part of it, and I'll request Salim to take the damages part. First part on the
With the permission of the chair, can I just ask a corollary to what my learned friend has just said here before me, the earlier speaker?
Yes, Lata.
Now, yes, I wanted to know the same thing about the reflective loss, the claim by shareholders for reflective loss, a concept, you know, a claim which is disallowed under most domestic jurisdiction. And yet, several judgments have been given consistently permitting such claims. Now, a host country, which is already a needy country, he talked about the imbalance, the host country is already a needy country wanting the investment. Even if there is a lot of transparency about it, they find themselves unable to, you know, sort of go on making payments under two heads. The direct claims are okay, but then to ask for this kind of reflective loss, like the imagined loss that he was talking about, the perpetual loss that could have, that could diminish the value of the shares, etc., etc. So I would like to know if the working group 3 had an opportunity to examine that at some length, because most host countries, which have to come on board with everything, would be most keen to know how that is going to be dealt with.
There it goes. Yes, thank you very much for the questions. I can address, I think, pretty much all of them with saying that each one of the issues that has been mentioned so far is in fact on the agenda of the working group as an area for reform. So taking the last one first, reflective loss is something that the working group has specifically heard about. There were a number of papers that were done by the OECD and David Gaukroger at the OECD, in-depth treatments. They were brought to UNCITRAL as a working group. And in fact, in the draft procedural rules that Jay mentioned recently, there are provisions for the working group to consider on reflective loss and how to deal with that. Similarly, on questions about shell companies, and I take the question was as much about security for costs or the ability of states to recover since a shell company can lose and disappear. And I can certainly say, as putting on my Government of Canada hat as a Director General of the Trade Law Bureau, we have had a number of cases where we have been unable to recover costs awards against companies because they have been shell companies and have just vanished. This is also on the agenda of the working group, and in our procedural rules, there are drafts on security for costs, rules on when costs are to be awarded, as well as rules potentially to consider on standing. I won't get into the substance of damages. Maybe somebody else on the panel can do that. As Salim mentioned, I do sometimes have to be cautious as the chair. I can say, however, that the issue of damages is one that has been raised by a number of members of the working group. It is clearly of substantial importance. There is a lot of concern with how damages are being calculated amongst the states that come to UNCITRAL, and in particular with the increasing turn to discounted cash flow analysis and lost profits. And so this is also on the agenda of the working group. The Secretariat has prepared a specific paper on damages. The working group does now have a couple of questions to answer, and that is whether it is within the procedural mandate the working group has, how, if it is, how it might try to craft procedural rules to address what might be considered in some instances substantive questions. So what I can say is the working group will turn its mind to that, and will do so in the near future, as it's on the agenda even coming up this September. But I don't have any answers for you on how that might go yet.
Salim, can I request you to?
Yeah, I'm going to not answer each and every of these questions. We could go on forever talking about the granular answers to your questions. I think Shane has already given you one answer, which is there on the table. I'm going to address a slightly different point, but I think you will see related to what you're asking, which is this question of procedural reform against substantive reform. And you can see that some of the things you've mentioned could be classified in one or the other pot, right? Damages perhaps falling more in the latter. Pragmatically, and for legal reasons, the mandate that has been given to the working group is one to work on procedural reform. Pragmatically, why? You can see already just working on procedural reform is not easy at all. If you add into this, for example, trying to find agreement as to what fair and equitable treatment means, of course there never will be, there never was. So that's not going to work. So the idea was to be pragmatic as to what might be achieved. As a matter of law, you will also remember that the implementing mechanism will be the Mauritius Convention type convention. So you have to see how much weight Article 30 can take. There must come a point where this becomes a disguised amendment. So there are also legal issues to maneuver there. I would make a second related point, which may also explain, and it's not often talked about, but may also explain a lot of the resistance that there is within states that like the current system to structural reform. And it would be this, and you reflect upon this and see whether you agree, but I would submit that procedure drives substance. If in the 1960s this system hadn't been put in place with the personnel that then emerged, you might not have got the interpretations of those treaties that we have today. The procedure chosen, arbitration, which became based on the paradigm of commercial arbitration as it existed, drove a certain type of solution. There's nothing dreadful about this. That's how things work. You can also see that how if you created a permanent court that would see all of these cases and it would have to introduce coherence to this, you might well come to different solutions. And for example, you could have a shift of paradigm. You could have, as many within the field have been arguing, the court saying, well, this is essentially not commercial law. This is not about the sort of calculation of damages that you are talking about now in the awards. This is really administrative law of a different type, under different standards, but you're reviewing state action. And in admin law, in most domestic fora, you will not get very large awards of damages against the state because the courts are very conscious that you're taking away from the health budget or the education budget. So you can imagine that a permanent tribunal which would start looking at this through this different prism could come to very different solutions. Not advocating for it one way or the other, just this is how it could end up.
Yes, thank you, Salim. Thank you, Shane. Yes, would you please identify yourself and then pose the question to the panel?
Sir, myself, am I audible?
Yes.
Myself, Gauri Shankar Dubey. I am a non-lawyer, but did PGD in ETDA after retirement from government service. My question, I represent Construction Industry Arbitration Council of Delhi. That is Construction Industry Development Council extended arm. My small two questions are reforms, structural reforms and implementable reforms. Is there any provision for rebuttal in ISDS? Thank you, sir, for giving this opportunity to me.
George, will you take that?
I mean, I was trying to understand what is meant by rebuttal. Is it counterclaims? Okay, so an appellate mechanism. As on date, the ISDS mechanism is the arbitration what you follow. There is no appellate mechanism. The appellate mechanism is one of the reforms being discussed under UNCITRAL. In the current system, what you have is a challenge to the award in the seat of arbitration in case of UNCITRAL awards. In case of ICSID awards, I think Meg would be better to say, talk about it, but there is a provision for annulment of awards on certain grounds, which are mentioned under the ICSID convention.
Thank you, George. Thank you.
My name is Shantanu Pachahara. I'm an assistant professor at Rashtriya Raksha University. So my question is, as you pointed out, equal voice and balancing of the interest of the states, and we have already seen backlash against ISDS way of functioning. So what are your views regarding the possibility of the third world approach to international law of investment arbitration getting morphed into the current neoliberal approach of the capital exporting states in ISDS dispute resolution? Will we ever see it in real getting manifested in your text, or would it only remain to the textbooks? Thank you.
Thank you. I guess whether or not we see a different approach, in my mind, comes down to what the states want. In the context of UNCITRAL, this is not a process that is driven by myself or the Secretariat. It is a facilitated discussion. So if there are states who want to introduce a different framework for thinking about the procedural aspects of this dispute resolution, then it is open to those states to bring that. And UNCITRAL works that those states would have to discuss with other states to build consensus in the room, and that facilitated discussion can happen. I'm not sure that I've to date seen some real push for some of that, but it would be completely open to some governments to lead that if that's what they wanted to do.
Salim wants to supplement to that answer.
I think Shane makes a very important point, which is this is a state-driven process. So what you need is a state to adopt, for example, the position that you seem to advocate. and then build consensus around it. You see, it's all very nice to come in a conference room and say, from the perspective of a sovereign state, I say this, I say that, I say this. Well, you are a sovereign state. So act, analyze, actually look at the issues and propose solutions. Just railing against the system is not going to change it. And in terms of building consensus, this is where perhaps fora like ALCO and others can help. Because as you say, there is definitely room for, you say, a third world approach or a developing nation approach. I think India has to be careful and think carefully about what it wants as well. It's becoming increasingly an investor state, and it will be as the years go by. But I think Shane's point is very important. It has to be state-led.
Yeah. You're not audible.
Maybe I steal the microphone.
Hello.
No, I don't.
So I'm sorry. Well, good afternoon, everybody. I'm Gudmundur. I'm a professor at Tyndall Law School, and I've been representing Iceland in the working group since 2017. Now, colleagues on the podium know my views about the permanent court. Following on what Selim said, I've said many times that we are not bringing anyone kicking and screaming to this court. If they don't want the court, that's fine, but just don't stand in our way when we're trying to establish it. Now, I have a question. I don't know which of you can answer, which may be of interest to the audience here. How many states would you say are in support of the idea of a permanent court, given the caveats we heard from George about we don't know exactly the final form?
Jay, would you like to take that? Or Shane?
I don't want to be the one counting. And I think the states actually are taking, I don't think, we know the stance of some of the states. And I think some of the states are actually looking into the designing of this. They want to see the design and the structure of the standing mechanism before they take its stance on it. So I think I don't want to be the one counting. I don't want to say 27, but Shane?
I'm not going to answer your question either, Gudmundur. I definitely don't want to be the one counting at this point. I would say that Jay is right. There are a number of states that have made clear, and Salim mentioned some of them. Obviously, the European Union has this in some of its existing treaties already. There have been a number of other states from other geographic regions that have expressed a significant interest in the court, in the establishment of a court. There are a significant number of states, though, who are simply interested in following the work and making their decision based upon what the court looks like. One of the challenges that I think we've really had, and I've tried to steer the working group away from with varying degrees of success, is having people argue about whether a court would solve the issues based on assumptions that they make about what the court would look like. And so they'll say things like, well, you know, it won't work because there won't be any investor say at all in any way in who's appointed to the court. And part of the answer is to that was we haven't decided that yet. We've talked about various ways in which the investor community could participate at various levels, even though there might be state appointment in the end. So I think there's a lot who are trying to keep an open mind, and we're not at the point yet where we are starting to count. I don't think that that would be a useful thing to try and do at this point. I think a lot would be in the simply interested but undecided category anyways.
Yeah, I would go further. I think it's not right that we should have to count, because the whole purpose of having the two tracks was to allow those who wanted to work on structural reform to do so unhindered, and those who wanted to work on incremental reform to do so unhindered. And instead, what we're seeing is that there is, because of course these are all big stakes, there's a lot of games being played as to how to slow down one track or the other, with one track being particularly targeted. But then it's going to be an issue of political will, and might is right in the usual way. I mean, you've got a very big state, no prizes for guessing its name. that wants to keep the system as it is, but itself hasn't put itself in a position where it can be sued. I mean, draw whatever lessons you can from that. And it will use its influence, as it's absolutely its right, for countries not to move away from the current system. On the other hand, you've got the EU, that is also an attractive place for many of our smaller countries to, I'm not counting India, of course, I'm saying Mauritius, to invest in. And they have an FTA, which makes it very plain what it is they expect. So if you're going to have an FTA or the like with the EU that calls for being a member of the court, are you going to say no? So that becomes incredibly political, and there's no way one can count now. Yes.
Thank you, sir. Hi, I'm Inan Gupta, no qualifications to speak of as such. My question is somewhat an extension of what Mr. Moolan said. Has there been a discussion, explicit or implied, on is ISDS even necessary? And if so, to what extent? In the sense that empirical evidence does show that it's not a great determinant of the decision to make the investment. And I believe the answer to this question will significantly inform discussions on, say, exhaustion of local remedies, etc. So your thoughts on that?
George, would you like to take that?
Yeah, the question of is ISDS required, or does ISDS have an impact on investment inflow? Just like you mentioned, India and US do not have a bilateral investment treaty, but there's a good flow of investment between the two countries. But where does the question of ISDS come at all? What is the reason for an investment treaty? Is to provide certain assurances to an investor. You're providing them with a cushion. You're not ceding sovereign power to the investor. So these are treaty negotiations, maybe multilateral treaties, bilateral treaties. It is for the two states sitting across the table to decide whether it's required at all. The Australian position keeps changing. At times they say that they don't want an ISDS system in their treaties. Sometimes they want an ISDS system. That depends on the government at any stage or the two countries negotiating. But on a question, like you mentioned, studies have shown that ISDS does not have an impact on the investment inflows.
Shane.
Thanks. Thanks. I would just add, if the question is, has this been discussed in the working group? I think one of the advantages that UNCITRAL as a forum has is that it does invite civil society groups and NGOs to come in and present and make their views known as well. The need for, and whether these treaties should simply be terminated or ISDS be terminated, has certainly been raised by a number of these civil society groups who have come, who have made presentations, who have described what they consider the problems with this form of dispute resolution. So it is certainly something that all the member states of the working group have heard, have considered, but to date, the interest in the consensus has been to work on reforming the system and developing both structural and procedural reforms.
Salim wants to.
Just very briefly to, as Shaila said, in terms of process, that's absolutely been raised. I just wanted to mention one thing, which is that when there's debate about the justification for investment treaties, one always talks about promoting economic flows. And that, I think, on balance of what I have seen no empirical evidence that shows anything one way or the other. I'll give a very amusing anecdote for all of you here in the room. It will be very amusing. You had a very prominent figure in the field arguing that, well, look at India. It increased the investment flows into India drastically, because he said, in the 80s, they signed treaties, and in the 90s, early 90s, flow of investment went up. Perhaps someone should tell him something happened around 1991 in India, but okay, which is not linked to investment treaties. So what do you say to this sort of thing? But that's what's being wheeled out at conferences. So, and that's the usual justification. You can't say anything one way or the other. There's another one I want you to think about. Maybe you already have it in mind, which is the promotion of the rule of law. Whether we want it or not, and I'm not taking examples, there are certain states where it is not possible to get domestic review of executive action in any meaningfully fair way. And even for those who live in that country, to be able to have a binding declaration from a tribunal under public international law, as you said, not bound by domestic law because it's there to look at the state acting globally through its three arms to see whether there has been unfairness. But imagine you've got that, but you could weed out what each of you is thinking is a problem with the system. For example, too high a measure of damages or what is perceived as arbitrary damages, all this or that or the other. But you keep the baby and you just throw away the bathwater, and you keep this element of rule of law for states that may not have it domestically. Is that not a good thing to think about?
Yes, I think we could conclude.
Rahul Donde, Levi Kaufman College, Geneva. Thank you very much for these excellent presentations. I think they snapshot the progress of the working group very well. I have two questions. The first is when it comes to state participation in the working group, I'm curious about the participation of the countries that form the Global South. Are there any particular issues that they find, that they feel particularly for? Something that bothers them, something that they want to actively see? If so, what is it? And the second question I have is more about the working of the working group, if I may. And that is that I understand that one can follow the discussions at the working group on the basis of papers which are produced after the working group has its various sessions. But in those papers, there is no attribution of comments by state. And that makes it difficult to understand what any given state's position is on any given issue. And it ties into what Salim was saying a bit earlier, which is that the states have a role and they can express themselves. But it's difficult to see how a state has expressed itself. And has there been ever a thought within the working group that the state interventions should be attributed to the state, and that would make the entire process more transparent, potentially more democratic, and allow for external civil society organizations based in those states to contribute and comment on their state's position? Thank you.
Thank you. Jay, can I ask you to go first on that?
Thank you. So there has not been a single position of the Global South. That has not been the case. Each member state participates in the working group as an individual member state, and their contributions and their comments have been actually focusing on their concerns, which we have been identifying as cross-cutting issues. So I think their concerns have already been reflected in the work plan of the working group. And in order to facilitate their participation in the working group, the UNCITRAL actually has a trust fund which allows to support the travel of delegations from the Global South to participate in the working group's discussions. This is with the contributions from the EU and the Swiss contributions that we are able to support travel of member delegations to our working group sessions. Now, it has been UNCITRAL practice not to attribute the comments made by delegations in the working group. It is actually against the policy of achieving consensus, in the sense that if you attribute certain comments to each delegations, they may not be more open to making those statements. However, while the report does not attribute a certain statement made by states, if you look at the audio recording of the sessions which are available after the session, you can find out what the delegations of each member state has said. So it is not as if that information is not available. The report itself is a short summary of what has been discussed and possibly what has been decided in order for the working group to make progress in the future stages. And that is why the working group report is produced in that way.
Shane, would you want to supplement on that?
Thanks. As Jay mentioned on the second one, you can certainly go and listen to the entire week's worth of debate and live that again for anybody who wants to. It is all online and, as Jay mentioned, attributed. I think the issue of the participation of the Global South is as Jay says, there's no uniform voice coming out of a number of states. You have what one might consider sort of investor groups of states, where mostly they're capital exporting, the United States and the European Union, and they have completely divergent positions. You see that among states in other regions as well. And so there isn't this typical blocks of states following patterns that you sometimes see in other European, or other, United Nations bodies. I think each state has had a different experience with ISDS, and they bring those different experiences to the table. I would say, however, that participation amongst developing countries and least developed countries is extremely high. If you go and you look at the number of interventions that are made, and you can do that by looking at the audio, it is an impressive number. They are fully, from the least developed countries in Africa to developing nations around the world, they are fully engaged in this issue, and they participate frequently and vocally to express their concerns.
That's all we have time now. We can wrap it up. Thank you very much for participating. I'm sure you all would have enjoyed it as much as I have. I thank my fellow panelists for their insights. So with that, we wrap this session. Thank you very much.
This session on the much deliberated topic of ISDS reforms has indeed taken a holistic approach addressing several critical issues, from shedding light on the UNCITRAL transparency rules, the Mauritius Convention, from the active engagements of the UNCITRAL working groups to diving into India's model BIT and a mindful concern for protecting the multilateral nature of UNCITRAL. It is evident that in the second round, we have traversed a spectrum of ideas and insights, especially embracing the, so to say, behind-the-scene complexities of the ISDS reforms from a multiple angles. I request you all to kindly arise and assemble for a group photograph. Ladies and gentlemen, as we draw to a close today, I would like to extend my heartfelt gratitude to our esteemed panelists, moderators, distinguished guests and speakers, and all of you who've been a part of this enlightening journey. Your insights and contributions have made this day truly exceptional. But the excitement doesn't end here. We have more captivating sessions lined up for tomorrow. I invite you all to join us again for our enthralling sessions on the commercial mediation from 9 a.m. to 10 a.m., followed by the sessions on commercial arbitration from 10 a.m. to 11 a.m., session on making India a hub for international arbitration from 11:15 a.m. to 12:15 p.m., which interestingly includes 4 sitting judges of the Honorable High Courts from all the 4 corners of the country. And lastly, a session on cloud from 12:15 p.m. to 12:30 p.m., followed by a valedictory session and lunch. These discussions promise to be as insightful and thrilling as today's event. So let's reconvene tomorrow, eager to continue our exploration of crucial topics in the field. Until then, I thank you all once again for your active participation and enthusiasm. Have a wonderful evening, and we look forward to seeing you bright and early tomorrow for another day of enriching discussions. Goodbye and have a fantastic evening.